I acknowledge the Ngunnawal and Ngambri peoples who are the traditional custodians of the Canberra area and to pay respects to the elders past and present of all Australia's Indigenous peoples. Senators, I invite you as I read the prayer to pray or reflect in your own way on your responsibilities to the people of Australia and to future generations. Almighty God, we humbly beseech thee to vouchsafe thy special blessing upon this Parliament, and that thou wouldst be pleased to direct and prosper the work of thy servants to the advancement of thy glory and to the true welfare of the people of Australia. Our Father, which art in heaven, hallowed be thy name. Thy kingdom come, thy will be done in earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive them that trespass against us. And lead us not into temptation, but deliver us from evil. For thine is the kingdom, and the power, and the glory, forever and ever. Amen. Are there any documents to be tabled by the clerk?
Yes, President, I table documents pursuant to statute and returns to order as listed on the dynamic red.
Are there any proposals for committees to meet during the sittings of the Senate?
President, committees have lodged proposals as shown at item 4 of today's order of business.
If there is no objection, the meetings are authorised. I call the clerk.
Government business order of the day number 1, Australian Human Rights Commission Amendment Cost Protection Bill 2023, resumption of second reading debate. Senator Green.
Thank you very much, Deputy President. Well, I spoke briefly on this bill last night, and I'm very pleased to continue my contribution. As I said last night, this is an important bill that seeks to provide access to justice for victims of sexual harassment, but other forms of discrimination in the workplace. Just to give a bit of a background on this bill, we know that the Respect at Work National Inquiry provided a clear vision for addressing sexual harassment in workplaces across the country. It was an inquiry that listened to experts, advocates, legal experts and survivors. Its key finding was that our country needed to provide reforms to address sexual harassment within our workplaces. This cost protection bill represents a key element of that vision because it recognises that financial risks of legal action are a significant barrier for individuals who have experienced sexual harassment within their workplace to pursue justice. Men and women who seek unlawful discrimination claims deserve to seek justice without unforeseen financial costs, especially if they are facing a big corporation or institution who typically has better access to financial resources, information and legal support to defend the claim. Now, I feel it should go without saying that this legislation is crucial for the future of unlawful discrimination proceedings and the success of access to justice. The Cost Protection Bill would be a reform that will enhance our justice system. It ensures that applicants could access discrimination claims without the risk of bankruptcy or debt for simply wanting to stand up for their rights. It sends a clear message that our community values the people who are standing up to receive justice, and that they should not have the suffering that they have endured in their workplace should not be further exacerbated by financial inability. And it provides greater certainty and stability to unlawful discrimination proceedings, which will be guided by a consistent approach to cost allocation. It must also be acknowledged that this reform is part of a bigger picture to make our justice system more accessible. Now, our government is committed to addressing discrimination within our country, and this reform is just one of the steps we're taking to support men and women who experience sexual harassment and violence. Now, I do want to address some of the concerns that have been raised by those opposite, and I'll go to those in a moment. But I want to be really clear about what this bill does and why we've adopted the approach that is in this legislation. While an equal cost approach is widely accepted among experts, academics and survivors, there have been some concerns that the reform could encourage unmeritorious claims or encourage parties to look at the justice system rather than engage in conciliation or alternative dispute methods. Now, it must be emphasised that we have a legal system with robust mechanisms to filter out these types of claims. It is also commonly known that false claims of sexual violence sit at the 2 to 5% range. This should not scare us away from introducing an equal cost model. To address the concerns that have been raised, that people will turn away from alternative dispute resolution methods due to this bill, it is unlikely that not paying respondents' costs will encourage a huge influx of these claims. There are still many factors that individuals consider before seeking justice before the courts, including alternative dispute resolution. This reform will rather ensure that costs are not the sole reason that an individual decides not to pursue an unlawful discrimination case, which is the way that things are at the moment. Costs are commonly the reason why an individual decides not to pursue an unlawful discrimination case. Pursuing justice in our courts is a right that every individual should have, and this reform is rooted in fairness and equity. The Cost Protection Bill is a reform that will change the lives of those who've experienced unlawful discrimination within our workplaces. By introducing this cost protection provision, the bill would alleviate financial barriers that currently discourage many from pursuing legitimate claims. It addresses the critical need to balance access to justice with those financial realities of our legal system and recognises those who seek to redress for discrimination should not be penalised by the risk of adverse costs. Now, we know that men and women who experience sexual harassment and make the decision to seek a legal claim deserve to seek that justice, and without the concern that they will have to pay hundreds and thousands of dollars in legal costs for standing up for their rights. The bill is about reinforcing our commitment to justice, fairness and equality. It's also about making our workplaces safer. And it is about ensuring that every individual, regardless of their financial situation, has an opportunity to have a safe workplace, to seek that type of justice, and to ensure that we stamp out sexual harassment in our workplaces forever. By supporting this bill, we're making a significant step towards a more just and equitable society that supports survivors and gives them a pathway to ensure that they can seek justice if they are harassed at work. As I said at the beginning of my contribution, Deputy President, I'm very proud of the previous work that I did coming to Parliament, working with all types of workers across all types of workplaces. But the work that I'm proudest of is sitting down with victims of sexual harassment in the workplace and working through them the options that they have and seeking justice on their behalf. I know that particularly these women, who we know more women are harassed at work, don't seek legal compensation or a legal claim without seriously considering all of the pathways available to them. I also know that the incredible toll that this takes on an individual. It means that they usually have to leave their work. They are usually subject to mental health, PTSD types of long-term health outcomes because of the harassment that they've received. And it makes it harder for them to work again. And it makes our workplaces less safe for the women that come next time. I'm very, very disappointed to see the views being put forward by some of those opposite. I know that there are principled views coming from some of those opposite, but I suspect we will hear some really disappointing views from the Liberal National Party today about the idea that women make up claims, that this will somehow create an explosion in cases, and that protecting victims in this way is a step too far when it comes to protecting women in our workplaces. It's just not true, and it is so separate from the reality of what victims go through when they make the really brave decision to stand up and say that something has happened to them at work and seek justice for it. And for every single one of the claims that we made by those opposite, those in this chamber should remember all of the evidence that we received during our inquiry, all of the evidence that was received during the Respect at Work bill. The decision by those opposite to not support this bill or not support it and make claims that it will make the justice system worse is, again, another legacy of the Shadow Attorney General seeking to prevent the Respect at Work bill and the Respect at Work recommendations being implemented. The Respect at Work inquiry was historic, and it was delivered at a time when women were calling for real and decent change in our workplaces and in our homes. And that report, 55 recommendations, sat on the shelf under the previous government and was never implemented. Well, our government sought to implement those recommendations. We've listened to the advocates, the women, the people that stand up next to them, the people that stand up for them. And this is the next step in developing that work. And it is really important today that we don't get lost in some sort of, legal minefield that those opposite are going to try to create. What we need to make sure that we do is remember what this bill is about. It is about making sure that victims of sexual harassment and unlawful discrimination have a pathway to justice and that they are not precluded from doing that because of the way that our cost system works at the moment. I thank the Senate.
Senator Scarr.
Thank you, Deputy President. And at the outset, can I thank Senator Green for her contribution and also the way in which she chaired the inquiry into this bill and also its predecessor. This issue has been dealt with 2 inquiries of the Legal and Constitutional Affairs Committee, of which I'm the Deputy Chair, and I also deeply acknowledge and respect Senator Green's history of standing up for and representing workers who've suffered awful instances of sexual harassment. And I should also say, before I make my contributions, that I also deeply respect Senator Waters' continued advocacy in relation to these issues, including the safety of women in our community. The other introductory comment I'd like to make is to recognise those who work in the community legal sector who represent women who've been subject to sexual harassment. And I just want to read a quote from Ms Melanie Schleiger of Victoria Legal Aid to put this in context. Even more heartbreaking is telling a person they've got a really strong case and that we will support them all the way, but they can't proceed because it is taking such a heavy toll on their mental health. Sorry, I've been doing this for a long time and I know it has an accumulative negative impact when you see that repeatedly time and again it feels like the system is so broken, end quote. So there are issues. There are issues, and as a member of the Coalition, I recognise there are issues with respect to the current cost system. My concern is that this is not the right answer. And from the contribution Senator Green made and Senator Waters made, you would be unaware, those listening to this debate, that the cost model which has been introduced in this bill did not have the support of the former Commissioner Kate Jenkins in her Respect at Work report. She actually proposed a different cost model. The cost model that's proposed in this report does not have the support of the Australian Human Rights Commission, a fiercely independent statutory body that actually works on a day-to-day basis in this space. It proposed a different cost model. The cost model proposed in this bill does not have the support of the Law Council of Australia, whose members represent people every day in this situation. So I say to those opposite, whilst they might warn about those on this side of the chamber raising issues which they consider shouldn't be raised, I say to those opposite, why haven't you told in your contributions those listening to this debate that the cost mechanism in this bill wasn't supported by Kate Jenkins in Respect at Work, wasn't supported by the Australian Human Rights Commission and wasn't supported by the Law Council of Australia? Now just think about that. If you've got those 3 individuals and esteemed bodies all recommending against this model, doesn't that raise a question in your minds as to whether or not this is the right model? And the reason why, the fundamental reason why that those individuals and organisations didn't support this model is they were concerned that if you set up a model, and this is what it does, it's called an equal access model, but it isn't really. It isn't really. What this model says is if I bring a claim, and it's not just limited to sexual harassment, I should say, it's any claim under our discrimination laws, which includes 18C, dealing with giving an offence in certain circumstances. It includes religious discrimination, it includes any discrimination. So it's not just sexual harassment, it's everything. And what this legislation does is set up a model where I make a claim, I'm unsuccessful, potentially on all counts. So I've required the respondent, the defendant if you like, to go through the legal process, go to federal court, spend potentially hundreds of thousands of dollars in legal claims, legal costs, all that time and expense. I've failed, but that respondent, unless they meet some very, very difficult tests, can't claim costs against me. Does that sound fair? Does that sound fair? That someone can take you to court, you incur hundreds of thousands of dollars in costs defending yourself, you're successful in defending yourself, but you can't claim your costs back. Does that sound fair? I don't think so. And that's the concern I have with this legislation, and that's the concern that Kate Jenkins had, the Australian Human Rights Commission had, and the concern the Law Council of Australia had. And yet we haven't even heard, and it's the thing which disappoints me, we haven't even had an acknowledgement of those concerns that have been raised. So it's very important that I put those concerns on the record. Let me quote from Emeritus Professor Rosalind Croucher, President of the Australian Human Rights Commission, the former President, and I have so much regard for Emeritus Professor Rosalind Croucher. She was an outstanding President of the Australian Human Rights Commission. Independent, fiercely independent, holding government to account. It didn't matter what their political persuasion. This is what she said, and I quote, this is from page 39 of the Hansard of the evidence of the inquiry. In the Commission's view, this is the Australian Human Rights Commission, these models, that is the model which was proposed by the Australian Human Rights Commission, which I'll talk about in a minute, and the model proposed by Kate Jenkins, represent a more balanced approach to costs for claims of unlawful discrimination. So the Australian Human Rights Commission proposed a model where the court could actually consider a range of matters, wasn't restricted what it considered, but primarily considered the interests of justice in terms of making cost awards, because it is so difficult, and I think we should be slow as a parliament to actually place a straitjacket around the discretion of our judges. The judge is the one hearing the case. Shouldn't they have the discretion as to who should pay the costs? I can't anticipate all of the different scenarios. That should be up to the judge to decide. And that's where this bill actually represents, it will be an Australia first precedent. Nowhere else under any court or tribunal system does this precedent actually exist, an Australia first, and that deeply concerns me. And the Law Council of Australia said, the Law Council is also concerned that the equal access model as proposed in the Cost Protection Bill was not recommended by the Australian Human Rights Commission, either in its Respect at Work or Free and Equal reports. So essentially, in Respect at Work, former Commissioner Jenkins said, adopt the Fair Work Commission protocol, which is each party pays its own costs. So in that case, the applicant doesn't have to be concerned about paying the respondent's costs if the applicant is unsuccessful, unless certain particular circumstances occur. And then the Australian Human Rights Commission proposed a model where the court could actually consider what's in the interest of justice in the particular case. I prefer either of those two models to this model, which says even if the applicant is unsuccessful on all counts, the respondent can't get their costs unless they can meet certain hurdles, which I'll talk about, which I think are very unlikely to be met by any respondent. So we have the government putting up a model which is not recommended by Kate Jenkins in her Respect at Work, which is not recommended by the Australian Human Rights Commission, and which is not recommended by the Law Council of Australia. And that is deeply concerning. That is deeply concerning, especially when both Kate Jenkins and the Australian Human Rights Commission both presented models which, in their view, would address the underlying problem of genuine, and in the vast majority of cases, claimants should not prevent any Australian going to court in relation to matters of this gravity. Absolutely agree. But this isn't the right model in my view, and there were some alternative models which I think would have been much better. Let me run through some of the issues with respect to this model. Impacts of prospects of settling discrimination matters. So both the Australian Human Rights Commission, who attempts to settle these matters on a day-to-day basis as part of their work, has said this model doesn't require someone who brings a claim to either engage in Australian Human Rights Commission exercises to reach conciliation to try and resolve it without it going to the courts. And it also doesn't enable a court to take into account the fact that someone makes an offer to settle and that offer to settle is rejected and you end up in court. So what about this scenario? Just consider this scenario. Someone runs a small business, and this isn't a fantastical scenario. This is, I practiced law for 25 years and I've seen situations like this. Just imagine someone's running a small business, one of their employees does something which they shouldn't have done. The employer, the small business owner, wants to try and settle the claim. They make an offer to settle. It gets rejected. Maybe it's a genuine offer. It's a decent sum of money. They want to move on. The applicant, the claimant, doesn't accept that offer and goes to court, ends up getting less than if they accepted the settlement offer, and the poor old small business owner has to meet all of their costs and also the applicant's costs, even though they made an offer to settle. Does that make sense? Does it make sense that a small business owner in that situation is treated the same as Westpac Banking Corporation or Commonwealth Bank of Australia or a company that's got 100 internal counsel and billions of dollars of revenue? Does that make sense to you? It doesn't make sense to me. It doesn't make sense to me, and it doesn't make sense to the Australian Human Rights Commission. It didn't make sense to the Law Council of Australia either. The second issue which was raised is the unintended consequences on the operation of the Australian Human Rights Commission. So the Human Rights Commission itself said that it could mean that defendants try and bring certain actions with respect to the Australian Human Rights Commission's process to try and stop matters going to court. And they're anticipating administrative backlogs, additional work. So one of the unintended consequences is that we spend more time and resources with respect to a particular matter. And the reality of the matter is the Australian Human Rights Commission does a wonderful job, but they've got limited resources, and they've raised that concern. The third concern raised by the Law Council by a number of applicants, submitters to this inquiry, is that this law doesn't just apply to sexual harassment cases. And we heard moving contributions in this debate from Senator Waters and Senator Green with respect to sexual harassment cases. Very vulnerable young women, particularly in certain industries subject to sexual harassment, whose rights need to be protected. Their rights need to be protected, and they should be given every avenue to assert those rights and obtain justice. But this bill goes further. It goes to religious discrimination. It goes to matters under 18C of the Race Discrimination Act. It goes to every matter of discrimination. And so a lot of faith-based institutions have said, we're concerned this is going to be weaponised against us, that organisations will bring claims against us, accusing us of discrimination as a charity, as a not-for-profit education facility, and we're going to be dragged into court, and our cost position won't be protected even if we're successful. The next point that's been raised is insufficient safeguards to protect charities, small business and individual respondents. There is a clause in this bill that tries to do that. It tries to do that, and I acknowledge that. However, it has some serious flaws, because even if you're a respondent to one of these claims, you win on every count, the judge finds in your favour, You've got to prove that you do not have, and this is the expression used, a significant power advantage over the applicant. A significant power advantage over the applicant. And then the explanatory memorandum gives an example of a significant power advantage as being the respondent is an individual applicant's employer. So how could it be that a small business that potentially tried to settle something, couldn't get it settled, is dragged into court, goes to court, wins on all counts, how can they prove that they don't have a significant power advantage as an employer over an employee? They can't. They can't. Practically, it's a nugatory protection. It's a nugatory protection. And there's nothing else like this in the law anywhere else. This will be the first time this principle is introduced into our system of justice. Typically, and this is what I believe, everyone should be treated equally before the law. Everyone should be treated equally before the law. I think that's a fundamental principle. So I am very concerned about this cost model. It wasn't recommended by Kate Jenkins. It wasn't recommended by the Australian Human Rights Commission. It's not supported by the Law Council of Australia. And I think everyone in this chamber should reflect on those facts and consider it very, very carefully.
Senator Sharma.
Thank you, Deputy President. Well, I rise to associate myself with the comments of my colleague, Senator Scarr, and to commend the work he did on the committee in scrutinising this piece of legislation, because there are some serious concerns about the implications and consequences of this piece of legislation, the Australian Human Rights Commission Amendment Cost Protection Bill of 2023. I would group them into 5 categories. Firstly and foremost, the bill does not follow the recommendation of the Jenkins report. Secondly, it goes well beyond its original scope. It extends not just to claims for sexual harassment or discrimination, but as my colleague Senator Scarr just said, extends to any and all types of claims under discrimination law. Thirdly, it removes judicial discretion, the discretion of judges in the awarding of costs, which is an important feature of our justice system and is intended to take into account the wide variety of circumstances that exist between an applicant and a respondent in these sorts of matters. Fourthly, it's likely, as the Australian Human Rights Commission and others have said, it's likely to inhibit the efforts to reach a settlement at an earlier stage of dispute. In fact, if you're an applicant, it disincentivises you from reaching a settlement because the approach it encourages is one of all reward and no risk if you proceed down the path of litigation. And fifthly, and finally, the legislation takes into account the characteristics of litigants in a way that is unusual, untested, and sets a dangerous precedent. One of the features of our justice system is that justice is meant to be blind. That is, justice is meant to assess the law impartially without having regard to the characteristics of the litigants before them. But what this legislation does is it instructs the court to take into account whether there is a power imbalance, whether there is a financial imbalance, what are the means or resources that a respondent has behind them, in a way that renders nugatory this injunction that justice should be blind. Now, undoubtedly, the main thrust of this bill is to address an important issue that was identified in the Jenkins review. During that review, the Commission received several submissions urging them to insert a cost protection provision into the Australian Human Rights Commission Act, recognising that the current cost regime, where costs follow the event, can operate as a disincentive for pursuing sexual harassment matters under the Sex Discrimination Act. This is an important issue that should be addressed because we have heard, this Parliament has heard, and commissions of the Senate, committees of the Senate have heard how complainants may be deterred from pursuing legitimate discrimination claims in the courts because of the risk that they will be ultimately liable for the costs of the respondent. What the Jenkins review recommended in recommendation 25 was that the Australian Human Rights Commission Act be amended to insert a cost protection provision consistent with what exists in Section 570 of the Fair Work Act of 2009, which provides for costs only being awarded against a party by the court if the court is satisfied that the party instituted the proceedings vexatiously or without reasonable cause, or if the court is satisfied that a party's unreasonable act or omission caused the other party to incur costs. That is the recommendation of the Jenkins Review. It basically recommends the importation entirely of a provision very similar to that exists in Section 570 of the Fair Work Act. But this goes way beyond that. What we're dealing with in the legislation goes way beyond that. What we have here, the scenarios we have here are that if a complainant takes a complaint to the Human Rights Commission, it then ends up in the federal court, the bill says that the court must award costs to the complainant if they are successful on only one or more grounds. A complainant could bring a claim under 10, 11, 12, 5 or 6 grounds, but if they are successful on one or more grounds, they should be awarded costs. And that rule in this legislation is to apply in all circumstances, in all cases, except when the costs are incurred as a result of a complainant's unreasonable act or omission. The model also says in this legislation that the court must not award costs against the complainant unless some very narrow exceptions are met. The court can only award costs against the complainant and to a respondent if they are satisfied that the complainant instituted the proceedings vexatiously or without reasonable cause, or that the complainant's unreasonable acts or omissions caused the respondent to incur costs, and only if the respondent is successful in the proceedings if the respondent does not have a significant power advantage, quote unquote, or does not have significant financial or other resources relative to the complainant. So the way this is drafted, it can be that a complaint that is brought on 10 grounds, 9 of which are dismissed, the respondent will still have to pay all the costs because they lost on that one ground. And even if the respondent is successful on all counts, that is, there is no claim that the court finds of discrimination or discriminatory conduct, they will not get their costs paid if they have a significant power advantage over the applicant. Well, that would often be the case in employer-employee relationships, or if the respondent has significant financial or other resources. Again, that would often be the case because it will often be a corporation or a business that is the respondent in these circumstances. So what this bill does effectively is it incentivises litigation and it disincentivises negotiated outcomes because it removes any substantial risk from the complainant that they will need to carry the costs of the other side if their claim is unmeritorious or found to be without foundation. And it removes the bill even removes the provision that allows the court to take into account offers to settle in assessing costs. So what that means is that if you have a complaint made against you, you make a good faith offer to settle, the respondent chooses not to, ultimately the applicant's claim is unsuccessful, the decision about whether costs should be awarded there, the court does not have the discretion to take into account the fact that this matter was attempted to be settled earlier. So effectively, there is now no downside to pressing ahead with a low prospect claim, and that will undoubtedly be exploited. We heard from the Human Rights Commission in this inquiry into this bill their own concern that this bill would unintentionally perhaps take away their own ability to encourage early settlement of these disputes rather than going to court. We heard similar concerns expressed by the Law Council of Australia as well. I did want to read some of the comments that were made in response to that committee's inquiry because I think this bears it out quite clearly. The Human Rights Commission said, as Australia's national human rights institution, the Commission is concerned that the reforms proposed may have unintended consequences on the effectiveness of alternative dispute resolution options aimed at facilitating early resolution of complaints, including settlement offers, and the Commission's conciliation function, and may impact on the Commission's role in stemming the flow of complaints that proceed to the court. So here we have the Australian Human Rights Commission warning that this bill may well have unintended consequences, that it may well frustrate the early resolution of complaints, including settlement offers, and that it may well impact on the Commission's role in stemming the flow of complaints that proceed to the court. We also heard from the Law Council of Australia, who said, and I quote, "The Law Council is concerned that the Cost Protection Bill tilts the balance overly in favour of the applicant and moves the financial risk and disincentive for unmeritorious claims to the respondents. The Law Council is concerned that the Cost Protection Bill reduces incentives for the parties to engage genuinely with the Australian Human Rights Commission's conciliation processes and later in any alternative dispute processes available. It could also render offers of compromise and so-called cul-de-bank offers ineffective." So we have here some legislation that is not actually doing what the Jenkins Review recommended. It's not helping to level the playing field or remove disincentives to bring in legitimate sexual discrimination claims. Instead, it is going a lot further than that. And in particular, I wanted to touch upon one provision that is genuinely unprecedented in many respects, and that is the characteristics of the litigants, or the applicant and the respondent. This is the provision which would require the courts to treat respondents, when they're assessing whether costs can be awarded, differently based on their financial power or financial means. The Law Council had this to say about that provision. Further, as a matter of principle, it is inappropriate for the courts routinely to treat parties differently based on their power or financial means relative to other parties, particularly where they have not engaged in unlawful conduct. But what this bill does is exactly that. You can be a respondent who has not engaged in unlawful conduct, has all the grounds on which a discrimination claim has been made have failed. You have not been found to have a case to answer. You may well have made earlier offers to settle this dispute through the Australian Human Rights Commission's conciliation procedures or other channels, but the applicant has denied to do so. And ultimately, if the court decides that you are, as the respondent, successful, that there is no case to answer, you will not see any of your costs recovered. You will not be able to recover any costs if you have a significant power advantage over the applicant, or if you have significant financial or other resources relative to the applicant. Now, as I said earlier, this will almost inevitably be the case. If you have an employee suing an employer or a corporation that stands behind them, it would be hard for the court to find that you do not have a significant power advantage over the applicant, or that you do not have significant financial or other resources relative to the applicant. And this strikes at the heart of the principle that justice should be blind. That is, it should not take into account the characteristics of litigants when assessing that law should be applied impartially, that we are all equal before the courts, and particularly if you've not been found to have been at any fault whatsoever. The idea that things that are unrelated to your conduct as being alleged in this case, your financial means, your relative resources, whether you're in a position of higher status within society, the idea that these should be taken into account by the courts strikes at the heart of liberal democracies and the principle that the principle of the rule of law, the principle of equality before the rule of law. What it effectively seeks to do is import a power-based calculus into a legal system that is founded instead upon the impartial application of principles. Now, I think, why has the government done this in this legislation? Why has the government gone significantly further than was urged in the Jenkins review has gone significantly further than recommendation 25 in that review to not only import an entirely new test for the awarding of costs rather than take on board that in section 570 of the Fair Work Act as suggested in the Jenkins report, that goes beyond the original scope, extending not just to claims for sexual harassment or discrimination, but to any and all types of claim under discrimination law, and to remove the discretion of judges in the awarding of costs. Well, undoubtedly, this will have class action lawyers and litigation funders rubbing their hands together with enthusiasm, because what it does is it encourages, unintentionally or otherwise, it will encourage unmeritorious claims. It will discourage early dispute resolutions and offers of settlement. It will add complexity and risk to the lives of anyone involved in commercial activity, and it will clog our courts with potentially quite unmeritorious claims in a way that goes way beyond what Kate Jenkins recommended in her review and recommendations, and that goes much further than what is required to remove what I accept are significant disincentives at the moment to the pursuit of sexual discrimination claims. That is why I do not support this legislation as drafted. That is why the Coalition has put an amendment which faithfully, comprehensively, but not expansively, seeks to implement recommendation 25 in the Jenkins review. And I urge all of those in this chamber to study this legislation closely, because it could well be the thin end of a wedge. Thank you.
Senator Chandler.
Thank you, Madam Acting Deputy President, and I rise to also make a contribution on the Australian Human Rights Commission Amendment Cost Protection Bill 2023. This bill was meant to do one job: implement recommendation 25 of the Respect at Work report. The recommendation to create a simple, cost-neutral jurisdiction in our federal courts to remove barriers to women to deal with remove barriers to women who deal with sexual harassment in the workplace. Recommendation 25 dealt specifically with pursuing sexual harassment claims in the courts, and a bill to address that recommendation would have undoubtedly had support right across this chamber. But this bill does not implement recommendation 25 of the Jenkins report. This bill does not implement a provision modelled on section 570 of the Fair Work Act. It is not aimed at sexual harassment in the workplace. Instead, it applies to all federal discrimination matters, and that is a massive problem. Because we know that federal discrimination legislation in this country is fundamentally broken. Instead of protecting women, as the Sex Discrimination Act was intended to do, we now see in this country a situation where it is used as a weapon to punish and silence women. We have seen that happen recently in the courts with the absurd situation of the Tickle versus Giggle case, where an Australian woman has been punished and fined for starting a female-only app. The decision in that case makes clear that the courts will interpret the current legislation such that female can mean someone who is biologically male. The courts found that sex is changeable and can relate to what clothes you wear or how you present yourself, which means that all of the provisions in that Act, in the Sex Discrimination Act, which were intended to specifically allow and encourage single-sex services for women and girls, are now all but impossible to rely on, which means that Australians who offer single-sex services for women and girls, services which millions of Australian women and girls rely upon, risk being taken to court and fined just for doing this. And this bill, I am concerned, will incentivise exactly that type of litigation that we have seen in the Tickle versus Giggle case by protecting an applicant who wants to try and undermine something like single-sex services for women and girls from having to pay costs even if the vast majority of their claims are dismissed. And it is very easy to predict how this will be used to target any organisations or clubs or volunteers who seek to offer single-sex sport for women, for example. This bill presents a free swing in the courts for activists who want to force a sporting body to allow males into female sport. Thanks to the changes that the Gillard government implemented in 2013, it's already incredibly difficult to offer single-sex sport or services or facilities for women and girls in this country. And that's because the previous Labor government, the Gillard government, took the definition of woman out of the Act and severed the term sex in the Sex Discrimination Act from its biological meaning, as the UN Special Rapporteur on Violence Against Women and Girls, Reem Al-Salem, said last week. And I want to quote from Ms Al-Salem's statement last week on the Australian Sex Discrimination Act and the implications of the current interpretations of it. I'm concerned that the court decision could make it potentially harder for women and girls to argue for the proportionality, the legitimacy and the necessity of female-only spaces in some circumstances. Even if unintentional, the ruling by the federal court may have made it potentially harder for women and girls in Australia to avail themselves of the full breadth of protections provided by the international human rights treaties that Australia is party to, including CEDAW and the ICCPR. Ms Al-Salem correctly stated that while the Act differentiates between the concepts of sex and gender identity, this distinction is abandoned in practice. It is inexplicable and nonsensical that the Albanese government has, in full knowledge that federal discrimination law allows a woman to be punished in a court just for offering single-sex female services, has chosen to make it easier for activists to lodge those very complaints in the court with this bill, by expanding the intention of this bill out so much broader than what the Respect at Work report originally recommended. These are the unintended consequences that we may see. This bill was supposed to be about implementing recommendations specifically about sexual harassment complaints. It is the Albanese government which has taken a political decision here. Let's be very frank about it. They have taken a political decision to apply this to all discrimination complaints, in full knowledge that many of these complaints that we are seeing more and more here in this country, like in the Tickle versus Giggle case, are being used to silence women and punish women. The way the Labor government has quietly extended this bill to all types of discrimination complaints, rather than being specific to sexual harassment cases, is eerily similar to the way they removed the meaning of sex and the definition of woman from the Sex Discrimination Act in 2013. Because in 2013 it was never mentioned by the government that their changes would have the effect of enabling a court to punish a woman for offering a female-only service, or that their changes would have the Sex Discrimination Commissioner telling a court that the way you dress helps to determine your sex for the purposes of the Act. They didn't mention any of that, and a decade down the track, Australians are seeing the consequences of that sneaky omission. And now again today we have a bill being presented as being purely about sexual harassment cases, when the reality is that the government has decided it will apply to all discrimination complaints, including those that activists will bring against women trying to offer single-sex services or single-sex sports or single-sex spaces. What we should be seeing here today is a bill which doesn't do what it was supposed to do, but goes way beyond that. The way that this bill has been drafted means that even if a complaint is brought on 10 grounds and 9 are dismissed, the respondent will still have to pay all costs because they lost on that one ground. And as I've just referenced, a discrimination complaint can be brought under current legislation in incredibly dubious circumstances, such as to compel women to accept males into female-only spaces. If someone forced into a court for a complaint like that wins on 9 counts and loses only on 1, why should they have to foot the bill for the whole case, including the grounds that they won on? How does that give the best effect to justice? The bill leaves open the possibility that the respondent must pay even in respect of grounds that are unsuccessful, because these are all part of the same proceeding. If you are successful on any ground, you recover all your costs, and if you lose completely, all you have to do is bear your own costs. If you make 20 complaints or 20 claims and you succeed on just 1, this bill leaves open the possibility that the respondent will be forced to pay for all of them. And it means that, in effect, there is no downside to pressing ahead with a low prospect claim. And again, if we're talking about claims of sexual harassment, then that was a recommendation of the Respect at Work report, and we understand why the government would want to be doing that. But what they have proposed here today goes so far beyond that, it's not even funny. This bill takes a different approach to what was recommended. It does not implement Recommendation 25 of the Jenkins report, and it does not implement a provision modelled on Section 570 of the Fair Work Act. It's not aimed at sexual harassment in the workplace. Instead, it applies to all federal discrimination matters, and it would become a catch-all provision extending into matters far beyond the recommended scope and intent. The government does not appear to be being upfront today about why it has done this and why it didn't want to bring in a bill which actually would have dealt with the scourge of sexual harassment in this country.
Senator O'Sullivan.
Thank you very much, Acting Deputy President. Well, as we've just heard from several speakers before me from the Coalition, this is a bill that should be implementing Recommendation 25 of the Respect at Work report. For those interested, Recommendation 25 was to amend the Australian Human Rights Commission Act to insert a cost protection provision consistent with Section 570 of the Fair Work Act 2009. And Section 570 of the Fair Work Act says, in summary, in a case related to the Fair Work Act, a party can only be ordered to pay the other party's legal costs if certain conditions are met. The party may be ordered to pay the costs only if A, the court believes the party started the case just to cause trouble vexatiously or without a good reason, or B, that the court believes the party did something unreasonable that caused the other party to incur extra costs, or C, the party refused to take part in a related matter before the Fair Work Commission and that refusal was unreasonable. Now, the Respect at Work report made 55 recommendations across a range of areas, many of which have now become law with the Coalition's support. But what this bill does is this bill takes an entirely different approach to what was actually recommended in the Jenkins report. It does not implement Recommendation 25 from the Jenkins report. This bill does not implement a provision modelled on Section 570 of the Fair Work Act. It deviates away from what was actually recommended. It's not singly aimed at sexual harassment in the workplace either. Instead, it applies to all federal discrimination matters, Now, for some reason, the Attorney-General has allowed for the possibility that if even one part of a complaint is upheld, the individual or business may still be required to cover the costs of the rejected portions of the complaint. Now, this makes it extremely troublesome for people in this whole space. It will become a catch-all provision, extending into matters far beyond the recommended scope and intent. The overreach here is of serious concern, of grave concern. The costs that will be imposed upon individuals and organisations without the necessary protections, without the narrow scope that would be required, as recommended by Jenkins' report, puts this bill in the very dangerous category. The Attorney-General is trying to dress up this bill under the guise of sexual harassment in the workplace, but it goes much broader than just sexual harassment. We know that this bill is aimed at more than that. It is another Labor bill that seeks to overreach. Now, unfortunately, we're seeing this time and time again with legislation that comes into this place, whether it's by poor drafting. I think there are some occasions where it's an oversight, where it's, you give them the benefit of the doubt. Maybe they've, through their haste and folly, they've rushed legislation through and considerations haven't been properly thought out. And then there are moments, like we're seeing with this bill, where it seems that there is an intended outcome here for it to be overreaching, for it to go far beyond the scope of what Jenkins recommended. And that's what we're seeing here. My concern is that this bill will have unintended consequences particularly for people of faith. It's difficult to give this government the benefit of the doubt when it comes to matters of religion, matters of religious freedom. We've already seen their first disastrous attempt when it comes to protecting religious freedoms. That attempt, quite rightly, led to a backlash from many sectors of the faith community. Quite an extraordinary display, quite an extraordinary step that the faith community have made. I mean, by their nature, turn the other cheek. Like by their nature, there's a predisposition when it comes, particularly, people of faith and faith community groups, to, be meek and mild. But they have been forceful in their opposition to the government's plans when it came to their religious discrimination bill. And the government, shamefully, have turned their back on faith communities across Australia. I'm glad they're not implementing, as the Prime Minister has ruled it out so far, they're not implementing the bill that they did plan to bring before this place. I'm glad that that's not happening, because that would have been a retrograde step for people of faith and faith community, and particularly religious schools. I'm glad that that's not happening. But I am very disappointed, as are faith groups and faith communities across Australia, of all persuasions, not just Christian, but Muslim, Jewish, that the government isn't providing the protections through a sensible bill. Faith leaders came together, again, across the broad spectrum of religious community, different faiths, have come together, made recommendations to the Attorney-General, to the Prime Minister, on what could be done to provide those protections. They've put forward a very sensible, workable list, but this government has run away from that. They don't want to have the fight with the left and within their party. Well, that's shameful, because it was an election commitment that was made. It was a commitment that was made before the election to provide people of faith with the protection that is necessary. So I don't have a lot of faith. I don't have a lot of faith in this government at all when it comes to matters of religious freedom. Now, the Australian Christian Lobby, in their submission on this bill, and I want to speak this into Hansard, made a very powerful point in their submission. They said the bill will have disproportionate, extremely adverse impact on Christian and faith-based schools and education institutions if, as the government appears intent on, the exemptions in the SDA are to be removed or reduced so that they have no value in enabling such institutions to operate in accordance with their ethos. It would make discrimination law activism virtually cost and risk-free for complainants. Now, just to interject on that point, who then therefore bears the cost? It will, of course, be those organisations. Now, Australians may be financially ruined, they go on to say, for things that should never have been alleged under discrimination legislation in the first place. The result of the bill in that context would be that Christian and faith-based schools and the like will become exposed to an entirely new range of discrimination claims under the SDA simply for operating in accordance with their ethos. Christian schools remain a highly popular choice among Australians. The problem is that their ideology does not fit with Labor's current ideology." End quote. The burden of cost for this bill, the implications of this bill, will be borne by, in the instances that I've raised, by those within the faith community, particularly faith-based schools. What does that mean? It means their insurance costs will go up. And in turn, of course, it will mean that the fees that are paid by parents that are making the choice to send their children to that school will also go up. So at a time of a cost of living crisis, this is the worst decision that could ever be made on a cost basis. But of course, it is damaging when it comes to freedoms in this country. It is damaging when it comes to freedoms in this country to have a bill such as this. This bill takes an entirely different approach, as I started, to that which was recommended in the Jenkins report. Labor have used the recommendations of that report and decided to add in some of their own formulation when it comes to this bill. Now, it's within their rights, they're the government. But we're belling the cat here. It is outrageous what they're doing by extending and making it much broader and wider. Once again, Labor is targeting people of faith. The cost model proposed in this bill differs from the Australian Human Rights Commission's recommendations. And as Senator Paul Scarr, the chair of the committee that looked in this, my good friend and colleague said, there is strong evidence that there are issues with the current system that need to be addressed. However, there is no consensus with respect to the cost model, which should apply to proceedings commenced under Part 11B, Division 2 of the Australian Human Rights Commission Act in 1986. There are unintended consequences in this bill that the government have not adequately addressed. Therefore, I think, and the coalition stands in opposition to this bill because it does not advance protection from discrimination in the way that it should, and in fact will increase the number of vexatious claims that are made against people. You can use the processes of the Human Rights Commission to frustrate, to add cost, to add burden to organisations that maybe you've got an opposition to ideologically. And it is reprehensible and it is something that should not proceed. Thank you.
Senator Canavan.
Deputy President, well, there are a lot of challenges facing our country right now. It's a pretty tough time for most Australians. Just paying for basic things, just going to the supermarkets become a stressful exercise for many to know if they have enough money in the bank, staying in their home with mortgage costs going up, and that's for those who are lucky enough to have a home. We've got tent cities popping up around our major cities as well, something I never thought I'd see in this nation. Lots of issues, and so you would think, I think people out there would hope that here in this place that we'd be debating something, trying to do something to tackle those issues. Instead, we've got a bill here that can only be described as a lawyer's picnic on steroids. Really, it's a massive lawyer's picnic. That's, as other speakers have outlined here. I'll go through it myself in some detail. But really, if you gave a lawyer or a large corporate law firm a blank cheque and said, "Here, write the law for this country," you wouldn't get far away from this, because effectively this bill before us today subsidises litigation in this country. Obviously, therefore, will incentivise more people to take matter through the courts. And pretty much every time something ends up in the courts, there is only one winner. There's a formal winner and a formal loser, but almost always in the civil courts, when things end up in the courts, there is one group of winners, and they're lawyers. They're the ones who win. They laugh off all the way to the bank. In one way or another, most of the other people involved end up with a huge bill, or at the very least, if they come out with their shirt, they have a life racked with stress and interruption, and it's never really the same for people. So I don't know why we would be seeking to introduce legislation that would encourage more and more disputes to go down a legal judicial pathway that's high cost, high stress, highly resource intensive in a country that is struggling to just simply provide other basic services. Why would we do that right now? It makes no sense that the government's priorities seem so divorced from the concerns of average Australians, which are clearly about the cost of living, the standard of living and the availability of basic services like hospitals, housing, basic energy needs, etc. But this bill does go way beyond what has been recommended to this place, and there's very little explanation from the government about why it hasn't taken on the recommendation of the Respect at Work report. It's become known as the Jenkins report. That report made a number of recommendations, many of which we've dealt with and have gone through this place. It's a very important report about standards of behaviour in this place. And there was a recommendation in this report, recommendation 25, was to make it easier for people to bring a matter of sexual harassment to the courts. We believe this was an admirable aim. Well, obviously it's an admirable aim, but we believe it was a sensible recommendation. In brief, that recommendation would would reduce the times which a complainant of sexual harassment matters would found to have to pay costs. So it would restrict the options for a court to impose a costs order on somebody that was bringing a sexual harassment matter through the federal court process. Basically, it would mean that unless it was found that the complainant had acted in a vexatious or without a reasonable cause manner, a costs order couldn't be imposed on that person. And look, I believe, given the sensitivity of these types of matters and the very personal and difficult way in which people have to bring such complaints, there's a rationale there in that case, in those limited cases, to provide some restriction on costs orders so that people do not feel deterred from bringing serious matters of sexual harassment forward. But this bill goes way beyond that. That's the recommendation of the Jenkins report. It's a recommendation that we support, and if the government had brought legislation, it would be very clear if the government brought legislation to implement that recommendation and do that thing, it would have been supported. It would go through this place with very little rancour or waste of time on it. It's a sensible thing to do. But that's not what this bill does. It doesn't implement recommendation 25. It goes far beyond that recommendation, and it expands these restrictions on costs orders into matters that go far beyond those of a personal nature in the case of sexual harassment, to cover all other discrimination issues, including potentially religious discrimination, racial discrimination, and it does so in a way that's even more harmful potentially to encourage excessive litigation in this country. So in effect, what we've ended up with here is a recommendation that was only about these personal and highly sometimes embarrassing matters that are difficult for people to bring forward, to include a whole lot of other matters here which could encourage people to bring potentially quite unreasonable matters of religious discrimination, racial discrimination forward. And there is always, I think, a balance to be had here in these matters, because there are some more nefarious groups of people out there who are looking to always accuse people of racism or religious discrimination today. And obviously where that happens, where those complaints are substantive, they should be handled properly through the courts, but we shouldn't establish a situation where anybody can be accused of these things, and those that are making the accusations not have to provide reasonable justification for why they'd bring them through a judicial pathway. So when it does that, as it does that, to go into the detail, this bill would make it that a court must award costs to a complainant. So this is the case if someone complains that someone else has acted in a racially discriminatory way, the costs must be awarded to the complainant. That's the accuser has to pay for the complainant if they are successful on one or more grounds. This is, I think, one of the biggest issues here. So let's say somebody, just use an example, somebody brought forward a case that had 10 or 15 different accusations of, say, racial discrimination, and the court found in the end that just one of those 15-odd accusations was successful, was upheld. The costs of the entire litigation would have to be imposed on the accuser. The accuser would have to pay not only the accused would have to pay not only their own costs but also the costs of the complainant as well, even though the complainant has failed to prove 14 of the 15 allegations in that particular case. But that's just a particular case. In any case, that's totally inconsistent with how our courts deal with these matters at the moment. They look at a decision in the whole context, and if the majority of the the accusations were not upheld, it's unlikely a court would order costs against an accused for all of it, for all the costs. May have a partial cost order. It may not award any costs at all. It takes away that discretion from the courts, this bill, and puts a ridiculously high standard on people accused. Even if they're very successful in defending the accusations, they still could end up with a massive, massive bill. Worse, though, probably, possibly. Well, actually, I'll use this point now while I'm on it. The issue with this particular point too, that's been raised in the Senate committee without adequate answers, is what happens in the event where the accusations extend beyond just the discriminatory matters that this bill purports to cover. And so say somebody had brought complaints under industrial relations law, but as well as in that case they'd also had a matter of racial or sexual discrimination. If they were successful on the discriminatory issue but unsuccessful on the industrial relations complaints, under this bill, a literal interpretation of the bill as drafted, it would mean the court would have to award costs to the complainant for all those matters, even though they were completely unsuccessful on a group of matters, say on industrial relations, that they had brought. That seems completely out of whack as well. And again, the government hasn't really shown good faith here in answering these legitimate issues that have been raised by many people, including good faith people in the legal fraternity and the judicial fraternity, about these issues in the Senate committee. This is interfering with long-held practices in our courts that really, I mean, the issue here, the fundamental issue here, while I'm on this point, is where's the evidence this is broken? I mean, we on the sexual harassment case can understand, absolutely understand the personal nature of those complaints and the need for possibly some tweaking here to help people bring forward such issues that are very hard for anyone to do. But on these general issues of disputes between people that obviously get quite heated at times but are still arise between whenever you get humans interacting with each other, where is the evidence that our long-standing court processes about cost orders are broken? There's a decision the judicial courts make about these matters. They consider the whole judgment as a whole. They consider all the arguments. They consider even the pre-trial potentially negotiations that occurred and whether or not plaintiffs and defendants were reasonable in their offers of settlement or rejections of settlement. They consider all those things and make a considered decision, taking all those factors into account about who or if anyone should be awarded costs. But this now just tilts it all in favour of the complainants, and that obviously is a massive blank cheque to big corporate law firms who make money off running court cases. That's what they do. They're in the business of doing that. And sometimes it's important to take those sort of cases and defend people who have been wronged in life. But obviously there is an element of that community that takes that to extremes, and we end up with a society crushed under excessive litigation, where a lot of people get hurt, except for the lawyers, of course, as I mentioned. But going back to the detail here, another issue here is that the model says that it's very restrictive on when or if costs should be awarded against the plaintiff or the accuser. So I said the accuser, if they win on one factor, will get all their costs paid. So they've obviously got an incentive to just launch as many actions as they can, many issues as they can, because they only have to be successful on one and they get everything paid for. In the event that they don't get any of them up, though, it's very rare that they'd actually get costs awarded against them. That will only happen under this bill under some 3 limited circumstances, and I'll just go through those. So the court will only be able to issue costs against the complainant, the plaintiff, that is costs to the respondent, if the complainant instituted the proceedings vexatiously or without reasonable cause. That's quite a high bar. They have to prove that there was a vexatious element to the complaint. The complainant's unreasonable acts or omissions cause the respondent to incur costs. And that's a bit vague. Is it just the costs that were incurred as a result of the unreasonable behaviour, or all of the costs? The respondent is successful in the proceedings, does not have so they have to be successful, obviously, to have this awarded to them, does not have a significant power advantage is another aspect, and does not have significant financial or other resources relative to the complainant. Again, this just seems to be an incitement to take action against people and companies that happen to be well-to-do. Now, I mean, probably the Labor Party doesn't worry about that. They're like, oh yeah, let them know. They're big businesses, they're rich people, make them go through the courts. But I mean, there's got to be an element of justice here in our society, that you can't just have a situation where I mean, I thought when you go into the courts in our system, the lady's blind, right? The lady's blind, the scales are there and there's a blindfold over it's probably a goddess or something. I'm not a lawyer, so I don't know the ancient mythology behind it, but they're blind because we think justice is blind. Doesn't matter if you're rich or poor or the colour of your skin, you all have the same rights in that court place. You're all a citizen of this country, and as a citizen of Australia, you have a right to defend yourself, you have a right to innocence before being proven guilty, you have a right for representation, you have a right to be treated fairly in the court. But this actually sets up a situation where, depending on your financial circumstances, depends on what sort of justice you have. Now again, some elements of this chamber, like, oh, well, bad luck, you're rich, too bad, too bad. I don't like that. I don't like setting our country up against each other like that. We're all Australian citizens and we all deserve the protections of the law. It's one of the fundamental bedrocks of our democracy, of our long-standing traditions of treating everybody equally in this country. But this bill completely tosses that out in what, as I said at the start of my contribution, seems to be the provision of a blank cheque to corporate law firms, big corporate law firms, by the Labor Party, who are having no regard to our histories and traditions, but are simply trying to benefit their political mates here in that sector. I don't think this bill has a leg to stand on in a credible and logical fashion. I'd implore the government to go back to the considered recommendations of a report that's been accepted by all parties in this place and drop this blatant attempt to tilt the scales of justice against some Australians in favour of others, mainly those who happen to have a law degree and make their money off launching litigations.
Thank you. Senator Brockman.
Thank you, Mr Acting Deputy President. Well, I'll start where Senator Canavan finished. Justice is meant to be blind, and it's a key driver of the fairness of our society, of the fairness of our judicial system, that we do try to have everyone treated the same way. But when you are considering these matters, particularly as a legislator in this place, you must recognise that both incentives matter and the signals you send make a big difference in terms of the way people interact with the judicial system, no matter how well-meaning, and let's give the government the benefit of the doubt. I might perhaps go on to talk about why I'll withdraw the benefit of that doubt a little bit later on, but let's give them the benefit of the doubt. They're trying to improve the system here. But the overreach in this bill, which took a very narrow recommendation from the Jenkins report and broadened it out significantly, will add an incentive into the framework of contesting these human rights type matters before the courts, which is very, quite frankly, unproductive for our society and does offer a new business model to the litigation funders who, quite frankly, I don't think add a positive contribution to our judicial system. Yes, the cost of exercising your rights under the judicial system are too high, and gaining access to the judicial system is too costly for a lot of Australians. But does that mean that the litigation funders, who generally work on a pay-to-win basis, add a positive aspect to our judicial system? Well, my view is that they do not. I did train as a lawyer. I got a law degree. I never practiced as a lawyer. I chose other paths. But one of the things that I do say to anyone who comes into my office, any constituent who comes into my office with a legal dispute, is my first recommendation is try and sort it out. Try and sort it out. Don't go anywhere near the courts if you can possibly help it, because the court system is expensive. It is, the outcomes cannot always be guaranteed, and those with very deep pockets often have an advantage. And so if you're a farmer, in dispute with your bank, I mean, the scales are very much tilted. But going and getting a litigation funder involved is not necessarily the answer to that problem. In this particular case, where you have the scales being tilted by government and once again the incentives being put into the system driving behaviour that is far from ideal, where, as Senator Canavan very eloquently outlined, you could have people where they perhaps have one or two complaints that perhaps are meritorious, but then they load it up with 14 or 15 complaints which are questionable, and under the protection of this approach to legislation, they hope to see the costs of the litigation being borne by the other party, I think is a very poor signal to send. Now, whether intended or not, that will be the outcome. It will put in people's mind the idea that they can enter these kinds of contested spaces and litigate these human rights matters at none or low risk. Now, that is a very dangerous approach to take to these kinds of matters. I mean, the fact is you should have to think. You should have to think very carefully indeed before you take matters to a court system, to a judicial system, and putting in place a set of incentives that say the likely outcome, even if I only get one success out of 10 or 15 matters that I am prosecuting, is that I will have the costs awarded in my favour. I think that is a very bad message to send, and it is a long way from what the Respect at Work report recommended and what many of the submissions said. For example, many submissions recommended that cost protection provisions in the Human Rights Commission Act would, and I quote, provide that applicants and respondents should bear their own costs unless an exception applies. There are also submissions that costs act as the cost should follow the event and as a disincentive to pursuing sexual harassment matters under Sex Discrimination Act. And that was the narrow problem that was attempting to be fixed. But as I've said, the scope has crept beyond that and does take us into a different place. It does not, this bill does not implement recommendation 25 of the Jenkins report. It does not implement a provision modelled off section 570 of the Fair Work Act, which is what that recommendation consisted of. It is not aimed at sexual harassment in the workplace, which again is what the Jenkins report was all about. Instead, it has been broadened, as I've said, to apply to all federal discrimination matters. It will become a catch-all provision, extending into matters far beyond the recommended scope and intent as set out in the Jenkins report. For example, if the government decided to pursue its flawed religious discrimination bill, this bill would apply to religious institutions and schools. Again, this is a long way. This is a very long way indeed from what was recommended in the Respect at Work report. It implements, this bill, the Orwellianly described modified equal access model. Modified equal access model. I mean, think about those words in combination, and I'm sure many of those listening to this are puzzled by what that phrase actually means, because it is a truly Orwellian phrase, because this model is not about equal access at all. Even the government's own materials have to put equal access into quotation marks because it's not about equal access, which I find quite extraordinary. This model does not remove barriers in a way that preserves the integrity of litigation and the discretion of the court. Instead, it tilts the balance in favour of the complainants, regardless of the nature of the complaint and the conduct of these proceedings. And that, in a nutshell, is why this bill does go too far. It goes further than any other Australian jurisdiction and any other comparable nation. The current approach in our courts is for cost orders to reflect on the conduct of the proceedings, the merits of the parties' positions and the ultimate outcome. I think most people, on hearing that, would say, well, that sounds like a pretty reasonable approach. That sounds like a pretty reasonable approach. You look at it, how the proceedings have been conducted by both parties, so whether there has been vexatious action, whether people have been timely in their handling of matters, their handling of the provision of information, the way they've approached the court and the way they've approached the other party in terms of the proceedings. Obviously, it also looks at the merits of the parties' positions. Obviously, that's what courts do in the end. They look at the relative merits of the case before them, and often cases aren't black and white. In fact, very few cases, particularly in this area, are black and white. They're very difficult and nuanced areas where judgments are going to be made. And of course, then the courts also need to look at the ultimate outcome. You know, has someone been found to have been in breach of the law? Now that would, I think, in most people's minds, be quite a reasonable benchmark by which courts can seek to achieve justice. Now, again, this is quite fair and reasonable. Judges who are hardworking and try their best to be independent, and I do not think judges take their responsibilities lightly. And this bill does remove discretion from the judges, from the courts, because it requires that the court must award costs to a complainant, so the person who brought the original complaint to the court, if they are successful on one or more grounds. Now again, that removes the ability of the court to make a decision to say that whilst one party may be successful on one ground out of 15, perhaps they don't actually deserve to be rewarded for taking the matter to court in the first place. Perhaps they don't actually, they shouldn't be rewarded by having any cost order in their favour. This is actually a frequent outcome of courts where they say, yes, you know, yep, you've won a part of the case, you've won a small part of the case, but in bringing it to the courts, you are not actually achieving anything, and you are not going to get an order for costs in your direction. But this takes away that discretion. This takes away that discretion and allows or forces the judge involved to award costs in favour of a complainant, even if, on the balance of all the activities in the case, all the conduct during the proceedings of the case, looking at the relative merits of the parties' positions and then looking at the ultimate outcome. Effectively, this law says the ultimate outcome is the only thing that matters. The ultimate outcome is the only thing that matters. Mr Acting Deputy President, I think this bill is overreach. I think it goes too far, and I believe that we should oppose this bill.
Thank you. There's 30 seconds to go before we get to 2-minute statements. So with the concurrence of the Senate will move straight into 2-minute statements. I'm speaking very slowly. Oh, sorry, Senator.
Contribution on the bill, and it'll be a very important contribution because it's a very important bill. That I understand that time is of the essence, and I will be in continuation, would be my understanding, Acting Deputy President.
Senator, being 1:30,
yes.
We will now be proceeding to 2-minute statements. You will be in continuation. Senator Hume.
Thank you, Acting Deputy President. There was a lot to learn from last week's GDP figures. Not only are we in the longest household recession in 50 years, but productivity has collapsed by 6.3% since Labor came to power. When productivity is going backwards, it's absolutely impossible to grow the economy in a sustainable way. In fact, the only thing that's propping up economic growth right now is that excessive government spending. Now, Jim Chalmers is the Treasurer is trying to make a virtue of this, but it simply shows just how much the private sector is, and particularly small business, is retreating on his watch. The reason that private sector spending has ground to a halt is because Labor have sucked the aspiration out of our economy. Recent statistics show that only 8% of small business owners are under the age of 30. Now, that's half the number of small businesses owned by young people in the 1970s. And you can understand why. Why would a young person take a risk to start a small business when Jim Chalmers is simply going to hit them with higher energy prices, complex industrial relations rules, and of course, more taxes? Just recently, I joined my friend and colleague, the member for Casey, Aaron Violi, to meet with small businesses out in Healesville in Victoria. The pain that businesses feel goes so far beyond simple high inflation or high interest rates or high energy bills that are pushing up their overheads. They told us that there's an increasing amount of red tape wrapping their ability to grow their businesses, that Labor's industrial relations changes have only made life more difficult. Keeping up with complex awards and employment rights has become a nightmare. Now, these are businesses that don't have HR or legal departments. They have mums and dads that do their businesses during the day and then go home and do the books at night. The only way to get the economy moving again is to place the economic settings in place that will allow businesses to grow. Productivity is essential for our prosperity.
Senator, your time's expired. Senator Gregan.
Thank you, Acting Deputy President. Today I rise to draw attention to a conspicuous silence from those opposite. Conspicuous silence about one of the first policy proposals to be put by the new leader of the Liberal Party in South Australia, Vincent Tarzia. On this side of the chamber, we know that South Australians expect quality, accessible and affordable health care. And they need it when they need it, not to be worrying about what they may have to pay for it. One of the utmost duties of the government is to provide certainty and care for the people of this country. It should be above politics. People should have the confidence that it's going to be there when they need it. But that's not the case. That's not what's happening here. One of the first policy proposals to come out of the new Tarzia-led Liberal Party came straight from the mouth of Shadow Assistant Minister to Mr Tarzia, Adrian Peterick. And let me just quote what he said. "If there was a gap fee for people turning up to emergency that didn't get admitted, I think you'd see a drastic reduction in people attending emergency departments." Now, that's not the first time we've seen this kind of commentary from the Liberal Party across the country. Let's not forget that it was the former Health Minister, Mr Dutton, who wanted Australians to pay a patient tax when they went to the GP. It's the same Health Minister, by the way, who was voted the worst Health Minister in Australia's history. So the question here is, what do the Liberal Party actually care about? Do they care about cost of living, or is this just a wedge they're using? Do they care about accessible healthcare, or is it just smoke and mirrors? Fundamentally, let's hear you condemn Tarzia's tax, let's hear you condemn Dutton's tax, and let's support South Australians and all Australians' healthcare.
Senator Waters.
Thanks very much, Acting Deputy President. Well, last night this building was overflowing with mining and fossil fuel lobbyists for the Australian Minerals Industry Parliamentary Dinner. The event is hosted by the Minerals Council, who donated $84,700 to Labor and $146,380 to the LNP just in the last financial year. Last week, the Prime Minister was in Western Australia doling out tax credits to mining corporations. But at last night's dinner, Minerals Council CEO Tanya Constable told the PM in her address that the environmental approval process must be sorted out in a way that provides unfettered tax-free access to land and resources, ignores the wishes of traditional owners, ignores biodiversity and climate, and has little industrial relations protection for the mining sector's workforce as possible. She effectively warned the Prime Minister to undermine mining profits at his peril. Earlier this year, the Minister for Resources tried to pass an amendment to give her, rather than the Environment Minister, ultimate authority for offshore gas project approvals. That proposal to bypass environmental approvals, which the Greens stopped, followed revelations that Minister King received a request from the CEO of Santos to gag First Nations groups and fast-track new offshore gas. Santos asked for the laws to change to bolster their own profits, and presumably Santos thought that its $110,000 donation last financial year makes such a direct request to the minister entirely reasonable. Well, who is the government working for, the Australian people or the fossil fuel industry? Twice I've introduced a bill to ban donations from fossil fuel corporations and other sectors with a track record of trying to buy influence, but there hasn't been any interest, and I wonder why, because it's not in the interests of their donor mates.
Senator Sharma.
The nation of Bangladesh has seen significant turmoil and unrest and a tragic loss of life in recent months, but I'm pleased to be able to say that since the interim government took office under the leadership of Muhammad Yunus on the 8th of August, they have made significant progress towards restoring stability in Bangladesh, but also restoring people's rights and freedoms. We've seen a new Chief Justice appointed, we've seen a new Central Bank Governor appointed, we've seen 16 university vice-chancellors step down who were involved in suppressing the legitimate protests by students on their campuses. We've seen the interim government promise to try those responsible for state-sponsored killings, and it's important that those crimes do not go unpunished. We've also seen the interim government throw out some of the spurious cases brought against the student protesters by the former government in Bangladesh, and we've also seen reforms to the police force to restore faith and trust in that institution. And I wanted to commend here the people of Bangladesh and the large Bangladeshi diaspora abroad, including in my own home state of New South Wales, and Bangladeshi civil society, and especially the brave student protesters who demanded to take back their country and bravely faced off against heavy-handed security forces. Tragically, some 450 protesters paid for Bangladesh's freedoms with their lives, and it's important that their memories be respected and that their legacy be taken on board by this new interim government. It's important in Australia that we support the interim government. We would like to see elections free and fair as soon as possible, but we recognise that institutions and faith in Bangladesh's institutions must be rebuilt first. But also, we do urge respect for the political and civil rights of all Bangladeshis, regardless of faith or political affiliation, and warn against any retributive violence.
Senator Walsh.
Thank you, Acting Deputy President. Well, last week marked Women's Health Week, and as a gender-equal federal government, we are committed to a health system that works for women. For too long, women's health has been overlooked, and as someone who's always fought for a better future for women in this country, I'm proud to say that we're determined to change that. Our fantastic Assistant Minister for Health, Jed Carney, is leading the charge. She's been actively listening to the needs of Australian women and collaborating with the Victorian State Government to ensure impactful initiatives in my home state. Since we've been in government, we have established the National Women's Health Advisory Council, giving a voice to women and girls across the nation. We've launched the End Gender Bias Survey to better understand women's real experiences and guide our policies, and it's working thanks to this absolutely crucial work and the brave women who have shared their stories. We have funded 22 endometriosis and pelvic pain specialist clinics, including 4 in Victoria. We've committed $160 million in the budget to women's health, because under our government, improving women's health is core business. And making sure that women are treated with respect and dignity and listened to about their health, that is core Labor business. This work not only advances gender equality, but it saves lives too. So thank you to all the women who've participated and spoken up as part of this work, so that women's health is the priority that it needs to be, and so that women's health and their needs are seen and heard and addressed in this country.
Senator Lambie.
Thank you. Last week, Canadian milk giant Saputo announced they were closing King Island Dairy and retiring the brand. I was on the island earlier this year and had heard from locals that they were worried that this might happen. The King Island Dairy was set up by farmers in 1902, and it was their cheeses, still made by hand, that put Tasmania on the global food map. It was a devastating loss for the island, not just the jobs and the families those jobs support, but the effective death of an iconic brand that served as a brand ambassador for the world-class food we export all over the world. All Tasmanians benefited from this success. The Tasmanian Liberals say they are working hard to find another investor. Well, I hope so. All Tasmanian politicians, state and federal, need to pull out all stops to fix this. Saputo say they are also trying to find alternatives. My office reached out to them today again to get more details, and we were told they had nothing more to say. Meanwhile, in Burnie, workers are still on strike at the Saputo factory, and all they're asking for is the same pay packet as the same workers on the mainland. On their website, Saputo say they have responsibility to demonstrate good corporate citizenship. How's that going for you? Well, there is a story doing the rounds that Saputo had a buyer, but they didn't want any competition. How disgraceful of you. And of course, the islanders have been here before. In 2012, Brazilian company JBS closed down the abattoir on the island. That abattoir is still sitting empty with a loss of 150 jobs and leaving beef farmers with hefty freight bills. We see it time and time again. Multinationals, God damn them, buying into our Tasmanian companies, standing shoulder to shoulder with you politicians in here, only for them to turn their backs on the locals before much longer. I'm hoping that an angel investor can be found, because the loss of the King Island Dairy is not just a loss for King Island, it is a loss for the whole of Tasmania.
Senator O'Sullivan.
Thank you. I wish to draw this chamber's attention to the Liberal Party's excellent candidate in Tangney, Howard Ong. I've had the privilege of getting to know Howard over the past 2 years, and what I see is a committed, engaged and importantly a caring person that will deliver real results in Tangney. When Howard and his wife Hilda moved to Australia from Singapore over 28 years ago, he started his own successful small IT business and has been giving back to his community by volunteering across numerous initiatives for decades now. And by standing as a candidate for the upcoming election, he's wanting to serve the community now in a representative way. And I can't think of anyone better to represent the Tangney community in the southern suburbs of Perth. Howard has hit the ground running in Tangney. He's already out there on the hustings, door knocking and getting around as many community groups and businesses as possible. An important trait in any member of Parliament's role is their willingness to listen, and Howard is doing just that. He's speaking to locals, and it's clear that many residents are concerned about the direction that this government is taking our country. Australians all over are feeling the pinch. Small businesses are hurting and communities, sadly, are feeling unsafe. Now, just last week, Howard mentioned his local tennis club faces over $20,000 in increased electricity bills. A barber in his area pays more than $10,000 monthly in rent, and many residents are saying that their mortgages are unsustainable. And Prime Minister Albanese is neglecting to address the real problems facing Western Australians. He does not get WA, but Howard Ong does. Howard is a real local that will deliver real results. And I'd encourage anyone living in Tangney to give Howard their full support.
Senator Sheldon.
Well, this week we saw the chaos that ensues when the Liberals and Nationals have to come up with actual policies. Now, since the last election, they've only come up with 3. They've committed to undoing all of Labor's good work on improving wages and conditions, and they want to raid your super to inflate house prices. and they want to spend $600 billion of your money on their mates' nuclear power plants. Now, that is the grand sum of their plans for the economy. Lower wages, lower super, and bankrupting the country to pay for their nuclear money pit. Now, in this policy vacuum, shadow ministers have begun freelancing on policy. I don't blame them, because it's hard to campaign on no, no, no all the time. So yesterday, the Leader of the Nationals in the Senate, one of the most senior coalition members, came up with a bright idea to flog off Jetstar, presumably so that their mates in Qatar or another foreign capital fund can purchase it. Now, it's clear to me why that is a ridiculous idea, because breaking a wing off our national airline and flogging it to the highest bidder would be worse for workers, worse for passengers, and worse for our national sovereignty. Now, thankfully, Senator Mackenzie thought ahead and avoided all these issues by not telling anyone about her policy before she announced it. Mr Dutton's policy platform is like a dinner party hosted by a bloke who couldn't even boil water, because the leader has nothing to offer, so guests are rolling up with their own rancid policy dishes, and sadly, it's the Australian people who have to tuck into it.
Senator Steele-John.
Thank you, Acting President. The rental market in this country is completely broken. Never before has a system that was designed to help people achieve a basic human right been so stacked in the favour of profiteering corporations and apathetic landlords. Renters know the system is stacked against them. We are seeing people compete to get a rental, lines around the block. And if you are lucky enough to get one, you have to cross your fingers that you will get a benevolent landlord, one that isn't unresponsive, dismissive, and intrusive. The horrors are abundant. Rain pouring through leaks in the ceiling into the living room, mould in the bathroom, the absence of basic amenities like air conditioning and insulation. These are just a few of the problems that renters face. And if they complain, the Tenancy Acts are weaponised against them, leaving them fearful that they will be punished, including via eviction. That is why the Greens are proposing a National Renters and Rental Protection Authority. The National Renters Protection Authority would play a key role in enforcing new national rental tenancy standards. The Greens' plan would ensure $2.5 billion was injected towards states and territories that adopt model laws that place power back in the hands of renters. It is time that we protect renters' rights and back...
Senator David Pocock.
Thanks, Acting Deputy President. Today is World Suicide Prevention Day, an important opportunity to raise awareness, share messages of hope and encourage people to seek help. Each year in Australia, over 3,000 Australians die by suicide, and an estimated 55,000 Australians attempt suicide. Suicide is the leading cause of death among men aged 15 to 44, the leading cause of death. And one of the things we need to be talking about more as men is encouraging each other to actually talk about mental health, to reduce the stigma when it comes to reaching out to your mates or to a healthcare professional and actually talk about what's going on for you. There wouldn't be anyone in this place who hasn't been affected by a loved one or someone they know committing suicide. And often it's men who we think are the strongest, the most bulletproof, the ones that we thought had it all together. But underneath that was someone who was crying out for help and didn't feel like they could reach out and make themselves vulnerable. And so I'd encourage young people here, men out there, to actually think more about the ways that you can support your mate, and when you're facing issues yourself, to reach out. It's not a sign of weakness, it is actually showing strength as a man. We can only be human together. It's in our bonds and our friendships that really make us human. So it's a good thing to remember on this World Suicide Prevention Day.
Senator Scarr.
Thank you, Madam Acting Deputy President. I just want to associate myself with Senator Pocock's remarks. Mental health issues should be treated exactly the same as any health issue. No different to a broken arm, a strained wrist, whatever. They should be treated exactly the same, and that's where we need to get to as a society. At a National Press Club address, the Greens leader, Adam Bant MP, has announced the Greens tax policy. The Greens have let the cat out of the bag, and what a feral, mangy little beastie it is. A $514 billion tax grab. Can you believe it? The Greens are proposing a $514 billion tax grab. That's their solution to the current economic woes the world's facing. $514 billion of extra taxes. The extreme Greens tax policy would be a wrecking ball through the Australian economy. A wrecking ball. It would destroy thousands and thousands of jobs. It would decimate industries. It would force business offshore. It is economic madness. The Greens' $514 billion tax policy, the $514 billion tax grab, is economic madness. It is not in the best interests of the Australian economy. It is not in the best interests of the Australian people. And everyone in this chamber, other than the Greens, needs to bring the extreme Greens tax policy, a $514 billion tax grab, to the attention of the Australian voters before the next election. We cannot afford the Greens' extreme $514 billion tax grab. It would decimate the Australian economy and hurt the people who we represent in this place.
Senator Hanson.
Thank you very much. Well, last night I attended the Minerals Council of Australia dinner in the Great Hall with approximately 400 other guests. CEO Tanya Constable delivered a strong, passionate speech encompassing the hardship, challenges and benefits the mining industry delivers to Australia by way of taxes, jobs and infrastructure in rural and regional areas. She acknowledged the Prime Minister and, doing so, pleaded with him to support the industry instead of making it harder to do business. It was a fantastic, factual and hard-hitting speech that resonated with her colleagues and myself. On the other hand, the Prime Minister's speech was disingenuous. He delivered what he thought the room wanted to hear, but his actions over the past 2 years speak volumes. I was disgusted, furious and angry at his hypocrisy. So were many in the room. He has done so much damage to the mining industry since taking office, and in further legislation yet to be passed, such as the Nature Positive Plan, this piece of legislation is ridiculous and will cause more stress and cost. The PM spoke of consultation and an open-door policy, but nothing can be further from the truth. Everyone who consults is being required to sign non-disclosure agreements. Industrial relations, the safeguard mechanism, union and Aboriginal overreach, net zero and climate change BS, all of this and more risks the destruction of an industry worth about $350 billion a year in taxes and royalties and about 1 million direct and indirect jobs. The PM's refusal to overrule Tanya Plevesek's decision to ban the Blaney gold mine on baseless grounds and lies is a testament to his real attitude to mining. Also, I must add, his destruction of the farming industry in Australia as well. Shutting down the live sheep export, considering we have the best practice in the world, is sheer bloody-mindedness. As I've said on many occasions, he's the worst PM this country has ever had, and the sooner he and his government are thrown out, the better for all of us.
Senator Van.
Thank you, Acting Deputy President. Australia needs to replace our coal energy fleet with cleaner, greener firmed alternatives, and personally, I'd like to see this happen far sooner than later. Australia needs to replace our coal energy fleet with cleaner, greener firmed alternatives, and personally, I'd like to see this happen far sooner than later. certainly far sooner than scheduled. That is the low-hanging fruit in the decarbonisation transition. Unfortunately, our current approach to energy planning is driving a painfully slow pace and with only limited decarbonisation gains. The use of large, expensive transmission lines to provide more hosting capacity will only have a limited impact, cost tens of billions of dollars, and take at least 10 years. As the Chair of the Australian Energy Regulator, Claire Savage, wisely pointed out in an article recently, it is vital that before we build more network, we use more network. Why did she say this? Because she acknowledged that network asset utilisation across the NEM has dropped to a mere 40%. Yet in the same breath, she says she sees a wall of capex, that's money, coming at consumers that could do more than offset the lower costs of wholesale energy. You heard me right. We'll be paying more in supply charges, but not necessarily lowering our bills. On the flip side of this, all that wonderful solar and wind that is out in the regions is not even making it into the NEM. In the middle of the day, between 11 and 2, when the sun's shining brightest, it's often curtailed. Yes, sometimes for network constraints. But more often than that, it's being curtailed for economic curtailment. That is, it's a negative price. People have to pay to put it in the grid. That is clean, green energy that we could and should be using for free.
Senator Stewart.
Thank you, Acting Deputy President. We know that harmful gender stereotypes can have a huge impact on young Australians. We know that by the age of 6, girls' interest in science, technology, engineering and maths in STEM education is already negatively impacted by gender stereotypes and biases. And this has lifelong consequences. Currently, women make up only 15% of the STEM workforce in Australia. We should be encouraging young women to pursue an education in the sciences, and we absolutely should be doing all that we can to knock down these stereotypes that hold them back. And that work starts at an early age. The Albanese Labor government wants to ensure that our early childhood educators are well equipped to provide the best learning environment to teach children about STEM concepts early. I'm proud to be part of a government that is funding a 15% pay increase for our early childhood educators, but our work doesn't stop there. I'm pleased that the government has provided $6.7 million to the Little Scientist program. This includes professional learning for early childhood educators that aims to improve their confidence and ability to introduce STEM concepts. I recently had the pleasure of representing Education Minister Jason Clare at the Little Scientists Early STEM Education Awards ceremony at Froebel's Carlton Early Learning Centre. The awards celebrates and recognise excellence in early STEM education for children aged 0 to 7. And this year's theme, Overcoming Gender Bias in Early STEM Education. The award recognises the critical role of early childhood educators and teachers play in overcoming gender stereotypes and implicit gender biases that impact young girls' participation in STEM education. I received such a warm welcome at the centre. Congratulations to Froebel's Carlton's Warren team for being awarded Outstanding Early STEM Education Award for their project Blue It Sounds Blue. Congratulations to also Laura Satina and Rebecca Drysdale.
Senator Cox.
Thank you, Acting Deputy President. For the past 3 years, I've attended the annual Yamaji on Country events held in the Pilbara and in the Midwest Gascoyne regions of WA. This is a festival of culture, song, dance, food and language, and people who are all critical to sustain the oldest living continuing culture in the world. It is a place to come together and for community members to hold important conversation about what affects their lives and the solutions that they want to see implemented through their calls to action. It's a true example of what community-driven solutions, self-determination and place-based solutions all look like. At each of these events, I've heard WA grassroots communities talk about the importance of their voices being heard by all in state and federal politics. Yet this continues to be ignored by those in governments. Nothing gets actioned, and even if they show up, there is no report card or any solutions from either one of the major parties in the last few years. There are important issues such as racism, leadership, housing and accommodation, police and justice, education and employment, training and economic development, health and wellbeing that are all being raised across both forums. The Midwest event occurred days after the National Cabinet was in Perth, but not one federal politician had the decency to turn up. So much for hearing their voices, which is cold, deafening silence for those on the ground. The government rolled into town and met with hand-picked organisations, not meeting with the grassroots democracy in action, why people need to be included in these conversations about how things actually work on the ground. Our communities are sick and tired of not hearing any truth-telling or any truth listening by MPs that only bring hollow promises all the way to Western Australia.
Senator Green.
In the House of Representatives, the Liberal National Party voted against a bill to make manufacturing jobs here in our country, the Future Made in Australia bill. Imagine being so against Australian jobs to vote against.
Thank you, Senator Green. Right, we'll move to question time and Senator Brockman.
Thank you, Madam President. My question is to the Minister representing the Prime Minister, Senator Wong. Today, we saw thousands of farmers and truckies rallying outside Parliament House, many of whom have travelled up to thousands of kilometres from Western Australia to stand up for their livelihoods, to stand up for their communities, to stand up for their families after the appalling decision of the Albanese government to abolish live sheep exports. Minister, why was the Prime Minister too gutless to face these farmers outside Parliament House and explain why he has legislated to destroy their livelihoods and a successful Australian export industry?
Thank you. I'm going to ask for silence before I call the Minister. Minister Wong.
Thank you, President, and thank you to Senator Brockman for the question. And Australia is a democracy and people can protest. And people are entitled to come and put their views to our parliament and to do so respectfully. And protests of many shapes and sizes and on different issues have been seen, have been part of our democracy for a very long time.
Order, Senator Ruston. I called for order. I reminded senators in this chamber that they needed to listen in silence before I called the minister. That includes you, Senator Ruston. Minister, please continue.
Thank you. I understand the Prime Minister did meet with a delegation and I'm sure I haven't spoken to him about it, but I'm sure that they put their views and he would have put ours. And our views are that...
Order. Order. And Senator Ruston, I believe that your scarf needs to be turned around so it can't be read or taken off. Minister Wong, please continue.
Well, people in this democracy can disagree, but do so respectfully, something I might remind Senator Ruston about. The primary producers are a very important part of our economy and our community, and I appreciate that people don't agree with the decision the government has made to honour an election commitment, but it was an election commitment. It was an election commitment that has been taken to the Australian people, I think, not on one but two occasions, and we have sought to fulfil that, consistent with the pledges we made to the Australian people. We have given, this was a trade, obviously, that was already declining. This is a trade where we have given a substantial notice of the phase-out and are seeking to assist with an orderly transition by investing $107 million into...
Thank you. Senator Brockman, first supplementary.
Minister, latest figures show the flocks...
beg your pardon. Sorry, Senator Brockman. There was 10 seconds to go. If we can put 10 seconds back on the clock. I have asked... OK, so I'm going to... Senator Brockman, if we set the clock again, I'll ask you to start again on your first supplementary.
I would like to finish my answer.
Okay,
I was sitting down because
you sat
Senator
down.
Ruston continues to interject.
So just so...
So I will...
Order. Order.
There is a...
Order.
Do you want to answer?
Order across the chamber. There was 10 seconds left on the clock. Minister Wong has indicated she has not finished her contribution. Senator Wong, I invite you to continue for the next 10 seconds.
I would make the point that...
Senator McGrath. Minister, please continue.
That this government has put a very substantial amount into assistance to try and manage an orderly transition and to ensure jobs in Australia.
Thank you, Minister. Senator Brockman, first supplementary.
Minister, latest figures show the flock size in Western Australia dropping by 27% in 1 year, with industry experts predicting a 35% decline in lamb
Senator
numbers. Your government promised more processing in WA to replace live exports, but these numbers clearly show you are destroying the West Australian sheep industry. Minister, can you look those outside the building in the eye, fighting for their future, fighting for the industry that they love, and tell them that the process...
Minister Wong.
For the senator to finish. I leave.
Please finish. Thanks.
And tell them that the processors won't also close on the back of declining sheep numbers.
Thank you, Senator Brockman. Minister Wong.
Thank you for the question, Senator Brockman. Can I make a few points about the size and trajectory of this industry? In 2014-15, 2.1 million sheep were exported by sea at a value of $224 million. In 21-22, 475,000 sheep were exported by sea at a value of $80 million. So over the decade that the Liberals and Nationals were in government, live sheep exports decreased by 144 million and over 1.5 million head. Meanwhile, 1.5 million. So let's remember when those opposite were in government, we saw a reduction in this trade by value and a very substantial reduction by head. So I do respect that this is a difficult transition for those families and producers who have been in this trade for a long time, but this is a trade that has been
thank you, Minister. The time
under
for
you in
answering
decline.
has expired. Senator Brockman, second supplementary.
The Albanese government has banned the successful live sheep export sector, blocked job-creating mining projects, created chaos in the construction sector and driven up electricity prices for all Australians. Why is the Albanese government prioritising implementation of extreme policies of their friends and allies, the Australian Greens, and not delivering what's best for Australians?
Order. Order across the chamber. Senator Watt and Senator McKenzie, that applies to both of you. Minister, please start your question.
Thank you, President. Well, I would invite the senator to look at the work we did to reopen China as an export market for our barley exporters.
How's those barley exports
I would ask the senator to consider, and I would say to the sector, we have had live cattle exports grow by 54%, and we have exports of beef to Indonesia hit a record high in 22-23. I would remind those opposite that we have seen, under the work this government has done, increase in the exports of wine. We have seen some $20 billion of impediments that were in place when we came to government under you, which primarily affected some of the sectors that were included in your question. And we have seen that trade impediments have been removed on all of those sectors other than $1 billion worth as at the time of those impediments being imposed.
Thank you, Minister. The time for answering has expired. Senator Marielle Smith.
Thank you, President. My question is to the Minister representing the Prime Minister, Minister Wong. In my state of South Australia, parents often tell me how concerned they are over social media and the risk of harm that it's presenting to their children. South Australia has, of course, introduced landmark new laws to protect children and to support parents. Can the minister explain what the Albanese government is doing alongside the South Australian government to keep children safe online?
Order. Just a moment, Senator Wong. Senator McKenzie, you need to cover that shirt or remove it. Senator McKenzie, it's a prop. Cover it or remove yourself from the chamber. Order. 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 Senator McKenzie, I think your shirt is still visible, so I think you need to turn it inside out or leave the chamber. Order. Order. Senator McKenzie and all of the senators who think this is funny, props are not allowed in this chamber, nor are T-shirts or other paraphernalia that has words which are clearly visible. Senator McKenzie, I've given you a choice. No, it's not okay. Senator McKenzie, unless you intend for the whole of question time to sit there and hold the blazer, that is not appropriate. I've given you an option. No, I've given you an option. Minister Wong.
Thank you. Well, I'm very happy to answer a question about the safety of our children. And thank you, Senator Smith, for asking this question. And I think all of us know the extent to which this is an issue that parents are really concerned about. And parents are looking for leadership and for guidance and for help in how all of us manage what is a pretty tricky thing to negotiate or to put boundaries around with our children. And I'm sure you have found that this is something parents raise with you, and parents and grandparents. And so we know, of course, that social media can cause social harm and is taking kids away from real friends and experiences. And more importantly, we know that early access to social media can be very detrimental for young people's mental health and physical health. People want real solutions, and we as a government believe that working for the safety of our children is paramount, and that's why today the Prime Minister has announced we will introduce legislation to enforce a minimum age for access to social media and other digital platforms, other relevant digital platforms. That legislation will be informed by engagement with states and territories, and I do want to acknowledge the role of Peter Malinauskas, the Premier of South Australia, who has been engaging with not only his community but also with the Prime Minister on this issue. I'm very pleased that has resulted in the announcement that the Prime Minister has made. As Peter Malinauskas has said, as Premier Malinauskas has said, the work that South Australia has done is important, but we need a nationwide solution. And it is a Commonwealth. I'm surprised you are laughing about this. Most parents actually care about this issue. The community cares about this issue and they're laughing about it. It's quite extraordinary. A Commonwealth-led approach will ensure all Australian children are better protected from online harms.
Senator Marielle Smith, first supplementary.
Thank you, Minister. It certainly is a huge issue and an issue of concern for all Australian parents. Can the Minister outline how the Albanese government's approach, including the age assurance trial, will ensure effective social media age limits?
Minister Wong.
Thank you, President. As I said, a Commonwealth-led approach will ensure that all the children are better protected from online harms and ensure parents and carers are better supported. And we also want to hold big tech to account because platforms and online services have a responsibility for the safety of their users. And I hope this is something on which we can get agreement across this chamber. As I said, we will work with the states and territories to get this right. We are also going to consider the results of the various measures that Minister Rowland has put in place, the Age Assurance Trial and the Online Safety Act review. These measures have been welcomed by the E-Safety Commissioner, and the trial in particular is testing different implementation approaches to help inform policy design. We want to work with experts, young people, advocates and parents through the trial because we want these laws to be effective and we want to make sure that big tech plays their part in protecting users.
Thank you, Minister. Senator Smith, second supplementary.
Thank you, Minister, for outlining our government's approach. Can you explain why the Albanese government is taking action on this important issue now?
Thank you, Senator Smith. Minister Wong.
Thank you. And I hear what those opposite are saying.
Order.
They're telling us that, why hasn't this been done before? Why hasn't there been more action? I wonder what could have happened over nearly a decade of government. I mean, if only they'd been in power for nearly a decade. When the explosion in the online world really occurred, if only someone in power then thought that this might be an issue. Occasionally in politics it is a good thing to say, yeah, this is a good idea. Occasionally in this chamber it is a good thing to say, that is a good idea and we're going to back it. But they can't help themselves, can they? They can't help themselves. They have to. Yeah, they're doing it again. Look at this. Here we are. Both sides of politics might actually do something about safety of children, but those opposite just want to get angry about it. Well, we on this side, we want to make sure that protection of our children is paramount, and that is what we will do, and that is what we will legislate.
Senator Cash, once again, I called you to order, and you didn't come to order. I would ask you to not wilfully continue on when I've called you to order. Senator Davey.
My question is to the Minister representing the Minister for Agriculture, Minister Watt. There are thousands of farmers rallying at Parliament House today, devastated by years of the Labor government's anti-farming agenda, which over the last 2 years has scrapped live sheep exports and the ag visa, slapped farmers with a fresh food tax, a truckie tax, a ute tax and a superannuation tax on family farms, forced water buybacks, ballooned electricity bills and cut or delayed regional infrastructure funding. How will the Albanese Labor government policies do anything other than punish regional Australia and the farmers who feed our nation while further driving up the cost of living for all Australian families?
Thank you, Senator Davey. Senator Davey, Senator McCarthy is the repping minister. I note you've put the question to Senator Watt, so it's really up to you.
Go to the relevant repping minister.
Thank
Senator
you.
McCarthy.
Sorry, Senator McCarthy.
Thank you, President, and thank you, Senator, for your question. We are concerned, obviously, for all Australians, and that certainly does mean our producers, our farmers right across the country, and we certainly acknowledge the 400 protesters who gathered out there today. As Senator Wong said in her response to the previous, we certainly had...
Hey, oi! Order.
Senator Wong.
They're still going. They're still going.
Order.
They're still going.
Order.
Are you unable just to stop? I am saying... Point.
Minister, please resume your seat. Senator Cash, just prior to Senator Davey getting on her feet, I reminded you that when I called order, it applied to you. I will advise you that I will use the Standing Order 203. Now, if you don't agree with the response a minister makes, then that is what taking note is for, or indeed the open-ended adjournment. It is not an opportunity for you to continue to interject across the chamber. Minister McCarthy.
Thank you, President, and I will just address that for a moment. This isn't the concern about the hundreds of people that are out the front. No. In terms of numbers, Senator. In terms of numbers, Senator Cash.
Order.
What I was saying, which none of you have picked up on, is that we are concerned about all Australians, especially those people on the land.
Please resume your seat. Order. If you can't remain silent, I invite you to leave the chamber. Goes for Senator McGrath, Senator O'Sullivan, Senator Davey. Minister McCarthy, please continue.
Thank you, President. And I do urge the opposition to give me a chance to respond here. We are very, very concerned about all Australians, including our farming sector. The Albanese Labor government is committed to a robust, sustainable ag industry that continues to thrive in Australia. Since coming to government in 2022, we've been delivering for Australian farmers and producers, strengthening biosecurity, boosting the ag workforce, opening new trade opportunities and improving farm sustainability. We've delivered over $3 billion in extra funding for agriculture since taking office. Right. Despite the tight fiscal environment we find ourselves in, we're getting on with the job of fixing what the previous coalition government failed or couldn't be bothered to do,
it's a long list.
Fixing the $100 million black hole left in the biosecurity budget, and we're actually taking action on climate change and helping industry meet its own climate targets after 10 years of denial from those opposites.
Thank you, Minister. Senator Davey, first supplementary.
Minister, recent data from the MDBA shows that water diversions are now 23% below sustainable diversion limits, yet the Labor government is continuing to prioritise buybacks out of farming communities. Why does the Labor government only look at buybacks as a solution and ignore real degradation drivers like European carp? When will the government listen to farmers rather than acting against them?
Minister Wong.
Thank you, President. A point of order. That relates to a policy area that is not in the agricultural portfolio. It's in...
Senator Ruston.
Really?
Thank you, Minister.
She's
Thank
very
you, Minister Wong.
today.
I think Senator Birmingham also has a point of order. If
Well,
you finish
I don't think. Well, with respect, what I'd ask the senator to consider is if she wants to recast her supplementary question, buybacks are clearly not the responsibility of the agriculture portfolio.
Just a moment, Senator Davey. I'll come back to you, Senator Birmingham.
Thanks, President. On the point of order, President, Senator Davey's primary question referenced a number of impacts on farming communities, of which she identified water buybacks as one of those impacts in the primary question. This is a supplementary question going into that issue. The idea that water buybacks do not have an impact on the agriculture portfolio is a preposterous idea. They may not be the direct responsibility of the agriculture portfolio, but that is like suggesting that industry policy doesn't impact the Treasury portfolio or a range of other areas where the impacts on industry.
I intend to, Senator Wong, I'm intending to respond.
Specifically to sustainable diversion limits, that is very clearly a matter not within this portfolio. It cannot possibly be addressed to this minister.
Order. Senator Birmingham, order. I am advised by the clerk that Senator Davey should be given the opportunity to recast her question and link it to... And Senator Birmingham, you are not in a debate with me. I'm ruling on a point of order. Senator Davey, I invite you to recast your question and link it to agriculture.
With pleasure. Minister, recent MDBA data shows that irrigation farmers in the Murray-Darling Basin are using well below what has been identified as sustainable diversion limits. Yet your government continues to buy water from them, impacting negatively their communities. Why don't you listen to the farmers and review your policies on how you treat irrigation farmers?
Thank you, Senator Davey. Minister McAllister.
Thank you, President.
Minister McCarthy.
Thank you, President. I do believe, as Senator Wong has said, that this part of this question does go to a fellow minister. But please, let me finish. If I may finish, President. If I may finish, I would like to make reference to the question itself in terms of correcting Senator Davey that we aren't just buying. We are not buying back water only. We are funding water infrastructure and water efficiency projects, Senator Davies, and you know that. You know that. And so does Mr Littleproud know that. In fact, I don't think he's got that great a record either. I understand that he wasn't that welcome there today with the farmers in terms of the water as well.
Senator McGrath, order.
Poor David. Nobody likes David.
McCarthy, please. Order. Senator McGrath, I've called you to order 3 times. You ignored me. I remind you as well of Standing Order 203. Minister McCarthy.
Thank you, President. Well, as I was saying, it was noticed, other than other things that the opposition have said, it was noticed that the farmers were not happy with the Leader of the Nationals either. So I suspect...
Thank you, Minister. The time for answering has expired. Thank you, Minister. Senator Davies, second supplementary.
Minister, Australian farmers have now seen their pea contracts cut by 34% because Coles is importing peas from overseas. Similar scenes have been faced by SPC and Shepparton when the big supermarkets purchased imported fruits for their tinned fruits. Why is under Labor our farmers always getting done over? Is it any wonder that the farmers are out the front of Parliament House rallying today?
Order. Senator McCarthy.
President, well, we know that people can hold protests. It is a democracy in this country. But I will correct Senator Davey. We have been doing a tremendous amount in this area. And as I've outlined already in my previous responses, we've also been fixing the APVMA after it became a dysfunctional mess
remember that one?
at the hands of Barnaby's forced move to Armidale. The opposition spent almost a decade neglecting and eroding our trade relationships.
Minister
They
McCarthy,
destroyed...
please resume your seat. Order. Minister Gallagher.
But the behaviour of the opposition this question time is really getting to a new low. They are ignoring your direction. Minister McCarthy can't answer unless she is shouting. You should come to order.
Thank you, Minister Gallagher. I'm sure that you have witnessed that I am doing my very best. I have reminded particular senators of Standing Order 203, and I will request that for the remainder of the minister's question that people listen in silence. Minister McCarthy.
Thank you, President. I'll just have to say some of the things I've just said, just in case they didn't hear it, that the opposition spent almost a decade neglecting and eroding our trade relationships. They destroyed the relationship with our biggest trading partner, which our government has restored. We've opened new trade opportunities that allow the industry to continue to grow and remain competitive, and agricultural exports are now more diversified than ever, thanks to the Albanese Labor government.
Thank you, Minister. Senator Hanson-Young.
Thank you, President. My question is to Senator McAllister, representing the Environment Minister. Any day now, Tamboran Resources has announced it will commence gas fracking in the Beetaloo Basin in the Northern Territory. This is a project that will take over 1 billion litres of water and generate risky, toxic waste, but has not even been assessed for its impact on the environment or indeed the water table. Has the minister bothered to consider pulling the water trigger? Why has the minister not used her powers given to her by this parliament to make sure this project is called in?
Thank you, Senator Hanson-Young. Senator McAllister.
Thanks very much, President. Well, as the senator knows, all projects must comply with national environmental law, and that includes, of course, the expanded water trigger that was introduced by the Albanese government. Now, the proponent for the project that the senator refers to, Tamboran, has been reminded of this on multiple occasions. And they also know that any breach of national environment law will be treated extremely seriously. Now, these changes to the water trigger occurred after the Albanese government passed our first tranche of environmental law last year to add unconventional gas to the water trigger under national environment law, and we have been extremely clear with industry to help them implement their obligations. Now, the Department of Climate Change, Energy, the Environment and Water wrote to known companies with activities in the Beetaloo Basin, including Tamboran Resources, to inform them of the new obligations that may apply to these operations under the recent water trigger amendments. I understand that the Minister's office has also spoken to these companies and reminded them of the requirements under the Act. I am also advised that the Minister has not received a referral for these activities. And the reality of the law, Senator Hanson-Young, is that the exploration in question is authorised by the Northern Territory Government. And so the department that the Minister Plibersek administers continues to work closely with the Northern Territory Government to understand the impact of authorised exploration and whether that could have significant impacts on Commonwealth protected matters, including water, and that is consistent with the law.
Thank you, Minister McCarthy. Senator Hanson-Young, first supplementary.
Thank you, President. I'd like to acknowledge the traditional owners joining us in the chamber today who have come all the way from the Northern Territory to call on the government to do more than simply write a letter. Do more than simply write a letter. There is power within the laws, and they want the Environment Minister to pull the water trigger, to call in this project and show some leadership.
Thank you, Senator Hanson-Young. Minister McAllister.
Well, Senator, as we've discussed in this chamber more than once, and as we've talked about in estimates, the Minister's obligations are to follow the law, and as you'd expect, her obligations are also to make decisions in a way that are legally sound and that withstand legal challenge. And to that extent, the Minister is incredibly conscious that it is a legal question as to whether the water trigger in the ledge applies to any particular development. And she has repeatedly made clear that as a potential decision maker, it is inappropriate to express an opinion about the question that you raise at this stage. As I've already indicated in my response to your primary question, the Minister is taking steps to receive advice from the Territory Government and also from her department.
Thank you, Minister. The time for answering has expired. Senator Hanson-Young, second supplementary.
Thank you. The Labor Party lost 10 seats in the Northern Territory election only a couple of weeks ago. How many more seats are you prepared to lose before you take action? Will the Minister pick up the phone today and tell Tamboran, stop right there? Stop what you're doing before this is properly assessed.
Order. Order. Senator Hughes, when you've quite finished. And Senator Canavan. Minister McCarthy, obviously the first part of your question is not, Minister McAllister, the first part of the question is not within your scope, but the second part is. Thank you.
Thanks very much, President. And I acknowledge, of course, that these issues attract very strong interest from community members. And may I particularly acknowledge the elders from the Northern Territory who have travelled here today. And I know that this will be a question that is important to communities. But the question, as you've put it to me, Senator Hanson-Young, asks the Minister to take a series of steps without having consideration to the law. In fact, what it more particularly asks the Minister to do is to take a series of steps in having regard to a whole set of issues that are not relevant to the questions a Minister must consider under the legislation. As I've indicated, the Minister has asked her department to provide advice to her to ensure that all the companies operating in the Beetaloo Basin are complying with their obligations under the Act.
Thank you, Minister. Senator Stewart.
Thank you, President. My question is to the Minister for Women, Senator Gallagher. The Prime Minister convened National Cabinet last week, bringing together all jurisdictions to work together to address the scourge of gender-based violence. Addressing violence is a priority in both Working for Women, a national strategy for gender equality, and the National Plan to End Violence Against Women and Children. Can the Minister please update the Senate on the outcomes of National Cabinet, and how is the government working to improve the lives of women across Australia?
Minister Gallagher.
Thank you very much, President. I thank Senator Stewart for the question and for her ongoing commitment to driving gender equality. Indeed, all of the members of the government Senate team in doing that work. Too many women live in fear and too many lives have been stolen. Too many women live with ongoing trauma from their experience of violence in this country. And it's not just women's safety and well-being. Gender-based violence stand in the way of women achieving their potential, including their economic potential. This is why ending gender-based violence has been such a priority for the Albanese Labor government. Last Friday, National Cabinet did agree to a $4.7 billion package that harnesses important opportunities to work together to prevent violence and, importantly, to support and provide certainty to community-based legal services. This important package brings together efforts and funding to deliver much-needed support for frontline specialists and legal services in responding to gender-based violence, better innovative approaches to better identify and respond to high-risk perpetrators to stop violence escalating, and addressing the roles that systems and harmful industries play in exacerbating violence. The package includes a range of measures, including $3.9 million for a new national access to justice partnership, including a critical $800 million funding uplift with a focus on uplifting legal services responding to gender-based violence. For the first time, we will provide ongoing funding certainty beyond the 5-year agreement so that that sector does have that certainty that's been so badly needed. This is new money. The former government, of course, had left a funding cliff with no funding for these critical services beyond the mid-2025s. We've addressed that cliff and uplifted the funding, and we've also agreed to a new national partnership agreement on family, domestic and sexual violence responses.
Senator Stewart, first supplementary.
Thank you, Minister. Achieving gender equality relies on women being safe and economically secure. Can you please outline the work the government has done to drive gender equality, including initiatives that are supporting the economic security of women?
Minister Gallagher.
Thank you very much. I thank Senator Stewart for the supplementary, and it's an important one because we can't look at women's safety in isolation from other areas where we need to address gender inequality, and that's why in our government when we are going through the budget process, we are assessing every NPP, every new proposal against what it means for women in this country. We do gender analysis to make sure that we fully understand the implications of those decisions that we're taking. So that helped to inform our revised tax cuts so that more women received more of those tax cuts and 90% of women being better off. It's informed the decisions we've taken around PPL, to extend PPL and then also to add superannuation to PPL. In terms of the work we've done around early childhood educators and aged care workers, a highly feminised industry where 90% on average are women in that sector, that has informed the decisions we've taken to support pay rise. Publishing employer gender pay gaps, the list is too long.
Senator Stewart, second supplementary.
Thank you. It is inspiring to hear about the progress the Albanese Labor government has made on gender equality in just 2 years and what is possible when you make it a priority. As the first majority women government in Australian political history, it is clear that having women in Parliament drives policy change. How important has it been to increase the number of women in Parliament and around the decision-making tables of government?
Minister Gallagher.
Thank you very much, President. I thank Senator Stewart for that question too, because it is important, having served in a government where I was the only member in the Cabinet, to serving in a Cabinet now with record level numbers of women and serving in a caucus where more women than men are members of that caucus for the first time in Australian political history. I'm very proud, and it does make a difference. 30 years ago, the Labor Party set affirmative action targets, and we're now the government that has 52% women, but 100% supported to making women's lives better and pursuing gender equality. And look over this side and then look over that side. And I've got a message for the Liberal Party, the coalition. You know your big problem? You know your big problem as you drive gender equality is you keep pre-selecting men. That's the problem. It's really easy. You've just got to stop pre-selecting as many men and pre-select a few more women. And then you might get more women in your
thank
caucus.
You, Minister. The time for answering has expired. Senator David Pocock.
Thank you, President. My question is to the Minister representing the Minister for Science and Research, Senator Farrell. Australia's R&D expenditure is just 1.68% of GDP, well below the OECD average of 2.72% and well below the government's own target of 3%. Federal government spending on R&D is the lowest on record, sitting at just 0.17% of GDP, with business expenditure falling to 0.9%. In the federal budget, the government said it will commission a strategic examination of Australia's R&D system, noting that this was almost 4 months ago now. Can the Minister please provide an update on when this review will commence and when the terms of reference will be released?
Thank you, Senator Pocock. Minister Farrell.
President, and can I thank Senator Pocock for his question on what is a very important issue for this government. You did mention the figure of 1.68%, which was the figure that occurred during the time of the last government, the Liberal coalition government. Of course, the time when this research peaked, of course, was when it was at 2.25%, and that was when the Labor Party was in government. So the Labor Party has a strong record in this area, and of course, as a government, we want a vibrant, growing research and development ecosystem that is going to be particularly significant, Senator Pocock, for the government's program of Future Made in Australia. As you say, we have commissioned a strategic examination of the research and development in Australia. The review will look at the system-wide transformations that can turn our homegrown research and innovation into long-term prosperity and growth, and it will be supported by a panel of eminent experts to guide the government's thinking on research and development. The government has announced, as you said, its intention to undertake an examination of the research and development in Australia in May of this year. I understand that Minister Husick is currently consulting across government, and that will obviously include you, and will have more to say in coming weeks. This examination will be comprehensive and consider what Australia can learn from other countries in this area.
The time for answering has expired. Senator Pocock, first supplementary.
Thanks, President. Thank you, Minister. The university's Accord devoted significant time and attention to R&D and recommended that the Australian Government commission a formal strategic cross-portfolio examination of national research funding. Is there a difference in ambition between what the Accord recommended and what the government is now looking to do with this review? Will this be a high-level whole-of-government review or just a desktop audit?
Thank you, Senator Pocock. Minister Farrell.
Thank you, President, and thank Senator Pocock for his first supplementary question. I think it should be clear from my first answer, Senator Pocock, that the Albanese government is ambitious in this area. The whole structure behind Future Made in Australia is all about developing our homegrown technologies, our homegrown ideas, so that we can transform those ideas into prosperity.
We want to work with all of those groups in our community that are interested in achieving these ambitious goals. So the short answer to your question, I think, is no. There's no differences there. We are both very ambitious, and of course we are very lucky to have a minister like Minister Rahusik in this area, who's devoted to achieving the best possible results for our
thank you, Minister.
research.
The time for answering has expired. Senator Pocock, second supplementary.
President, and thank you, Minister. Minister, grave concerns have been raised about the impact of the government's proposed cap on international students and what it will have on universities' ability to cross-subsidise more than $7.7 billion on research annually. Will the review take these concerns into consideration? Does the government have a plan to actually fund research at universities in the short term?
Thank you, Senator Pocock. Minister Farrell.
Well, there's an old saying, Senator Pocock, you don't buy a dog and bark yourself.
You heard that one before?
Hey? Hey?
Order.
You don't buy a dog and bark yourself.
It's a very old one.
From
Order across the chamber.
from
Senator Scarr.
welcome back, Senator Mackenzie. So we've set up, as your first question made clear, Senator Pocock, we've set up a review. It's going to be full of eminent citizens in this country.
Senator Ruston.
I don't think there's a link between what we're going to be doing in the research space and what we've been required to do in terms of capping the number of overseas students. I don't think there's a link between...
Thank you, Minister. The time for answering has expired. Just before I come to you, Senator Van, I'll welcome our guests. So I draw to the attention of honourable senators the presence in the gallery of a delegation from Malaysia as part of the Canberra Fellowship Program. On behalf of all senators, I wish you a warm welcome to Australia and in particular to the Senate. Senator Van.
Thank you, President. And my question is to the Minister representing the Minister for Defence, Senator Wong. Minister, the 2023 Defence Strategic Review, the National Defence Strategy, the Defence Industry Development Strategy, all were at pains to point out that Australia needs the capability to build and maintain long-range strike here in Australia. Can the Minister disclose which companies have been contracted to our organisation that's doing that, GUIO?
Thank you, Senator Van. Minister Wong.
Thank you, President. And if I just on indulgence, just say to our friends from Malaysia, Selamat Datang. It's great to have you here, and we thank you for your friendship. In relation to the Guided Weapons and Explosive Ordnance Program, or GUIO as it is known, as you know, Senator, the government is very focused on making decisions to keep Australians safe and to create a future made in Australia, and an aspect of that is the delivery of a sovereign guided weapons enterprise. And we've backed this up through our actions. We will start manufacturing missiles in Australia next year. We've committed up to $21 billion over the next decade. There has been the acquisition of long-range strike weapons, and recently my colleague Senator Conroy announced the government would invest some $850 million to manufacture long-range missiles in Australia in partnership with Kongsberg, I think it's pronounced Kingsburg, but in Kongsberg Defence in Australia. The factory in Newcastle will be able to manufacture both the Joint Strike and Naval Strike missiles, and it will be the first factory outside of Norway to make these missiles.
Wong, please resume your seat. Senator Van.
Just on a point of order of relevance, I was asking for the key companies that have been contracted to provide weapons to GUIO.
Yep, and I accept that was the question at the end, but you also went to the strategic review and the need for particular weaponry and so on. So the Minister is being relevant to the question, but I'll continue to listen. Thank you, Senator Van.
I'm sorry, Senator, I thought this was directly relevant. I'm happy to try and get further information from DPMO if that assists. Mr Conroy has also announced the $142 million to acquire a Joint Strike Missile. As you know, there was the GUIO enterprise under the previous government only really produced two things, and they were two media releases. But I'm happy to provide further information. I thought that this was directly relevant to the question you were asking.
Thank you, Minister. Senator Van, first supplementary.
Thank you, Minister, and it's a shame that more wasn't or hasn't been done. I think it's safe to say, and it's covered in many media, but I can table something if required, that one of the companies that GUIO have contracted as a prime is called Raytheon Australia. Raytheon Australia, I thought you might, Senator Shoebridge. Raytheon Australia is a subsidiary of RTX, as it's now known, a US company that was fined $200 million for leaking secrets to Russia, Iran and China. Are you aware of, is the government aware of this?
Senator Van, the time for asking has expired. Minister Wong.
Thank you, President. I would say to you, Senator Van, obviously I have seen public reporting of the settlement to which you refer. I would make the point that this is a settlement between the US government and RTX. The advice I have is this is a matter for the US government, and we're not in a position to comment on the details of that settlement. What I can say to you after is the advice I have is that Defence has referred. Defence works across government and cooperates with partners, including the United States, to regulate the export and supply of goods and technology controlled on the Defence and Strategic Goods list. Defence has referred the matter to the Australian Border Force for investigation. I'm not in a position, obviously, to comment in any detail on that matter. What I can say is Australia has a stringent export control framework which is designed to prevent the irresponsible or illicit trade of military and dual-use items.
Thank you, Minister. Senator Van, second supplementary.
Thank you, President. Minister, given that one of the key primes involved with GUIO has had a huge settlement against it for leaking of security breaches, would you agree that the best way to protect our future guided weapons sovereignty is to work with and enable Australian companies to manufacture these weapons here in Australia?
Thank you, Senator Van. Minister Wong.
Well, that is, I'm asked for an opinion, President, and I probably won't proffer that, but I can make an observation, which I've made before, I think, in Senate estimates, that obviously when you're looking at defence capability, there are a number of matters which need to be considered. Obviously, capability, the value for money for taxpayers, and also assuring that a sovereign capability for Australia in those areas where that is necessary for our national security, and that is the approach the government seeks to take.
Thank you, Minister Wong. Senator Lambie.
Thank you, Madam President. My question is for the Minister representing the Prime Minister, Minister Wong. Meta, the owner of Facebook and Instagram, recently told this parliament they have over 130 employees in Australia. Their business here is, in their own words, a reseller of advertising services. But none of these employees seem to work on safety for Australian users. Apparently Meta thinks it's okay to globally outsource all that to Singapore and beyond, and we don't have laws telling them otherwise. Why is the Albanese government going to spend millions of taxpayers' money on trying to keep under-16s off social media before it legislates mandatory protections on social media companies?
Thank you, Senator Lambie. Minister Wong.
Thank you. Thank you, Senator Lambie, for the question, and I think this is a domain where government regulation and the right public policy settings do require consideration by this parliament, by parliaments, by the community, as well as by the government. And what I would say to you is I don't think that the introduction of legislation imposing age limits to protect children is in place of or should be excluded by the points that you raise. We are obviously aware of Meta's decision to walk away from commercial deals in relation to the Meta decision and announcement that it will no longer pay Australian news organisations for news content. Obviously, we all want a healthy, sustainable and diverse news media in Australia. That is important for our democracy, and it does include working out how it is that we ensure that large digital platforms utilise reasonable news information, and that these are under fair and equitable arrangements with the creators of content. We have been very clear that we think that what Meta has done is a dereliction of its responsibilities to Australian users. The government, of course, has established the Joint Select Committee on Social Media and Australian Society. That is one of the reasons, this backdrop is one of the reasons for that decision. We do believe that Australians should continue to have access to public interest journalism, including on social media, and we hope that the work that the committee does, and I'm aware of your interest in this, Senator, that together we can work out what is the best way forward on this issue.
Thank you, Minister. Senator Lambie, first supplementary.
Thank you, Madam President. About 75% of unwanted minor contact to kids, also known as grooming, on Facebook's products comes from a feature called People You May Know. Last week, Facebook told the Parliament that this feature is deliberately left on for under-18s in Australia. Has the Prime Minister directly raised the issue with Meta on this?
Thank you, Senator Lambie. Minister Wong.
Senator, I wasn't aware of that evidence until you just, from last week, until you just outlined it. I think that is grotesque, and I think all Australians would agree that we would want our children protected in whatever, from all of the ways in which the online world can cause harm, and our regulatory system does require us as parliamentarians, as legislators, as members of executive government to do more. We know that the online world does present new and emerging risks. What I would say to you is we have quadrupled the e-safety base funding to bring it to $42.5 million each year, with funding ongoing and indexed in recognition of the range of risks that online users face. And we have brought forward the independent review of the Online Safety Act, but none of that detracts from the ethical obligations and the responsibilities that these platforms have.
Thank you,
that
Minister.
They are
The
not
time for
discharging
answering has
for
expired.
Australians.
Senator Lambie, second supplementary.
Thank you. More than 14 years ago, the Australian Law Reform Commission warned of the risk to young people on social media. Since then, Big Tech has successfully lobbied to lower default privacy settings for kids in Australia from 18 down to 16. Does the government now intend to correct that error of judgment?
Thank you, Senator Lambie. Minister Wong.
Thank you, President. Again, Senator Lambie, what I would say to you is whether it's through the work of the committee, the work of the independent review of the Online Safety Act, or the ongoing work of e-safety, these are matters which we do need to look at. We have a domain which has expanded more rapidly in terms of reach and usage and penetration into particular markets in our communities, well beyond the regulatory framework that was in place. I think governments are seeking to catch up, and I regret that it is disappointing that we didn't see very much on this in the last 9 years prior to our election. But we are seized of this. We are very. We understand how important it is. It is a very difficult area, and governments around the world are grappling with it. And we welcome your and the crossbenchers' interest in this area.
The time for answering has expired. Senator Green.
Thank you, President. My question is to the Minister representing the Minister for Resources, Senator Farrell. I refer to the Albanese Labor government's commitment to growing Australia's critical minerals industry to deliver secure, well-paid jobs and a future made in Australia. How will the production tax incentive for critical minerals encourage processing onshore, add value to our resources here in Australia and build a strong, resilient economy?
Thank you, Senator Green. Minister Farrell.
Thank you, President, and thank you, Senator Green. And I know you come from that great resources state of Queensland. No, it'll stay great. Don't you worry. As this side of the chamber understands, the road to net zero is paved with Australian resources. Resources not only extracted in Australia, but processed locally to create secure jobs and open up more pathways for skills and training. And that includes critical minerals. An apt name given how critical they are to renewable technologies like solar panels and electric vehicles. Look, why don't you solve your own problems with your former leader of the opposition in South Australia, Senator? Why don't you focus on him rather than interfering with me? That's why. No, I know you're embarrassed by it. That's why the Labor Party announced the production tax incentive for critical minerals. That's very unfair. I think you should withdraw that. For tax incentives for critical minerals as part of the most significant budget for the resources sector in a generation. It's a foolproof, no-risk approach to grow our critical minerals industry, strengthen supply chains and create well-paid jobs in the regions. Modelling shows that building downstream critical minerals processing could generate $70 billion in GDP and create an additional 143 jobs by 2040.
The time for answering has expired. Senator Green, first supplementary.
Thanks, President, and thank you, Minister, for outlining how the Albanese Labor government will grow our critical minerals industry to create secure jobs and capitalise on the transition to net zero as we deliver a future made in Australia. Who is supportive of the production tax incentive and the boost it will deliver to the critical minerals projects across the country?
Thank you, Senator Green. Minister Farrell.
Thank you, President, and thank Senator Green for her first supplementary question. The Albanese Labor government's production tax incentive isn't just supported by the resources sector, it was developed in consultation with them. And it's no wonder that the WA Nationals are supportive, and that includes the Nationals candidate for Bullwinkle, Mia Davies, who has, she has welcomed downstream incentives. The leader of the WA Nationals, Shane Love, has said it is essential not just for Western Australia and not just for Australia but for the Western world to pursue production tax incentives like this. And it's not just the Nationals. Chalice Mining, who are developing a mining project in the Bullwinkle electorate, have hailed Labor's budget as providing crucial support to critical minerals.
Thank you, Minister. Senator Green, second supplementary.
Thanks, President, and thank you, Minister, for outlining why the sector supports the Albanese Labor government's production tax incentive for critical minerals to create secure jobs and encourage processing onshore. Minister, what is standing in the way of Labor's future made in Australia and our production tax credits? And what is at risk if future made in Australia isn't implemented?
Thank you, Senator Green. Minister Farrell.
Thank you, President, and thank Senator Green for her second supplementary question. You don't have to look further than those opposite to see what's standing in the way of the production tax incentive for critical minerals. The Coalition opposed it within minutes of budget night and labelled it corporate welfare for billionaires. Well, The future, that's what they did, yep. Well, the Future Made in Australia legislation has now passed the House, with 45 Liberals and Nationals speaking against the bill and refusing to support the production tax incentive. The 5 Liberal senators from Western Australia will have an opportunity to speak on this legislation, and I'm looking forward to you, Senator Brockman, and your colleagues supporting our production tax incentives.
Minister Wong.
President, I ask that further questions be placed on notice.
Are there any motions to take note of answers? Senator Colbeck.
Thank you, Deputy President. And I move that the Senate takes note of all questions from opposition senators today to government ministers. And today, Deputy President, we saw a disgraceful performance from the government, a disrespectful performance from the government towards Australia's farmers. Australia's farmers came to Canberra from all over the country today. Some made the trek across the Nullarbor from Western Australia to express their concerns about government policy, and not one government member or senator was prepared to turn up out the front and meet with or talk to Australia's farmers. It's an absolute disgrace that the government weren't prepared to front up to our farmers. But worse, Deputy President, but worse, when we ask questions in the chamber today, the government response is to diminish the presence of the farmers out the front, to undermine, to diminish the number of farmers who came to Canberra to express their concerns, who had one point to make. One point to make. Would you listen to us? Would you listen to us? So not only won't the government listen to the farmers, but then they come into this place today during question time trying to diminish their presence. It's a shameful performance. They talk about their Future Made in Australia policy. They talk about the work that they've done for farmers, Food and Grocery Code of Conduct. They promised the farmers out of the Food and Grocery Code of Conduct they get a better deal. What does that add up to for my Tasmanian farmers? For pea growers in Tasmania, a better deal from the supermarkets means a 34% cut in production. A 34% cut in production. Coles wants to mitigate its risk, and so what does it do? It decides to buy 9,000 tonnes of peas from overseas instead of getting them grown and processed in Tasmania. It's an absolute shame on those on government who talk the big talk, but when it comes to genuine action, it's the farmers who end up with the raw end of the stick. And that's exactly what happened to farmers in Tasmania, who now have a 34% reduction in their pea crop for the next summer. What happened to the better deal that they were promised from the Food and Grocery Code of Conduct? That didn't last long. It's only a few weeks since that policy was announced, and yet they're already getting dudded by the supermarkets, who decide they'd prefer to buy product from India or Vietnam or China or New Zealand than they would from Australian farmers. It's no wonder that the farmers turn up out the front of this building, thousands of them, in their trucks, to express their dissatisfaction with the way they're being treated by this government, and not one member of the Labor Party had the courtesy to go out and do the one thing they asked for them to do. Please listen to us. Come and talk to us. We can help you with your policy implementation. Not one Labor member would turn up. Not one Labor member.
So they come in here, they talk about their future Made in Australia policy. What does that mean for Australian farmers? Coles buy their product overseas. New Food and Grocery Code of Conduct, what does that mean for Australian farmers? Promising that will mean a better deal for farmers. Coles have already decided to buy a third of their pea crop this year from overseas. 26,000 tonnes of peas produced in Tasmania last year, 17,000 tonnes this coming season. What a great deal for Australian farmers. And this government come in here, not only disrespect the farmers by not turning up, then turn up in the chamber and diminish their presence. It's an absolute disgrace, and it's no wonder that Australian farmers are angry. They just want to be heard. I'm sure my colleagues will talk more about the impact on the sheep farmers in Western Australia, who formed a large chunk of those who are out there today, who are seeing their entire businesses and their entire communities destroyed. The Labor Party needs to step up and do what the farmers have asked them to do and just listen.
Senator Steele.
I rise to make my contribution to questions from those on the other side. And I just want to start with paint a picture. Let's go back a few steps, shall we, before the pandemic. And I remember sitting, and I don't make a habit of this, Mr Deputy President, but it just shows you how badly bored I was this Sunday. But I had insiders on, okay? I just want to clarify, I don't make a habit of watching that crap.
I'm disappointed in you.
Yeah, no, seriously, but it was on. And up popped former Senator Marise Payne, who I had a lot of respect for, Senator Payne, and all the years she was in here. And I remember her going on about China and the start of the pandemic. I'm going to get to agriculture, make no mistake about that, and a real pile-on attack on China. And I thought, wow, that's unlike Senator Payne, and I think she might have been the foreign minister at the time. And coming from Western Australia, where every second person and their kids and the dog have all got fluoro shirts, I thought, why are we doing what I thought was President Trump's, the sheriff in the region, carry on? Why are we taking our greatest trading partner? Because I had just returned from a delegation to China not long before that, and how buoyed the Chinese were to be doing business with Australian farmers, particularly around barley, wine, timber, it was at crayfish. And I tell you what, from that day, the damage that was done to our country through our agricultural exports that China just stopped. And it took until last year, or I should say the year before, actually 22, when the grown-ups were put back in charge of the Treasury benches. And I just say, don't forget that side over there didn't give a damn about the damage it was going to do to our agricultural exporters, particularly in those fields. But I'll also say this, in 23-24, Australia exported over 70% of its agricultural, fisheries and forestry production to no less than 169 markets globally. And I can safely say that it's the most diversified trade has ever been. And I have to say that's thanks to the grown-ups being put back in charge, the Albanese Labor government. Now, after the coalition, Mr Deputy President, through you, spent nearly a decade eroding and neglecting our relationships with other trading partners as well, and the disgraceful mismanagement, as I said, of the relationship of our biggest trading partner, we've put the runs back on the board for our farmers and our exporters. Restoration of market access for several agricultural and forestry products contributed to a record $17.4 billion in exports to China in 2023 alone. I can also say we recorded 88 technical market access achievements in the year 2023 to 24, including opening 10 new markets and 44 improvements to existing access. There were 34 actions to maintain or restore markets, which protected markets worth no less than $4.6 billion. And for the live cattle export industry, This government insured over $700 million of Australian animal products, 700 million, can continue to be traded in the event of a lumpy skin disease incursion through ongoing emergency animal diseases preparedness work. Think about that. Remember not long coming into government and Minister Watt, when we had the fear of FMD in Indonesia, and the prompt response that this government did, and I applaud Minister Watt, as I know the industry did at the time, absolutely. Talking to industry, listening to industry, implementing the systems recommended by industry. And no, they didn't. Thank you. You're right, Senator Ciccone. They didn't. And in fact, they took every opportunity to run scare campaigns, how our meat industry was going to be, our red meat cattle industry was going to be decimated. So we've also seen the entry into force of our free trade agreements with the UK and India under this government. And well done, Senator Farrell, and Minister Farrell, I should say, as well as ongoing negotiations with the UAE and the EU. We've also invested no less than $1.03 billion long-term sustainable funding to strengthen Australia's biosecurity system, including nearly $7 million into ensuring Australia is ready for any detection of the latest strain of avian flu.
So, we have a whipping list, Senator Lambie, but are you seeking the call? Senator Brockman.
Thank you, Mr Deputy President. Well, Senator Sterle tried valiantly there to defend this government's record, but of course, what he ignored completely, don't even think it got a mention, Senator Sterle, through you, Mr Deputy President, was the elephant in the room, particularly from Western Australia, which is the live export trade in sheep. And that has broken the relationship between the Labor government and the agricultural industry in a way that I have seen no issue before. And that is because the justification for this policy is threadbare. It's about preferences from radical activists, radical animal activist parties in inner city seats in the eastern states in return for an entire industry out of my home state of Western Australia. And last year I rose in this place and asked questions about the devastation of confidence that had flown through the West Australian agricultural sector on the back of the Labor government's decision to ban live exports. And those opposites just laughed it off, you know. But now we see it in practice, we see it in the government's own numbers, that the herd has declined, the flock has declined in Western Australia by anywhere up to 50%. Yes, there was a drought involved. Yes, there was a restocking into the eastern states. But the fact is, the lack of confidence, the banning of the live export trade, combined with that reduction in flock numbers, will mean that Labor's promise, and you've got to remember that Labor promised to see this live export industry replaced by chilled meat exports. It's not going to happen. There aren't going to be the sheep in WA because you have destroyed the industry. You have destroyed confidence in the industry. You have destroyed the size of the industry. Sheep numbers have declined by anywhere up to 50% in 2 years. Lamb numbers are going to be down this season by 35% on current estimates in Western Australia. The question is not now about opening new processing facilities in WA. The question is now as to when the next processing facility will close down in WA, because this Labor government's policy decision has completely undermined, destroyed confidence, destroyed scale, and the people that suffer aren't just the farmers, it's the communities, it's the truckies, it's the shearers. I mean, the Labor Party, the party that was formed by striking pastoral workers and shearers in Queensland, has now turned their back on that industry, turned their back on that industry. There will be no wool industry in Western Australia as the self-replacing merino flock loses one of its key economic drivers, which is the export of the wethers from that production system. They won't come back. They won't come back unless they have a light at the end of the tunnel. And that light at the end of the tunnel is when we go to the polls this year, maybe, probably next year, that we see a Peter Dutton-led Liberal coalition government who restores the trade, backs in our export partners overseas. Those who are purchasing our sheep, who have invested in their systems, who have invested in animal welfare, who have invested in taking their standards up to ours, raising their animal welfare standards up to Australian standards in order to participate in this trade. That is the light at the end of the tunnel. That is the hope for the sheep industry in my home state of WA. That is why we had truckies, we had shearers, we had farmers travel to Canberra from WA, some of whom left 3 or 4 days ago.
Thank you, Senator Brockman. Senator Grogan.
It's been fascinating listening to Senator Brockman and his obvious complete and utter lack of understanding of what's going on here. But I'll come to that. Let me first say that farmers are the backbone of our agricultural industry, and we do listen and engage with the industry. And the fanciful commentary saying that no one invited went to meet with the farmers, I had a quick poll around this side of the chamber. No one was invited. Oh, when did we see that happen before? That might have been the last time that Senator Mackenzie rallied a bunch of farmers here and told them that invitations had been provided to various ministers. I also checked with those ministers and the invitations hadn't been provided. So it's making stuff up like this is just so ridiculous. You're so desperate, so desperate. And let me just give you a little fact for those opposite, because they don't really like facts these days. They seem to have departed from that somewhat. In 2014-15, 2.1 million sheep were exported, right? And who was in government then? Oh, I think that was you lot. And then in 2021-22, that number had dropped to 450,000 sheep exported. Now that seems like quite a significant drop under the time frame of those opposite, of the Liberal National Government. Yet Senator Brockman stands there quite cheerfully and blames all the reduction in those exports on us. So, when the Libs and the Nats stand up and say that this is all shock, horror and amazement, let's just be clear. There's no surprises here. The Labor Party went to the last 2 elections committing to phase out live sheep exports by sea. We didn't hide it. We were very clear, very honest about what we were going to do. And when we got into government, that's exactly what we did. So I would also refer to Senator Brockman's entertaining comments that ending live sheep export would lead to the closure of sheep processing. Well, where to start? Live sheep are, well, not to put too fine a point on it, but they're live, right? So they're not going to the abattoirs. They're not going through the processing. And live sheep that are not exported stay here and, well, hey, can be processed, right? So, yeah, let's keep the sheep. Let's keep them in Australia. Let's process them here. Let's process them here for our market, or we can process them here and export them, because Senator Brockman seems to have misunderstood the whole idea of a live sheep export. It's not a sheep export ban, it is a live sheep export ban. So, I would also draw the Senator's attention, in fact the whole Chamber's attention, to the fact that there are 2 WA abattoirs that I know of and processors that are expanding their operations. The increasing sheep supply, what they're seeing is as the move is happening, there is more processing. As the move for not exporting live sheep by sea, they are seeing more sheep to process. So they are ramping up their businesses. They are investing in their businesses to process those sheep. In fact, one of them is adding an entire extra shift and 200 new jobs. 200 new jobs. And the other one has invested $50 million in a cold storage as part of its expansion because they see the industry growing. They see greater opportunities for them to take those sheep that are no longer going to be exported and to process them here. But let's be clear, there's $107 million on the table and 4 years to make the transition. Looks like those abattoirs in Senator Brockman's home state of WA are doing it pretty well. They are looking at the opportunities here and they are making the most of them. So I would suggest that those opposite stop trying to politicise this issue, stop using the farmers for your own political point scoring, and get on board with supporting them. And that transition in the industry is going to make a difference. There's going to be more jobs in WA and there's going to be more opportunities.
Senator Davey.
Thank you very much. And, you know, I could spend my whole time just rebutting one senator's contribution, but I actually want to rebut the whole way Labor treated this issue during question time today. This government has today cemented their anti-farming agenda. I mean, after the PM's performance at the Minerals Council last night, where he walked into a room full of miners and talked about how good transitioning battery power would be, you can tell this government doesn't listen to the industries that keep this country going. In reply to my first question about their anti-ag policies, about the biosecurity tax, ute tax, truckies tax, we got platitudes about how Labor care for all Australians. Well, if they care for all Australians, how about the Australians who are paying more than 12% more on their grocery bills? And they're also paying more on all of the input costs that contribute to those grocery bills. That's gas up 33%. That's electricity up 14%. Insurance up 17%. So not only are they contributing to higher grocery bills, but every single Australian are facing those higher costs at home as well. And then, when I asked why they're focusing on water buybacks rather than addressing the real environmental degradation such as carp, I was instructed to rephrase because water isn't in agriculture. I mean, seriously? Seriously? We all know that agriculture is highly dependent on water, be it through irrigation or through rainfall and climate conditions. But I rephrased. I asked why they continue to take water out of irrigated agriculture, harming our irrigation communities, because this government continues to ignore even research from the likes of the University of Adelaide, who just recently reported that negative whole-of-icon site scores for the Coorong and the Lower Lakes were not only lower this year than in January-February 2022, but also at their lowest recorded health since the end of the Millennium Drought and the commencement of the Basin Plan. Think about that. This government ignores the fact that irrigated agriculture is now extracting less than a third of the flows in the Murray-Darling Basin, less than the scientists decreed would be sustainable diversion limits. But this government still goes out with a chequebook to rip water out of productive agricultural use. And the minister today didn't even try to address the issues of Tasmanian pea farmers or fruit growers around Shepparton who've had all their contracts cut because the big supermarkets find that it's cheaper to import than to buy Australian grown. So while Senator Scarr stands up and talks about our great agricultural export statistics, they've got to realise that our agricultural exports are growing in spite of this government, not because of this government. Senator Scarr had the hide to discuss forestry exports. Forestry exports coming from a Labor government when Labor is closing native forestry across Australia. In Victoria, they've shut native forestry. In Western Australia, they've shut native forestry. This government has to stop ignoring the facts that their policies are leading to a decline in Australian agricultural capacity to produce. The Murray-Darling Basin Plan is seeing a decline in dairy and other irrigated commodities, and it continues on and on.
Thank you, Senator Davey. I put the question. Those questions say aye, against, no. The ayes have it. Senator Lambie.
The Prime Minister announced today that a re-elected Albanese government would ban the under-16s from using social media. Sounds great, yeah? And I'm all for sending a message that kids are damaged by excessive social media use. But my worry is that kids will be able to get around these bans, and there is a heap the government could be doing right now to rein the tech giants in, but they just don't have the courage to do so. And the headline looks good, right? Yeah? I reckon it's just a smokescreen for their lack of action on gambling reform. Suck that one up today. And like I said, there is a lot the government could be doing now to let tech giants know that the government is serious about protecting Australian kids and adults from social media harm. At the Joint Select Committee on Social Media in Australian Society, Meta said their products do not harm children. They should have an acting award. I wasn't in the room, but apparently they did this with straight faces. You've got to be kidding, yeah? Australia does have a regulatory framework for online safety, but the Act was written in a world where just removing the content would fix the problem. That's important, but it doesn't address the use of algorithms and the way big tech giants design them to pull our kids and keep them in there. Company documents from Meta, cited in a US case, describe several Meta officials acknowledging the company designed its products to exploit young minds, including a May 2020 internal presentation called Teen Fundamentals, which highlighted certain vulnerabilities of the young brain that could be exploited by product development. The presentation discussed teen brains' relative immaturity and teenagers' tendency to be driven by emotion and intrigue of novelty and reward, and asked how these characteristics could manifest in product usage. In that case and others, Meta said they would rather parents and app stores do the policing. They passed the buck and you've allowed them to get away with it. You've got to be kidding me. You want the parents to do this with the kids when it's not even their product. You should be ashamed of yourselves today. Honestly, it just keeps getting worse. One Facebook safety executive even suggested that cracking down on younger users and what they might be exposed to might hurt the company's business. How about that? Right out there. And in 2021, Frances Horgan, a former Facebook product manager, blew the whistle, telling the US senators that Facebook's products do harm children and that they do stoke division and that Facebook could do something about it if they wanted to. And I quote, "These problems are solvable. A safer, free speech, respecting, more enjoyable social media is possible. Facebook can change, but is clearly not going to do so on its own," end quote. During her testimony, Ms Horgan particularly blamed Facebook's algorithm and platform design decisions for many of its issues. Earlier this year at the National Press Club, Ms Horgan warned bumper sticker solutions like banning children under 16 from social media could jeopardise an historic chance of meaningful change. In other words, it's just a lazy way of trying to get around it. In the case of bans, you're almost saying the problem with these platforms is the children. They're not the platforms themselves. It's the platforms that are the problem, not our children. And until you start holding them responsible and doing something to those platforms, nothing's ever going to change. Okay, nothing's going to change. This is becoming a joke, your government over there, and I've had enough of it. The government should take a look at what Europe is doing. Have a damn good look at what it's doing. They have Digital Services Act. They regulate the algorithms. That's the one, regulating the algorithms. What's stopping you? What's stopping you? Even if our government had the spine to look to serious regulation like Europe's, it won't solve all the problems. We need to teach our kids to be digitally literate. In Finland, they teach kids from primary school age critical thinking skills. That's right, they're called critical thinking skills. This is so they know what they're looking at, so they know how to check what is true and what isn't. We could also be teaching emotional intelligence when our kids are at primary school, but you don't want to invest in that either. You just want to continue to do what previous governments does and keep putting band-aid fixes on these. This is why you never get the solutions that you want. That's why you've got kids out there on the streets out of control. All right? This is your fault. This is your government. This is your responsibility, and you are failing our children of the future. You are failing them because you don't have the courage to stand up to them tech giants. You are going to be the people responsible for the failure of the future. It is going to be your government because of your lack of courage. What is new in this place? Because you want to put a band-aid here and a band-aid here instead of stinging Queen Bee where it needs to be stung. Stinging it where it needs to be stung. Right at Meta. This is Meta's responsibility and you're not holding them accountable. What's new? What's new? Not holding people accountable and not holding them accountable for what they're doing and destroying our kids' lives in Australia. You should be ashamed of yourselves today.
Senator Lambie, I understand that you probably intended to move to take note of the answer to your question. So I'm going to put, you did? So I'll put that question. Those are the questions. Say aye, against no, the ayes have it.
Okay, are there any notices of motion to be given for another day? Senator Chisholm.
I give notice that on the next sitting day I shall move that the provisions of paragraphs 5 to 8 of Standing Order 111 not apply to the following bills, allowing them to be considered during this period of sittings: Better and Fairer Schools Information Management Bill 2024, National Health Amendment Technical Changes to Average Pricing Disclosure Threshold and Other Matters Bill 2024. I also table statements of reasons justifying the need for the bills to be considered during these sittings and seek leave to have the statements incorporated in Hansard.
Is leave granted? Leave is granted. Thank you, Senator Chisholm. Senator Rennick, I believe you're seeking the call.
Yeah, thanks, Madam President. I seek leave to make a short statement about my new status as an independent senator.
Is leave granted? Leave is granted for 1 minute, Senator Rennick.
I inform the Senate that I have resigned from the Queensland Liberal National Party and now sit as an independent senator for Queensland.
Oh, thank you, Senator Rennick. Senator Rennick.
Just also inform the Senate that I should be designated as a whip for the purposes of Standing Order 24A relating to the selection of Bills Committee.
Thank you, Senator Rennick. That has been noted. I shall now proceed to the placing of business. Is it desired to postpone or rearrange the business? I call the clerk.
Thank you, President. Postponement notifications have been lodged as follows. Business of the Senate notice of motion number 4 for today postponed to the 11th of September 2024. Business of the Senate notice of motion number 3 for today postponed to the 16th of September 2024. And general business notice of motion number 599 for today postponed to the 16th of September 2024.
Thank you, Clerk. Sorry. Okay, so we've done with placing or rearranging. No one else seeking the call. I'll now proceed to formal business, and I'm going to start with general business notice of motion number 5 594, standing in the name of Senator Cash. Is that you, Senator Askew? No, I'm just trying to deal with the less contentious ones first.
Cash, I ask that general business notice of motion number 594 be taken as a formal motion.
Is there any objection to this motion being taken as formal? There being none, I call Senator Askew.
I move the motion.
So the question is that general business notice of motion number 594, standing in the name of Senator Cash and moved by Senator Askew, be agreed to. Those of that opinion say aye. Against? I believe the ayes have it. Is anyone moving 595, standing in the name of Senator Roberts? No, I'll move on. I'll now go to general business notice of motion number 596, standing in the name of Senator Kovacic. Senator Askew.
On behalf of Senator Kovacic, I ask that general business notice of motion number 596 be taken as a formal motion.
Is there any objection to this motion being taken as formal? There being none, I call Senator Askew.
I move the motion.
So the question is that general business notice of motion 596, standing in the name of Senator Kovacic and moved by Senator Askew, be agreed to. Those of that opinion say aye. Against? I believe the ayes have it. I'll now deal with general business notice of motion number 597, standing in the name of Senator Smith, Senator Dean Smith.
Thank you, President. I ask that general business notice of motion number 597 be taken as a formal motion.
Is there any objection to this motion being taken as formal? There being none, I call Senator Smith.
I move the motion.
So the question is that general business notice of motion number 597, standing in the name of Senator Dean Smith, be agreed to. Those of that opinion say aye. Against? I believe the ayes have it. I'll now deal with general business notice of motion number 598, standing in the name of Senator Whish-Wilson. Is that you, Senator McKim?
It is, President. Thank you. I ask that general business notice motion number 598, standing in the name of Senator Whish-Wilson, that it be taken as a formal motion.
Is there any objection to this motion being taken as formal? There being none, I'll call Senator McKim.
Thank you, President. I move the motion.
So the question is that general business notice of motion number 598, standing in the name of Senator Whish-Wilson, be agreed to. Those of that opinion say aye. Against? I believe the ayes have it. I'll now move to general business notice of motion number 601, standing in the name of Senator Duniam. Senator Duniam.
President, I would ask that general business notice of motion number 601 be taken as a formal motion.
Is there any objection to this motion being taken as formal? There being none, I call Senator Duniam.
I move the motion.
So the question is that general business notice of motion number 601, standing in the name of Senator Duniam, be agreed to. Those of that opinion say aye. Against? I believe the ayes have it. Division required. Ring the bells for 4 minutes. lock the doors. So the question is that general business notice of motion number 601, standing in the name of Senator Duniam, be agreed to. The ayes shall move to the right of the chair, noes to the left. I appoint Senator Urquhart as teller for the ayes and Senator McKim as teller for the noes. Order. There being 29 ayes and 11 noes, the matter is resolved in the affirmative. Senator Roberts, I'll now deal with your matter, and I advise senators there may be further divisions. So I'm going to general business notice of motion number 595. Senator Roberts.
Thank you, President. I ask that general business notice of motion number 595 be taken as a formal motion.
Is there any objection to this motion being taken as formal? There being none, I call Senator Roberts.
I move the motion.
So the question is that general business notice of motion number 595, standing in the name of Senator Roberts, be agreed to. Those of that opinion say aye. Against? I believe the ayes have it. I'll now deal with general business notice of motion number 602, standing in the name of Senator Duniam. Senator Duniam.
Thank you, President. I ask that general business notice of motion number 602 be taken as formal.
Is there any objection to this motion being taken as formal? There being none, I call Senator Duniam.
I move the motion.
So the question is that general business notice of motion number 602, standing in the name of Senator Duniam, be agreed to. Those of that opinion say aye. Against? I believe the ayes have it. I'll now deal with general business notice of motion number 603. You've been busy, Senator Duniam.
President, I ask that general business notice of motion number 603 be taken as formal.
Is there any objection to this motion being taken as formal? There being none, I call Senator Duniam.
I move the motion.
So the question is that general business notice of motion number 603, standing in the name of Senator Duniam, be agreed to. Those of that opinion say aye. Against? I believe the ayes have it. I'll now deal with general business notice of motion number 587, standing in the name of Senator Little and other senators. Senator Little.
Thank you, President. I ask that general business notice of motion number 587 be taken as a formal motion.
Is there any objection to this motion being taken as formal? There being none, I call Senator Little.
I move the motion.
Senator Pocock.
Amendment to the motion is circulated in the chamber.
Is leave granted? Leave is granted. Senator Pocock.
Thanks, President. I move the amendment.
Senator Chisholm.
To make a short statement.
Is leave granted? Leave is granted for 1 minute. Thank you, Senator Chisholm.
We do not support this motion. We don't need another standing committee with another review. We need to make sure existing reviews are completed and implemented. The motion isn't about good governance, it's about politics. Various other similar reviews are underway or being implemented. These should run their course. For example, the Australian Law Reform Commission is already reviewing native title. The review will report in December 2025, similar to the proposed motion. The same witnesses would be encouraged to appear at both inquiries. This is part of the government's additional $20.8 million contribution over 4 years to improve the native title system, of which the ALRC review is the first part. A brand new standing committee launching a whole new review would be at best duplicative and wasteful, at worst it would be destructive and harmful. Small First Nations groups do not have the resourcing to respond to multiple inquiries on the same topic. First Nations community already experience consultation fatigue. This wasteful duplication would be confusing and distressing for First Nations communities.
Chisholm. So I intend to put Senator David Pocock's amendment to general business notice of motion number 587. So the question is, those who support Senator Pocock's amendment say aye. Against? I believe the noes have it. division required. Ring the bells for 4 minutes. Lock the doors. So the question is that the amendment moved by Senator David Pocock on general business notice of motion number 587 be agreed to. The ayes shall move to the right of the chair, the noes to the left. I appoint Senator Askew as teller for the ayes and Senator Urquhart as teller for the noes. Order. There being 32 ayes and 32 noes, the amendment is negated. I will now put the substantive motion. So the question is that general business notice of motion number 587, standing in the name standing in the name of Senator Little and others be agreed to. Those of that opinion say aye. Against? I believe the ayes have it. Division required. Ring the bells for 1 minute. Lock the doors. So the question is that general business notice of motion number 587, standing in the name of Senator Little and others, be agreed to. The ayes shall move to the right of the chair, the noes to the left. I appoint Senator Askew as teller for the ayes and Senator Urquhart as teller for the noes. Order. There being 31 ayes and 33 noes, the matter is resolved in the negative. I'll now go to general business notice of motion number 593, standing in the name of Senator Chandler. Order. Order. Senator Chandler.
Thank you, President. I ask that general business notice of motion number 593 be taken as a formal motion.
Is there any objection to this motion being taken as formal? There being none, I call Senator Chandler.
I move the motion.
Senator Chisholm.
I seek leave to move an amendment to the motion.
Is leave granted? Leave is granted. Senator Chisholm.
I move the following amendment: omit midday on 11 September 2024, substitute 10 a.m. 16th September 2024.
Thank you. So the question is the amendment as moved by Senator Chisholm to general business notice of motion number 593, standing in the name of Senator Chandler, be agreed to. Those of that opinion say aye. Against? I believe the ayes have it. I'll now move the amended motion. So the question is that general business notice of motion number 593, standing in the name of Senator Chandler and amended by Senator Chisholm, be agreed to. Those of that opinion say aye. Against? I believe the ayes have it. I'll now move to general business notice of motion number 600, standing in the name of Senator Bragg. Is that you, Senator Askew? Yes.
On behalf of Senator Bragg, I ask that general business notice of motion number 600 be taken as a formal motion.
Is there any objection to this motion being taken as formal? There being none, I'll call Senator Askew.
I move the motion.
So the question, Senator Chisholm.
Leave to make a short statement.
Is leave granted? Leave is granted for 1 minute. Senator Chisholm.
The government has a $32 billion plan to build 1.2 million new homes by 2029. Those opposite are only interested in playing political games and getting in the way of genuine action. When an FOI request is received as required under the legislation, consultation occurs with the party involved, as the government did in the instance with Cbus. Cbus objected to the release of documents that considered to be business information and available exemption under FOI Act. Consistent with this, the government made a claim of public interest immunity in response to the Senate order for production of the same documents. This was done in good faith to protect business information and to ensure we can continue to undertake robust and frank stakeholder consultations which are ultimately in the public interest. We want to continue to have frank and candid consultation processes in the future, and that's why we comply with the legislation when it comes to FOIs. We've released the relevant documents on 5 September 2024 in line with the Information Commissioner's decision in the usual way.
Thank you, Senator Chisholm. So the question is that general business notice of motion 600 standing in the name of Senator Bragg be agreed to. Those of that opinion say aye. Against? I believe the ayes have it. Division required. Ring the bells for 4 minutes. Lock the doors. So the question is that general business notice of motion number 600, standing in the name of Senator Bragg, be agreed to. The ayes shall move to the right of the chair, the noes to the left. I appoint Senator Askew as teller for the ayes and Senator Urquhart as teller for the noes. Order. There being 42 ayes and 18 noes, the matter is resolved in the affirmative. That concludes formal business, and I will now deal with the two deferred votes from yesterday. But I think Senator Smith is seeking the call. Senator Smith.
Thank you, President. I ask that Senate business number 1 in my name be taken as formal.
Okay, I understood that was being debated later, but yes. So is the motion, no one's disagreeing that be taken as formal? Thank you.
I move the motion.
So the question is Senator Chisholm.
Seek leave to make a short statement.
Is leave granted? Leave is granted for 1 minute. Senator Chisholm.
The government would like to thank the tax industry bodies for their constructive engagement with us on this matter. The government is committed to industry bodies to make further changes to the tax determination, on which we intend to publicly consult and finalise by early October. This includes aligning the obligations within Section 15 of the Instrument of the Accounting Professionals and Ethical Standards Board Code of Ethics. This voluntary code currently only applies to some tax agents. The change will expand it to all tax agents in a consistent way. The government is also committed to reduce the number of items in the disclosure obligations to Section 45 to remove duplicative items that are already covered in other areas of the law. Industry bodies have indicated support for these changes. I seek the opposition's commitment to delay this motion to provide industry time to consider these amendments as part of public consultation. Absent that commitment, the government will be opposing this disallowance motion.
So the question is that business of the Senate, Senator David Pocock.
Go 1 minute statement.
Is leave granted? Leave is granted for leave is granted. Senator Pocock sought leave to make a short statement, and he was given leave for 1 minute. Senator David Pocock.
Thanks, President. I thank Senator Smith for lodging this disallowance, and I share the concerns industry reps have raised around the poor process and consultation. However, I also recognise that there has been good faith engagement recently from government, and they've come to an agreement with industry bodies to work through the remaining outstanding issues. And I believe that the government should have the opportunity to deliver on this. Should they not, I'd be very happy to support a disallowance, but at this stage I won't be.
Thank you, Senator Pocock. Senator Dean Smith.
To make a short statement.
Leave is not granted. Senator Dean Smith. Senator Barbara Pocock.
Leave to make a short statement.
Is leave granted? 1 minute, Senator Pocock.
Thank you. Thank you. I wish to put on notice the pressing need for action to hold tax agents to account in light of all of the evidence this chamber has heard in relation to PwC and the need to act. We've had a lot of outrage in this chamber about what we have seen and what our nation has seen in corrupt behaviour, and what we need is action into the future and not deferral. We need timely action which allows us to hold tax agents who behave improperly, the small proportion who behave improperly, to account, and that's the action where I look forward to seeing this Senate realise before long.
So the question is that business of the Senate. Senator Dean Smith.
Second time to get leave to make a statement.
Leave is not granted. Senator Dean Smith, and I do invite senators who have pressing things to say to join the adjournment debate tonight, at which point I'm sure the whips will not welcome it, but that is the appropriate time. Well, you can always put it on your socials, Senator Smith. What a shame. I listen. So the question is that business of the Senate number 1, standing in the name of Senator Dean Smith, be agreed to. Those of that opinion say aye. Against? I believe the noes have it. Ayes have it. Division required. Ring the bells for 4 minutes. Lock the doors. So the question is, business of the Senate number 1, standing in the name of Senator Dean Smith, be agreed to. The ayes shall move to the right of the chair, the noes to the left. I appoint Senator O'Sullivan as teller for the ayes and Senator Urquhart as teller for the noes. Order. There being 31 ayes and 31 noes, the matter is negated. I do believe that now concludes formal business, and I will move to the deferred motions from yesterday. I remind senators that yesterday evening 2 votes were deferred as listed at item 12 on today's order of business. I understand it suits the convenience of the Senate to hold those votes now. I will deal first with the motion moved by Senator Duniam concerning a proposed disallowance of the Aboriginal and Torres Strait Islander Heritage Protection Kings Plains Declaration 2024. I put the question that the motion be agreed to. Those of that opinion say aye. Aye. Against? Aye. I believe the noes have it. Division required. Ring the bells for 1 minute. Lock the doors. So the question is that the motion moved by Senator Duniam be agreed to. The ayes shall move to the right of the chair, the noes to the left. I appoint Senator O'Sullivan as teller for the ayes and Senator Urquhart as teller for the noes. Order. There being 29 ayes and 31 noes, the matter is resolved in the negative. I will now deal with the deferred vote relating to a reference to the Rural and Regional Affairs and Transport References Committee proposed by Senator Kenzie and the amendment moved by Senator Cash. I put the question. Senator Mackenzie, are you seeking the court? No. I put the question that the amendment moved by Senator Cash be agreed to. Those of that opinion say aye. Aye. Against? No. Believe the ayes have it. Division required. Ring the bells for 1 minute. Lock the doors. The question is that the amendment moved by Senator Cash be agreed to. The ayes shall move to the right of the chair, the noes to the left. I appoint Senator O'Sullivan as teller for the ayes and Senator Urquhart as teller for the noes. Order. There being 30 ayes and 32 noes, the matter is resolved in the negative. Unless there are further contributions, I will now put the question on the substantive motion. So the question now is that the motion as moved by Senator Mackenzie be agreed to. Those of that opinion say aye. Aye. Against? No. I believe the noes have it. Division required. Ring the bells for 1 minute. I can take until my vote. Lock the doors. So the question is that the motion as moved by Senator Mackenzie be agreed to. The ayes shall move to the right of the chair, the noes to the left. I appoint Senator O'Sullivan as teller for the ayes and Senator Urquhart as teller for the noes. Order. There being 30 ayes and 32 noes, the matter is resolved in the negative. That concludes the deferred votes.
Okay. Senator Mackenzie has submitted a proposal under Standing Order 75 today. It is shown at item 13 of today's order of business. Is consideration of this proposal supported? All good. With the concurrence of the Senate, the clerks will now set the clock in line with the informal arrangements made by the whips. I call Senator Mackenzie.
Thank you.
To move the motion.
To move my motion?
Yep.
I move the motion that the Albanese Labor government needs to end its anti-farming agenda that is damaging Australia's competitive advantages, driving up the cost of doing business for Australian farmers, and will further increase the cost of living for all Australians. I move the motion, Mr Acting Deputy President. And I move that motion in the Australian Senate today because it is today that the Australian farming public, and I see many, many people in the chamber from Western Australia and beyond, who've had enough of a Labor Party that does not care about the future sustainability, prosperity or security for their present business or that indeed for their intergenerational operations. And we have had thousands of farmers from right across this great brown wide land here on the front steps of Parliament. And did the Prime Minister bother to come out of this ivory tower onto the front lawns and face the accusers? No. Oh, he gave the President of the NFF a bit of a shellacking, might have used some choice words that aren't very parliamentary, but the Prime Minister refused to meet the thousands of people who gathered this morning. The Minister for Agriculture, Cooey, couldn't be found either, nor did she bother to go over to Western Australia to actually face a state that is at the front line of this government's anti-farming agenda, and that is the live sheep trade out of Western Australia. A trade that is celebrated, a trade that is a key system in primary production in the West and that provides culturally appropriate protein to the Middle East. But never mind that it is world-leading in animal husbandry, that it underpins thousands of jobs in the West. This Labor government, this Prime Minister, was prepared to trade the livelihoods of these Western Australian primary producers for a few cheap seats in Melbourne, Brisbane and Sydney. Dirty deals done dirt cheap, and who pays? The Australian farming family. And it wasn't just those that support the Keep the Sheep campaign. There were irrigators from the Murray-Darling Basin who've seen this government decimate their future by removing the socio-economic test that must have been present before a government removes additional water from these farmers. And what's Tanya Plibersek done? She's just said, we're taking it anyway. We don't care about the science. We don't care about how healthy the Murray River is. We don't care about how many suicides this will cause in the Murray-Darling Basin. We're taking the water anyway. And any farmer worth their salt, any of us, 9 million Australians who don't live in capital cities, knows you remove water, you remove wealth from these communities. The cattle industry, the NTCA was in town. We know that it is sheep first and it is the cattle industry next, and I know my colleague and cattle woman herself, Senator Susie McDonald, will have more to say on that later in this debate. But this government let their mask slip when we had the Rural and Regional Women's Award in this very building a couple of weeks ago. The Prime Minister almost choked on his beautiful Australian beef. when he wanted to swallow his words instead of swallowing that fabulous product, when he let it slip that is coming for the live cattle trade next. And the NTCA were also out there. But it's not just our primary producers who are under attack by this government. It is our trucking industries and the whole supply chain that underpins them and our regional communities. Because this government doesn't care. They think we're out of sight, out of mind, and today we made our voice heard. And I was very proud, as a National Party leader in this Senate chamber, a rural and regional woman myself, to stand next to the National Party's candidate for the new seat of Bullwinkle in the West, Mia Davies, a woman who comes from primary production stock. She's been the leader of the opposition in Western Australia. She's experienced, passionate and serious about standing up for the West here in this place. And it's about time Western Australians had someone in the House of Representatives that was prepared to back them in a way that Prime Minister Albanese and his government hasn't.
Senator Chisholm.
Thanks very much, Acting Deputy President, and it's a real pleasure for me to speak and actually dispel the myths that the opposition have been purporting when it comes to this motion, and I welcome the opportunity to oppose it today. I was recently appointed the Assistant Minister for Agriculture, Fisheries and Forestry, and I've very much enjoyed the engagement I've had from industry in the month or so that I've been in that portfolio. Very welcoming and also very knowledgeable, and very happy to share their thoughts and knowledge with me, which I appreciate. I acknowledge that there is a lot to learn in this space. It is such a big portfolio area, and I am very grateful for the engagement that I've had with industry, and my door is always open and always happy to have a discussion with them about them. One of the first opportunities I had was to speak at the National Farmers Federation Leaders Summit in Canberra a number of weeks ago. And that was something that I really enjoyed and valued. And I was very clear at that, where I outlined the agenda that the government is pursuing when it comes to agriculture, fisheries and forestry, that we know that we're not going to agree on every issue, but we are committed to working and finding common ground and ensuring that we can advance the industry. And that's exactly what we have been doing since we came to government. We've delivered on our election promises, but we've also been focused on the future because we understand how important this area is to the country, but also the export potential that avails itself in this portfolio as well. And you've got to recall, and it's interesting that Senator McKenzie didn't talk about any of the record of the previous government of when they were in power and what we inherited. But that obviously has been a big focus from this government in terms of correcting what we've seen when we came to government from the previous 10 years of those opposite. And what did we actually see when we came to government? A $100 million black hole in the biosecurity budget. And there's one thing that unites the agriculture sector, it is around biosecurity and the concerns that they have. So that's something that we had to go about fixing in the budget that we have done. We saw a decade of climate denial and no support to help agriculture industry meet their own climate targets. And again, this is something that industry sees as an opportunity. They just previously didn't have a government that were committed to working with them. They have that now in this current government, and we see tremendous opportunities. We know about the damage they did to the APVMA and the dysfunctional mess that they left that in for so many years that has taken so much time to fix, that is now on the right path. And also the trade relationships that are so important in this sector that they neglected and eroded over 10 years of time. So we've actually been getting on with the job of fixing these challenges that the opposition couldn't be bothered to do or had failed to do. We're delivering for Australian farmers and producers, and we're committed to a robust, sustainable agriculture industry that continues to thrive in Australia because we understand how important it is for so many parts of this country. We've been strengthening Australia's biosecurity system, ensuring long-term sustainable funding with an investment of over $1 billion. We know that the threats will continue. That's why it is important that we have that robust biosecurity system in place that can do what we need to keep Australia free. We've delivered $11.1 million to uplift Northern Australia's ability to detect, prepare for and respond to exotic plant, animal and aquatic pests and diseases through funding the implementation of the Northern Australia Biosecurity Strategy. When it comes to workforce, We've boosted the agricultural workforce, securing fee-free TAFE and vocational education and training places for courses right across Australia. So far, we've seen over 14,000 enrolments in agriculture courses. We've also worked with industry to adjust program settings for the Pacific Australia Labour Mobility Scheme to continue the transition period for minimum hour settings until 1 July next year. The May budget included $1.9 million over 3 years to provide targeted grants for industry-led projects with benefits across the sector. We'll continue to invest in programs that support the employment and retention of our best people. And in trade, we're opening up new trade opportunities for our sector to grow and diversify overseas markets. In 23-24, Australia exported over 70% of its agriculture, fisheries and forestry production to 169 markets globally, the most diversified trade has ever been. Restoration of market access for several agricultural and forestry products contributed a record $17.4 billion in exports to China in last year alone. We've delivered over $3 billion in extra funding for agriculture since taking to office, and over $500 million to the National Reconstruction Fund. We understand how important this sector is to the economy and to Australians, and that's why we will continue to support it, despite the rhetoric of those opposite.
Senator Wilson.
Thank you, Acting Deputy President. It's always good to see farmers in Canberra. Good on those farmers who travel from around the country to exercise their right to protest and have their voices heard in this place. The Greens don't agree with everything they were here protesting on today, especially the ban on live sheep export. That's something we have supported, but we do support farmers in other areas. And I've got to say, it's good to see the Nationals today standing with farmers, because in the 13 years I've been in this place, I have watched them abandon the farming community and join forces with the coal mining industry and the resources industry. That's where their heart has been in the last decade. And let me tell you what is ironic about that, is that the biggest threat facing farmers in this country, and indeed all around the world, same for our supply chains in this country, is climate change. And the Nationals, more than anyone in this place, in the last decade, have undermined climate action. In this building, decisions we've made on acting on climate. My state of Tasmania just recently had another record flooding event last week, and my mates who have got farms lost a significant number of cattle and sheep and trees, and this is happening right around the country. Extreme weather is a function of our changing climate, which is caused by rising emissions, which is caused by primarily the burning of fossil fuel and the approval of fossil fuel projects, which this government continues to do, and the previous government championed it while they were in this place. And we look at Australia's winter, the third winter in a row where we've set records. 42 degrees only a couple of weeks ago, a new record. Temperatures across the heartland over 16 degrees Celsius above their long-term averages. We're continuing to see weather records broken everywhere. And we talk about concerns over water in the Murray-Darling Basin. We talk about biosecurity risks being presented to Tasmanian and farmers all around this country. And it's climate change. So how ironic that Senator Mackenzie comes in here today to put up a motion talking about how this government is somehow making life worse for farmers and has an agenda to put them out of business, when what is actually putting them out of business are droughts and famine and pestilence and everything that goes with what we know is climate change. So I just wanted to make it really clear today that if you're an Australian farmer, you need to be rightly concerned about the government not acting fast enough. And I'm pleased that there are thousands of farmers around this country who have joined Farmers for Climate Action and are calling in a bipartisan and tripartisan way for more action on the climate from politicians in this place. That's what I think I would like to hear farmers calling for. That's what we need.
Senator O'Sullivan.
Thank you, Acting Deputy President. I just want to commend Senator Mackenzie for bringing this motion of matter of public importance before us today, before the Senate to consider, as a matter of significant importance for this country. The need for the Albanese government to end its anti-farming agenda, which is damaging Australia's competitive advantages, driving up the cost of doing business for Australian farmers and further increasing the cost of living for all Australians. Well, I was very proud today to stand out the front of this building there with farmers that have come from all over the country, indeed quite a number of them from Western Australia, who have made an enormous effort to come over from Western Australia to be here. Some of them drove their trucks over, spent the number of days that it takes to drive across the continent in that way is something to be commended, something that should be supported. But unfortunately, we did not see anyone from those opposite, certainly not the Prime Minister, go and front up at that rally. A real shame, because as a Western Australian, I am seeing firsthand the impact that the closing down of this important trade is having on the livelihoods of families, of generations of families that have been farming in Western Australia, that have seen this trade occur, that's provided a livelihood for them and their families, and it's been decimated. We're already seeing the impact of this. Even though the ban doesn't come into place for several years' time, we're already seeing the impact on the flock in Western Australia, and it is absolutely shameful that this government is just pandering to the interests of those in the inner city areas. We saw that because to get some preference votes in the by-election in Dunkley, they traded off votes with the Animal Justice Party or whatever party it was, those activists that traded off votes just for a cynical result, a cynical transaction that ultimately has cost the lives and the livelihoods, I beg your pardon, of farmers in Western Australia. It is absolutely shameful. But you know what else is shameful? Is that during question time, we had interjections from the former Minister for Agriculture, somehow belittling the size of the crowd out there. Now, it doesn't matter whether there was just 2 people out the front, several hundred people out the front, or thousands of people out the front. What matters is that people came here today to have their voices heard. Now, there was a very large crowd. I can't count the number that were there. I wasn't there long enough to do a full head count. But there was, I don't know, maybe over 1,000 or more. Those that were there longer would know, would have done that count. But the fact that it's raised in this place, even by Senator McCarthy, who raised it and said there was only 400 people, like as if that's something to be snickered at. I mean, it just shows the attitude of those opposite. It just shows the attitude of those opposite and their disdain towards this industry, their disdain towards the producers in this country that have a proud tradition. I mean, these farmers care more about their animals than anyone else, than any activist that might want to front up to their farm would ever provide. They care deeply about it. I've been to the feedlot. I've been on the ship. I've seen the quality. I've seen the efforts that have been taken by these producers and by the exporters. And I've witnessed firsthand their care and the attention that's paid. They have done everything that the regulators, that the government has called on them to do. They've done it and more. And now to have in their face this decision by this government and by this parliament, who have turned their backs on Western Australia, is an absolute shame. Before the last election, there were placards, there were billboards put up on polling booths at schools across the country on election day saying, "Put WA first, vote Labor." Well, what a mockery those signs are. What a mockery this government is to even their own words. Because they are not standing up for WA. They are not being true to their convictions in Western Australia. They're pandering to those over here on the East Coast. Those on the East Coast that aren't considering the livelihoods, that aren't considering the proud tradition and the care that has been taken on these properties and these farms. It is absolutely shameful. And I am proud as a Western Australian to have stood on that stage in front of that audience today, those that have made the effort to be here, to have their voices heard. Well, your voices have been heard today. But unfortunately, those on this side are not listening. And the only way to remedy this is to see a coalition government return so that we can reverse this shameful legislation.
Senator Ayres.
Thanks, Acting Deputy President. Well, rallies are good things. I know I've organised a few of them in my time. They are good things. It's a good thing in our democracy to have people assemble. We have freedom of assembly in this country. On our side of the chamber, it's freedom of assembly for everyone. side of the chamber. It's freedom of assembly when it suits them. When it suits them. They don't like it, freedom of assembly, if workers get together. They don't like it. They don't like it. They send them threatening letters. They are angry by the idea of ordinary people getting together. But in this case, they're for it, and maybe it'll be a learning experience. Maybe it'll be a learning experience for them. As I say, I've organised a few rallies in my time, and I do understand that there are sharp differences of views about the government's decision in relation to live sheep exports. And I absolutely respect the right of Australians who are affected directly by this or have a view about this to put a view to government. That's why, indeed, the government's played its part here. Dozens of meetings with Western Australian farmers about these questions. There has been a compensation package that has been developed by the government. There is an ambition there to work with the agriculture sector in Western Australia to develop onshore processing options at scale. I mean, and the truth is, nobody could do more damage to the live sheep export trade than the previous coalition government did. Billions of dollars worth of lost trade as that industry fell off a cliff under their watch. Now they're there in the rally, but they did more damage to Western Australian agriculture than is contemplated in what is an orderly phase out of this sector that was brought to not one election but two elections. And this is a government that does what it says it is going to do. What I do object to are the dishonest claims that are made by the coalition about agriculture policy. The first thing they should do in terms of agricultural policy is apologise for a decade of neglect. If they were fair income about it, they would apologise for a decade of neglect. Their slogan, developed in their focus groups, like, it's interesting, keep the sheep is the slogan. At no point does it say save the live export trade. It says keep the sheep, as if, you know, we're going to take them into people's backyards and pat them on the head and keep the, like, it is the most dishonest. It is the most dishonest campaign slogan. It's developed by your team. Developed by your team is what's going on. Now let me come to these questions. Senator O'Sullivan, very upset about claims that are made about the size of the rally. You know, there's nothing wrong with a rally with a few hundred people out the front of Parliament House. There's nothing wrong with that. What is wrong with the Liberal National Party making claims, inflated claims, of thousands of people out the front, which was the immediate default? And I know, as I say, I've organised a few rallies in my time. You always make claims about tripling the number of people are there because it suits your purposes. But the problem is that it's not right. That it's not right. And those claims are made by this crowd, even though they know they're not right. No wonder they've got such trouble in fiscal policy terms. They can't count. They can't count. Now, it is a good thing that people flew or drove here from Western Australia. It is a long flight, 5.5 hours, which I do have to say is longer than Senator Mackenzie's divestiture policy in the airline industry lasted. It lasted 5.5 hours, right? That's the truth. Now, this show is such a rabble. Dishonest claims about agriculture, red-hot opinion pieces in the Australian Financial Review, which last less time than a flight from Sydney to Perth. This is another rabble making dishonest claims, leading the farming community up a cul-de-sac with claims that can't be sustained.
Senator Roberts.
Thank you. How would One Nation restore Australian farming? Explained in the 60 seconds the Nationals have allocated me. Easy. End net zero madness. Net zero is a policy of the Liberals, the Nationals, the Labor Party, the Greens, the Teals. each committed to destroying farming through a death of 1,000 regulatory cuts, strangling farmers with restrictions on water use and on farm chemicals and fertilisers, and even their soil. Strangling the life out of rural Australia in the name of reducing carbon dioxide, which fertilises the very food these net zero ideologues eat. Net zero really means net zero food, net zero clothes, net zero freedom, net zero travel. We've been told by the UN and the World Economic Forum food will be produced in near-urban intensive food manufacturing facilities, producing cultured laboratory meat, forced greens with no cell structure and bug protein. Allow Australian farmers to once again feed and clothe the world. It's time to end government by ideology.
Senator Babet.
Thank you. I stand with our farmers. Farmers are the backbone of our nation. If farmers don't farm, citizens don't eat. That's why the war being waged on farmers by our government must end. Enough with ordering them to reduce emissions. Enough with telling them what they can and cannot export and how. Enough with covering prime agricultural land in panels, poles, wires and turbines. It's madness. If you want to eat bugs, then you know what? Keep going, like Klaus Schwab from the World Economic Forum wants you to do. If you like real food, though, and you value a healthy life, support the farmers. Who would you rather trust? A family, a hard-working farming family, farming the land, producing food for our dinner plates, or inner-city, soy latte-sipping, woke activists who worry that cow farts are causing sea levels to rise as they preen their man buns?
Senator McDonald.
Thank you, Acting Deputy President. Well, hard to beat that final line. I want to thank Senator Mackenzie for bringing this matter on and having a debate, even in this short time in the Senate, because this goes to far more than what happens at Parliament, what happens in Canberra. This is the men and women right across Australia who have incredible challenges. And the part that really worries me about Labor is how few of them understand how hard it is to farm. They don't understand that you are battling international commodity prices, you're battling a duopoly of supermarket buyers, you're battling variable seasons, skyrocketing costs of production, a shortage of workforce, and at the same time your own government, who is putting more and more restrictions onto how you operate. They are spending more time in the office and less time on the farm because they grow food. I'm not sure if you're aware, but 99% of the population, most of us, rely on 1% of the population to grow our food and fibre. 1% of our population who is saying, we have had enough. Their children are saying, this is not a career that I want to choose anymore because of what Labor is doing. Now, I have got a long list of issues of what Labor has done just in the last 2.5 years. You really can't believe it when you look at it. The introduction of the Climate Change Authority and their out-of-control direction that is not being pulled into line by Labor. They say, oh, it's an independent agency. The Global Methane Pledge, water buybacks. They removed all of the funding for Northern Australia water projects, took that money and bought water out of the Murray-Darling. Less food opportunity in the north, less food opportunity in the south. They're bringing in Scope 3 emissions reporting from the 1st of January next year. Superannuation changes, forcing farmers to pay for unrealised gains on their properties in super funds. They've removed gillnet fishing in far north Queensland. I've already talked about water buybacks. They're refusing to settle the live export dispute. These very same ministers, cabinet ministers, who shut down the cattle live export industry are now at the table shutting down the live sheep export out of Western Australia, which also includes cattle, by the way. Nobody talks about that part, but there are also cattle affected in that. Salmon farming in Tasmania. This is an industry that is kind of bowing under pressure and is about to break. We should care. We should care that our farmers are labouring under the costs of labour. We should care that their ability to grow food and fibre is being restricted. We should care that policies that have been run by the Greens in inner city places with this fanciful idea that we can have greenhouses and manufactured food will feed billions of people around the world. We should care about that and say enough. Because what the NFF has done is led a group of farmers from across Australia who've said, please, let us do what we do best. Let us manage our land. Let us farm. Let us grow food for you. Let us not be restricted by the EU's restrictions on deforestation, policies that do not apply in the Australian context. Please stop the World Heritage listings of our important food manufacturing places. Please let us make our own decisions and not be driven by overseas government and regulations. This is the sort of things that farmers talk to me about when they are complaining about how hard it is to be compliant, to grow food and fibre, and all of the things that we don't have to consider. In fact, our biggest problem is eating too much, but we never ever stop to think about how hard it is to grow it. So this government needs to urgently stop and understand the cumulative effects of so many separate and disparate decisions that are just breaking the will of farmers and ensuring that young people are saying it is too hard. I do just want to finish on one point though. The bit that keeps the people in my part of the world, Northern Australia, awake is when they see a dirty deal done with the Greens in a Victorian by-election to shut down their industry. They know that a minority Labor government with the Greens will shut down the cattle live export industry in Northern Australia in a heartbeat. They won't even pause to examine the dead bodies.
Thank you, Senator. The question before the chair is that the motion moved by Senator Mackenzie be agreed to. Those of that opinion say aye. Aye. Those against say no. I think the ayes have it. Is a division required? Division is required. Ring the bells for 4 minutes.
Dr Dawes, the question is, the urgency motion as moved by Senator Mackenzie be agreed to. The ayes shall move to the right of the chair, the noes to the left. I appoint Senator O'Sullivan as teller for the ayes and Senator Grogan as teller for the noes. Order. There being 31 ayes and 33 noes, the matter is resolved in the negative.
If senators could make their way out a bit more quietly, we will now consider the proposal from Senator Tyrrell, which is also shown at item 13 on today's order of business. Is consideration of the proposal supported? Yes, I believe you're all standing for the proposal as opposed to leaving the chamber. Great, thank you. And with the concurrence of the Senate, the clerks will set the clock in line with the informal arrangements made by the whips. I call Senator Tyrrell.
Okay, I move the motion as a matter of public importance. With Australia in the grip of a cost of living crisis, now is the time to focus on providing good numeracy and literacy education so our children are equipped to make fiscally responsible decisions. Cost of living crisis is a phrase we hear a lot in this place, and the government says it is working to provide relief for people, but it also told us to make more fiscally responsible decisions. If we've struggled to learn the basics of numeracy and literacy, how can we make better decisions about how to budget? Numeracy is not a nice to have. Numeracy is a must-have. We use numeracy every day to pay for a coffee, to cook, to read the parliamentary sitting calendar, to solve problems. Numeracy is essential. It helps us make sense of life. But so many in Tassie struggle when it comes to numbers. This isn't a new problem. Tasmanian numeracy results have fallen below the national minimum standard for a very long time. The most recent NAPLAN results showed 43% of Tasmanian grade 9 students fell into the bottom 2 proficiency levels, and that means 2 out of 5 students in my state need extra support or are developing that is working towards where they need to be when it comes to their number skills. But on a recent visit to Burnie High in the state's northwest, I saw how this community has worked together to increase the numeracy results for its students, and they're winning. Burnie Counts has helped prepare primary school students as they move to high school, and it's starting to turn around NAPLAN results. It's developed by the Burnie Numeracy Collective to improve numeracy outcomes, and has been trialled at 5 primary schools that feed to Burnie High. 28 teachers from these schools took on extra professional development in the maths curriculum to develop consistent teaching methods and assessment across grades 5 to 8. They also worked with parents to get them more engaged in numeracy lessons. The Burnie Counts student surveys show improvements in students' enjoyment of maths, and their confidence when it comes to doing well in maths. When parents were surveyed, the number who said they felt fear around maths halved, and the parents who said they like maths increased by 13%, showing parents were reinforcing the work done at the 5 Burnie schools. Teachers raved about the program too. Over the past 2 years, they have found better ways to teach maths, and they are more confident in teaching math concepts now. But let's look at the numbers that go with this, because that's what we're really here to look at. The 2024 NAPLAN results for grade 9 students at Burnie High School showed 89% of students achieved medium to high growth in numeracy, which is significantly above Tasmania's grade 9 average of 75%. To give you a little more insight into how Burnie High School numeracy stats have developed, in 2019, 74% of Burnie grade 9s recorded medium to high growth. This grew to 77% in 2021, 87% in 2023, and it's now at 89%. And the number of students falling into the strong proficiency category has grown from 59% in 23 to 64.2% this year. This is above the national average of 63.4%. Go Burnie kids! Besides helping build more confident kids, Burnie Counts has helped the wider community engage with numbers too. You can walk along the Burnie foreshore and join in fun maths activities. Yes, maths apparently can be fun. Check the direction and distance from Burnie to cities around the world with a supersized compass. Compare your height against Tasmanian Olympian Ariane Titmus and other role models, or play human-sized snakes and ladders. These activities have been rolled out within the community through collaboration between the schools involved with the Burnie Numeracy Collective, Australian Schools Plus, Burnie City Council and the Tasmania Community Fund. Not only is this an example of a community helping itself, but it shows how everyone benefits through collaboration. Burnie Counts is a great example of how a well-planned and tested program can help our kids do better at school. This program has already helped hundreds of kids in Burnie, and I feel confident the stats will continue to go up in future testing. But what about the kids on Tennessee's West Coast, or those struggling with numbers in Launceston or Hobart, or even in your electorates? We need programs like Burnie Counts to be rolled out to communities struggling with numeracy across the country. I call on the government to take our kids' education seriously and commit to improving numeracy. I call on this government to commit to improving numeracy in Tasmania and across the country. Without a good understanding of numbers, our kids will miss out on the skills they need to make good money decisions.
Senator Henderson.
Thank you very much, Madam Acting Deputy President. Well, I'd like to thank Senator Tyrrell for raising the critical issue of improving literacy and numeracy in Australian schools. With 1 in 3 students failing NAPLAN, evidence-based teaching reforms must be urgently mandated in every classroom. Getting back to basics is critical, and there is no excuse for any more delays. Failure to deliver what works in the classroom, the teaching of phonics, explicit instruction and other proven teaching methods has damaged a generation of Australians. Consigning students to a lifetime of functional illiteracy or a failure to reach proficiency in numeracy is akin to child neglect. The Albanese government has failed to deliver these critical national reforms for more than 2 years, and that is shameful. Education Minister Jason Clare has talked a big game. There is a draft agreement, but so far the Albanese government has not delivered the national reforms that he promised. Instead, the Albanese government has delivered a school funding war, which culminated in state Labor education ministers coming to Canberra and protesting against the Albanese government, with the Victorian Education Minister Ben Carroll declaring the Liberals, when in government, did a better job funding public schools than this government is doing. Failure to teach children to read and write and be numerate fuels disengagement, dysfunction and even youth crime. That was the finding of the National Children's Commissioner Anne Hollands, who warned that unless schools do more to help struggling students, things will go from bad to worse. She told the Australian's education editor, Natasha Beta, The fact that kids have to wait to be in prison to get one-on-one intensive learning support that they need is just abominable. In the Northern Territory, the situation is particularly dire. I have to raise concerns. The Albanese government conducted a mad scramble to sign a funding agreement in the dying days of the Territory Labor government, but this shows that Australians will not be fooled by any government with big spending plans and no real plan. The CLP's win in the Northern Territory election shows that Australians want schools funding to deliver real improvements in the classroom, not wasted on all the wrong priorities. I applaud Leo Finocchiaro's determination to get children off the streets and back to school, learning to read and write, which is critical to combating youth crime in the Northern Territory. I have to say that given Australia is one of the worst for classroom disruption, Minister Clare's failure to include a behaviour curriculum in the draft National School Reform Agreement is a major oversight. This must be remedied. We know that children cannot learn in chaos or in classrooms that are disrupted, where they are disengaged and not focused on the important work of all of our teachers. And of course, so many teachers are leaving the profession, hard-working, dedicated teachers, because of violence and aggression in many, many classrooms across this country. That said, as Senator Tyrrell referenced, there is amazing work happening in so many classrooms, in school systems, and we are even seeing a real move in our states and territories. More and more teachers are looking at the evidence, are looking at what works, evidence-based teaching, explicit instruction. And I saw a great example just at a school, a Catholic school just outside Hobart. We're using the latest evidence-based teaching. The children are absolutely thriving, and they are children in a low SES area and are just doing so incredibly well. So while we are seeing, as I say, some real moves in Tasmania with a focus from the Tasmanian government on explicit instruction and literacy, the New South Wales government has rewritten its syllabus. The Victorian government has made important announcements in relation to moving to the teaching of phonics. We do need to see action, for instance, in New South Wales. It's going to take another 3 years for the New South Wales syllabus to be properly rolled out. So, as I say, the Coalition is determined that in every classroom we must have evidence-based teaching mandated. We must get back to basics, and Australian parents deserve no less. Thank you.
Senator Stewart.
Thank you, Acting Deputy President. High-quality education is fundamental to unlocking opportunities and to success in life. I feel like the evidence is very well known to support that. The Albanese Labor government is determined to make our education system better and fairer, no matter how much your family earns or no matter where you come from. We know education opens the doors of opportunity for every Australian. I want to thank Senator Tyrrell for bringing forward this motion this afternoon and raising this topic. We are committed to strengthening our education system to ensure all students are prepared for the modern world by ensuring every student has the skills that they need. And our littlest deserve no less. I know Victorians are doing it tough right now. The Albanese Labor government's primary focus is easing the cost of living pressures facing Australians at the same time as fighting inflation in our economy. From July 1, we've delivered a tax cut for every Australian taxpayer, not just some. A $300 energy bill relief for every Australian household and $325 for small businesses. A freeze on the cost of PBS medicines for every Australian. A third consecutive pay rise for 2.6 million workers. More funding to build more homes in every part of the country. We're also delivering cheaper childcare, fee-free TAFE, and the biggest investment ever in expanding bulk billing. We're planning for the long term while helping Australians right now, working to bring down inflation and planning a future made in Australia. We know there's more to do and we'll continue every day to deliver for every Australian. Those on the other side have opposed every single one of these. They've said they will cut $315 billion from the budget, and we know that the cost of living measures that we've put in place, every single one of them is under threat from those opposite. They left us with $3 trillion of debt and nothing to show for it. They left us with debt and deficits, and now they want to create more chaos. I guess the apple doesn't fall far from the tree. It breaks my heart to think about the impact of 10 years of a coalition government and its impact on students, schools, teachers and families. They ripped more than $20 billion out of public schools across the country. $20 billion. Absolutely heartbreaking for our kids, for our families and for our teachers. What this has meant in practical sense is that attendance rates declined, high school completion rates declined, teacher shortages grew and the gap between the rich and poor got bigger. Through the Better and Fairer Schools Agreement, the Albanese Labor government has put $16 billion on the table to ensure students and young people are equipped with the skills required to make responsible decisions in all aspects of their lives. This would be the biggest increase in Australian government funding for public schools delivered ever. The Better and Fairer Schools Agreement ties funding to reforms to help students lift. The Better and Fairer Schools Agreement ties funding to reforms to help students lift student outcomes, improving numeracy and literacy education in our schools. It's great to see that Western Australia and the Northern Territory have signed up to the Better and Fairer Schools Agreement to fund these important reforms. We know that a good, solid education can set you up for life. Let's work together to give our young people the best start in life.
Senator Allman-Payne.
Thank you, Acting Deputy President. And I want to say thank you very much to Senator Tyrrell for bringing on this motion. I know that Senator Tyrrell values education and takes a keen interest in this area, and I appreciate the advocacy that she does on the behalf of our young people, both in Tasmania and across the country. Furthermore, this motion deals with two issues that I care deeply about, and that is how we alleviate poverty and help people who are in a cost of living crisis, and primary and secondary education. And I agree wholeheartedly with Senator Tyrrell that we are in a cost of living crisis, but I would go one step further and say that the cost of living crisis is actually impacting on our ability to provide a quality education for our young people to improve their literacy and numeracy. And it's doing that in two ways. The first way is the impact that the cost of living crisis is actually having on our school communities. So at the moment, we have young people coming to our public schools who are housing insecure. And let's be real, the majority of young people who are either in housing stress or in other forms, experiencing other forms of poverty and insecurity are by and large attending our public schools. So we have young people coming to our public schools who are housing insecure. That impacts their ability to learn. You know, I've taught senior students who are couch surfing. It's really hard to get your assignments done if you don't know where you're going to be sleeping that night. And yet the government could take steps to tackle that. They could freeze rents and they could put a cap on rents, and that would help more people into secure housing. They could also increase the build of public, affordable, good quality housing. The government used to build 1 in 4 homes. We don't do that anymore. That would be a concrete and substantive way that we could make a meaningful difference in the lives of the families and the young people who form our public school communities, that would enable them to engage in their learning and to do better in their literacy and numeracy. We could make supermarket price gouging illegal. I'm certain there won't be a public school teacher in the country who didn't have a young person in their classroom today who was hungry, who either came to school without having breakfast or didn't bring lunch or had neither. I remember talking to a young person in the playground one day, and they were walking down the steps and they had a can of soft drink in their hand. And I made a comment about, is that, you know, the best thing that you should be having for lunch? And they told me how grateful they were that someone had given it to them because they hadn't had breakfast or lunch for that week, and it was Friday. Try getting a young person to engage in what's going on in a classroom to improve their literacy and numeracy if they're starving. You know, if we actually took action, if the government took action to tackle grocery prices, that would make a huge difference for the young people who are coming into our schools. We could raise the rate of income support. Before we even started the cost of living crisis, 1 in 6 young people in this country was living in poverty. And that was before we saw the massive increases in costs of living. Those are the young people who come to a classroom who don't have a notebook, who don't have a pen, whose parents haven't got a hope of buying them a laptop or an iPad, because once upon a time governments and schools provided the technology and the resources that kids needed to learn, and now we just cost shift that all onto families. Well, if you're a family that is struggling with the cost of living, and your young person attends a public school and you don't have all those resources provided for you, it's hardly surprising that it's a challenge for you to engage in the curriculum and to do the things that you need to do to improve your literacy and numeracy. And let's not forget teachers who are making up the shortfall in our public schools for the lack of funding and resources, who on average spend $800 to $1,000 a year out of their own pockets to resource those schools, and now they're experiencing a cost of living crisis. So the people who are filling in the gaps and plugging the holes are less able to do so. The government can take action on both these things. They can tackle cost of living and they can fully fund public education, and they really need to get on with the job.
Senator Dominant.
Thank you, Acting President. I rise today to speak in response to the urgency motion brought forward by Senator Tyrrell. And I'm really glad that Senator Tyrrell has brought this topic before the Senate, because a quality education truly sets out our young people up for the best possible start in life. It is absolutely an issue of national importance, and now more than ever we must focus on equipping the next generation with the skills they need to succeed. Sadly, 10 years of the coalition government were absolutely terrible for students, teachers and families across this country. That's because more than $20 billion was ripped out of our public schools, as already highlighted by Senator Stewart, and no surprises who was sitting on the Expenditure Review Committee at that time, none other than Peter Dutton. The coalition has failed our students. Attendance rates declined, high school completion rates fell, teacher shortages grew and the gap between rich and poor widened. In contrast, Labor values education because it opens the doors of opportunity. That's why we are committed to building a better and fairer education system, one that prepares students for the modern world. Our children deserve the chance to develop the skills they need to succeed, as Senator Tyrrell outlined, and the building blocks of this are, of course, being equipped with solid numeracy and literacy foundations. But how are we going to do this? The Albanese government's Better and Fairer Schools Agreement is a significant step towards this. It ties funding to important reforms designed to lift student outcomes. Among those reforms are essential measures to improve numeracy and literacy. For instance, we're introducing the Year 1 phonics check and an early years numeracy check to identify students who need additional support as early as possible. Senator Tyrrell outlined an example from Burnie of where improvements in maths education were evidenced. The Albanese government believes in evidence-based teaching, and we are backing that up with targeted, intensive interventions like small group or catch-up tutoring for students who fall behind. These are proven methods that work, and they're aimed at ensuring no student gets left behind. These are critical reforms to enable our young people, when they go into the world, to make their own way, to be as prepared as they can be to make fiscally responsible decisions. But none of this can happen without our teachers. Teachers are the backbone of our education system, and they do one of the most important jobs in the world. And I am reminded of this by my husband Luke, who, as a secondary teacher, has this year been teaching many Year 12 students this year to prepare them for their futures at a secondary school in northern Melbourne. That's why our reforms also include initiatives to attract and retain teachers, particularly experienced ones, by rewarding their hard work and incentivising them to work in schools that need the most support. These reforms aren't just about lifting individual students, they're about lifting the whole system. We're setting clear targets, like getting more students out of the lowest NAPLAN bands and into the higher levels for numeracy and reading. Reforms to assist young people in making fiscally responsible decisions. Skills that are required for all young people, as Senator Tyrrell has rightly identified. And we're focusing on improving school attendance because school is where the learning happens, and we're committed to ensuring the proportion of First Nations students completing Year 12 as part of our dedication to closing the gap. This isn't just talk. And these reforms are backed by real funding commitments. Western Australia and the Northern Territory have already signed up to the Better and Fairer Schools Agreement. In the Northern Territory, this means their schools will go from being the lowest funded in the country to some of the best funded. Over the next 5 years, their schools will be nearly $1 billion better off. In Western Australia, the agreement means every student will attend a fully funded school by the first day of term in 2026. That's the kind of transformative funding we want to see in every state and territory. The Australian government has put $16 billion on the table to close the funding gap and drive these reforms. But we can't do this alone. The Commonwealth is ready to contribute, but we need the states and territories to step up and meet us halfway. From day one, this Labor government has sought... So from day one, in being in government, education has been a key priority for this government, and we are taking real action in a way that balances ambition with responsibility.
Sorry, I was just sorting out the next thing. My bad. Thank you, Senator Hughes. Senator Roberts.
Thank you. Education systems are failing our children right across Australia. Yet we have fundamental solutions, and I'll get to these. First, I want to thank Senator Tyrrell for her MPI today. Secondly, I want to define the problem. Instead of focusing on the basics, children are forced to learn from the latest list of woke obsessions and distortions. That's no way to develop students, to guide students. Consider the fact that some schools consider Bruce Pascoe's book, Dark Emu, to satisfy the Indigenous history curriculum. Anthropologists have utterly debunked his fiction as cherry-picked nonsense. Yet in many schools, this is taught as history, as if it's undisputed history. A Sydney primary school has sparked debate after telling pupils to place their hands on the ground and repeat in unison, "Always was, always will be Aboriginal land," before each assembly. That completely contradicts the High Court ruling. At some schools, allowing school children to identify as animals, like cats, and even providing litter boxes in classrooms is starting to become accepted. And can you see how this erodes respect for teachers? Boys and girls at a very young age know the difference between men and women and between cats and humans. Agreeing to their fancy is just nonsense. And they know that when a teacher says girls can be boys, that's ridiculous. Completely undermines respect. All of this is happening as Australia's education rankings are plummeting. And parents aren't stupid. They know the schools are not doing their job. They really woke up when children came home and started homeschooling and doing lessons over Zoom. That's when they realised, the parents realised that schools were not doing their job. Parents know also that schools are more interested in ideology, rubbish, than the basics of reading, writing and numeracy. This plagues not only public schools, it also plagues some private schools. That's why the rate of homeschooling is exploding. Parents are taking responsibility for their children, responsibility for their children's education. Between 2019 and 2024, Queensland homeschool registrations surged 229%. Tripled, more than tripled. While I support homeschooling, parents shouldn't have to take schooling into their own hands to make children get what they need. They pay good money in their taxation system and they should get what they need for their children. The basics of reading, writing and numeracy must be the #1 priority. One Nation supports the concept of charter schools. At the very least, government funding should follow the child, not be doled out on conditional grants that suit some bureaucrat. If parents want to send their children to a particular school or particular type of school, the funding should go there, should follow the children. That'll return control to principals and parents. This is a hallmark for schools that take responsibility and a hallmark for children that take responsibility in such schools. We have a federal education department in our country costing $184 million each year in bureaucrat wages alone, and it doesn't operate a single school. Sure, it has some responsibilities for universities, but it doesn't operate a single school, and yet it interferes in state school curriculum. So much for our federal system of education and system of governance. We need to disband, shut down the federal education department, and while we're at it, the federal health department. Restore competitive federalism, because that's a marketplace in governance. States that have a better run will see people coming to them. I also want to call out Maria Montessori, the greatest studier of human behaviour and human development. She said, after a lifetime writing books, reading, observations, meticulous observations, she said, the critical years for the formation of both character and intellect are birth to 6. And she got it absolutely right, along with so many other observations that she had. Children go through sensitive periods. They need teachers, they need guides, not teachers. And that's how people develop responsibility. Because that's the key thing that comes out of Montessori schools. And having been on the board of a Montessori school, as a parent at Montessori school, and the International Montessori Council as advisory board, I know she got it right. Get rid of the waste, get back to basics, the 4 R's, reading, writing, arithmetic, and responsibility.
Thank you, Senator Roberts. We're now going to move to the consideration of documents. The documents are listed on page 4 of today's order of business. Is there anyone who wants to take note of any of those documents? Senator Roberts.
I have the wrong spot here. No, I'm sorry, I'm waiting for 15.
Yes, we'll come to that in a moment. So just double checking before we move on. So Senator Pocock?
It's the document, the Human Rights Joint Standing...
That's coming in the next section. Yep. Okay, so... Oh, we do have Senator Little.
Can I just clarify, we're on page...
We're on page
document
4,
2.
so we're doing item 14.
Thank you. Thank you. I rise to take note of document number 2 on page 4 of today's read, the August release of the report on the National Plan to End Violence Against Women and Children. Well, we all want to turn the dial on family violence, but the plan is only as good as the paper it is written on if the Commonwealth does its job, and of course the states and territories do too. The track record of this government, though, has been go slow, poor delivery and off the mark on much of this. And we want to and will be on a unity ticket when the focus is in the right measure. For an example, look no further than this. At the 2022 federal election, the Prime Minister and his team promised 500 new frontline and community workers for the family and domestic violence sector. In February this year, there were just 2. In May, on becoming aware of this appalling progress, Minister Gallagher made another commitment the Labor government again failed to keep. The Minister promised to fill 352 positions by the 30th of June. They delivered just 94. Not all of them new positions, not all of them new workers. By the end of August, they made it to just 198, a long way short of the 352 positions promised. Australian women, children and vulnerable people fleeing violence in a sector who wants workers, they really want those workers, well, at that rate, it's unlikely they'll get 500 before the next election. Another example of a broken promise is the delayed rollout of the male perpetrator initiatives. Worse still, at the time, Minister Rishworth gave taxpayer money to an organisation that is not even compliant with its regulator, an organisation that's delivering a service for male perpetrators. Taxpayers should accept as a basic principle, a basic governance principle, that meeting reporting obligations before making announcements about new money would be done. Instead, of course, this government is all about the headline. It is therefore fair to ask, how much due diligence has been done on recipients of the funding initiatives of the National Plan? How can anyone forget the $400 million for a better, safer Central Australia? Despite that investment, family violence-related crime has increased in the Northern Territory by about 20%, and youth crime remains a significant issue. On one August night when I was in Alice Springs, 500 windows were broken. Next morning, youths and adults with rocks in their hands were walking the streets without even attempting to disguise their weapons. I saw it myself. After a grand final match in Alice Springs, violence erupted with hatchets, axe handles, baseball bats and sticks. How is it that in a major sporting event in Alice Springs that can occur when across the nation we check for those things in bags, we check for alcohol, we check for weapons, we do that on entry? The answer, Prime Minister Albanese, is not just send more money, it's about accountability, common sense. It's a similar story in Ceduna. Last weekend, a large fight in front of families between women after a netball match resulted in multiple injuries. All played out in front of children. In a town increasingly reliant on a welfare economy, it's likely that key figures from organisations funded to address violence and disadvantage were among those offenders. Don't ask Minister Rishworth what's going on in Ceduna, though. She'll say it's only perceived that there was a problem, ignoring a town bouncing from crisis to crisis. More reviews and advisory groups won't have as much impact as action. Ignoring the evidence is not the answer. The National Plan and the most recent rapid review of prevention approaches, that report, is clear about focus on early intervention and prevention. Early intervention and prevention is not about allowing alcohol restrictions to lapse in the NT without a transition plan. Early intervention prevention is not the removal of the cashless debit card, which evidence proves has been catastrophic in those communities that wanted it. Early intervention is not about removing income management to leave those with gambling, alcohol and other addictions and catching them when they've reached rock bottom. When a child comes into contact with the child protection system, we have failed them. When an individual or community can't get proper help for addiction, we've failed them. I seek leave to continue my remarks. Thank you.
Thank you. If there are no further speakers, I will go to tabling and consideration of committee reports and government responses, and I call on Senator Urquhart.
Thank you. On behalf of the Chair of the Community Affairs Legislation Committee, Senator Mariel Smith, I present additional information received by the committee on its inquiry into the National Disability Insurance Scheme Amendment, Getting the NDIS Back on Track No. 1 Bill of 2024.
And government responses. Senator Ayres.
Acting Deputy President, I present government responses to reports of the following committees. The Foreign Affairs, Defence and Trade References Committee on its inquiry into the efficacy of the Department of Foreign Affairs and Trade Due Diligence Framework, and the Legal and Constitutional Affairs Legislation Committee on its inquiry into the provisions of the Attorney General's Portfolio Miscellaneous Measures Bill 2023. In accordance with the usual practice, I seek leave to have the documents incorporated in Hansard.
Has leave granted? Leave's granted. I'm now going to go to committee reports and government responses presented out of sitting, and these are on page 5 of the Senate Order of Business. I'll go to Senator Roberts and then I'll come to you, Senator Pocock. Senator Roberts.
Thank you, Madam Acting Deputy President. I move to take note of document number 6, document number 6 under committee reports presented out of sitting, and seek leave to continue my remarks.
Thank you, Senator Roberts. Is leave granted? Leave's granted.
Thank you.
You've got more,
yes,
Senator Roberts?
Yes. I move to take note of item number 5 on page 5, Legal and Constitutional Affairs References Committee Report COVID, and wish to make comments.
You have the call.
Thank
Senator
you.
Roberts.
Last year, I was successful in having the Senate inquire into the prospective terms of reference for a Royal Commission into the government response to COVID-19. The inquiry was held, and I thank Senator Paul Scarr for his even-handed treatment of the process and for producing with the Secretariat an excellent report. Outstanding. After hearing and reading testimony from multiple highly qualified witnesses, every one of whom called for a Royal Commission, the committee did in fact recommend a Royal Commission be held. This was their report, 128 pages of honesty, decency and common sense. Last week, the government provided this response to the inquiry report, 1 and a bit pages. Here's what it says. The government does not support a Royal Commission. The government does not support working with the state governments on an inquiry. The government does not support the proposed terms of reference. The government does not support any further public involvement in the inquiry process. How can we have an investigation when the government says it does not support working with the state governments, yet it's got an inquiry underway right now that is not considering the state governments? Instead, the Albanese Labor government will continue with their cover-up inquiry comprising 2 bureaucrats and a university academic closely involved in the COVID response. Shame. The government is letting bureaucrats and academics investigate themselves. What a disgrace. Betrayal. It's inhuman. During the last election campaign, the Prime Minister promised a Royal Commission or similar inquiry, a Senate Select Commission of Inquiry, would fit that description. Then Senator Gallagher promised us a Royal Commission. Promised. No wonder the public distrust politicians when 2 promises that were clear as day were broken the minute the Labor Party came to power. It does raise the question, though, what was the motivation for the government to proceed with a cover-up instead of its promised judicial inquiry? Could it be the donations the Labor Party received from the pharmaceutical industry in the last election? Here's the list from the Australian Electoral Commission of donations to the Labor Party, the Australian Labor Party in 2022-2023. AbbVie Pharmaceuticals, makers of Liprolin, puberty blockers, $14,000. Alexion Pharmaceuticals, $33,000. Amgen Biopharmaceuticals, $27,500. Aspen Medical, $83,000. AstraZeneca, $33,000. And isn't that a huge conflict of interest, refusing to investigate? Bayer, $33,000. Bristol Myers, $52,000. HA Technical Pharmaceuticals, $54,000. Johnson & Johnson Pharmaceuticals, $36,000. Ka-chink, 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 the cash register in the Labor Party is ticking over. Merck Sharp Dome, $66,000. Novartis, $33,000. Pfizer, $25,000. Another cash register ka-chinging. Roche, $66,000. Sanofi Aventis, $42,000. Pharmacy Guild of Australia, who enjoyed years of profit dispensing high-paying COVID injections, $154,000. And Medicines Australia, the peak lobbying body for the pharmaceutical industry, which just gave the former head of the TGA, Professor Scarr, a job as a director, donated $112,000 to the Labor Party campaign funds. Ka-chink. Including smaller donations, the Labor Party raked in almost $1 million from pharmaceutical companies and associated favours bought. It's not just Big Pharma either. Remember when you couldn't get COVID at Bunnings, yet you could get COVID at your neighbourhood hardware store? Governments forced many hardware stores to stop business in lockdowns and went broke, while Bunnings grew its market share. Then they set up vaccination stations in their car parks. Now, I know many people thought that was odd, so let's look at this list of donations. Here it is. Bunnings, West Farmers donated $110,000. $110,000. Now, for completeness, let me list One Nation's farmer donations in 2022-2023. None. Not one. Not one donation from the pharmaceutical industry, the banking industry, the healthcare industry, or the net zero industry. Why? Because One Nation is not for sale. I will now review what the government is covering up with their refusal to hold a COVID Royal Commission. This is based on expert witness testimony to the committee inquiry and on peer-reviewed papers and data analysis which have come out since the inquiry. Firstly, testimony before America's Congress proved SARS-CoV-2 was a product of gain-of-function research with funding from Anthony Fauci's National Institutes of Health, managed through Peter Daszak's EcoHealth Alliance. The research started in the USA, and when President Obama banned gain-of-function research, it was moved to Wuhan Institute of Virology in China. But the research continued secretly and illegally in North Carolina. We know that. In 2021, Australia's CSIRO confirmed it assisted in the Wuhan research. We're complicit. Secondly, the official timeline for COVID is wrong. The University of Siena in Italy sequenced COVID on the 10th of October 2019. Unconfirmed reports persist of 3 lab technicians from Wuhan lab presenting with flu-like symptoms to a hospital in Wuhan in mid-September 2019. Those 3 were COVID's patient 0. Wuhan has 90 direct overseas flights a day, including 5 a day into Italy and 5 a day into Australia, where symptomatic infections started showing up around the end of December 2019. This means that in October 2019, when the Bill and Melinda Gates Foundation sponsored the COVID Event 201 war game that the World Economic Forum organised, COVID was alive in public. Note that the Nobel Prize-winning virologist Luc Montagnier sequenced COVID in April of 2020, and he found, quote, "It is not natural. It's the work of professionals, of molecular biologists, a very meticulous work," end of quote. Luke declared the virus was a combination of the original man-made SARS virus, parts of the HIV virus, and a bat virus, which was there to fool the body's immune system into thinking it had never seen the virus before, and as a result had no immune response to it. The fact the virus escaped before it could be perfected has saved billions of lives. What they tried to do here was evil personified. Here's just an example. Firstly, the RNA genome of SARS-CoV-2 consists of 30,000 nucleotides and 11 major coding genes. Pfizer, BioNTech and Moderna took the 4,284 nucleotides constituting the spike protein and at positions K986P and V987P introduced mutations to stimulate increased production of human antibodies. Those spike proteins of SARS-CoV-2 are involved in receptor recognition, viral attachment and entry into the host cells. The last part is significant. Both COVID itself and the mutated vaccine material enter human cells. There's certainty on this point. These COVID vaccines are gene therapies, yet are not regulated as such.
Please try again.
No safety testing was done on the long-term effect of introducing a mutated COVID DNA strand into the human genome. Secondly, Oxford University investigated brain injury from COVID. It mapped the brains of 785 participants and waited for them to get COVID. 401 obliged, creating a control of 384. All were scanned a second time, and any brain function difference was attributed to COVID spike proteins. Oxford University found, quote, significant longitudinal effects, including a reduction in grey matter thickness and tissue contrast, changes in markers of tissue damage in regions that are functionally connected to the olfactory function, the sense of smell. A reduction in global brain size in the SARS-CoV-2 cases. The participants who were infected with SARS-CoV-2 showed on average a greater cognitive decline between the 2 time points. The paper concluded these results may indicate degenerative spread of the disease through olfactory pathways through the nose. Doctors who advocated for nasal preparations were actually right. The nose turns out to be the key. One study found 471 bacterial agents in 171 face masks, many of which had a high resistance to antibiotics. This was an important issue for the Royal Commission to understand. Third, Yonker et al. From Massachusetts General Hospital tested young people presenting with chest pains and found free spike antigen was detected in the blood of adolescents and young adults who developed post-mRNA vaccine myocarditis, linking the shots with heart disease in the young. Fourth, we knew as early as November 2021 that spike protein built up in the lungs, heart, kidney and liver, causing an inflammatory response. Yet we kept injecting spike proteins into people, including children, over and over. Now they're dying suddenly and doctors are baffled. The hell they're baffled. Fifth, SARS-CoV-2 spike proteins, meaning most likely the shots as well, have serious effects on the vasculature of multiple organ systems, including the brain. Outcomes include fatal microclot formation, and in rare cases, encephalitis. Wait a minute. Isn't New South Wales now urging parents to vaccinate their children against a sudden outbreak of encephalitis? COVID and COVID shots are the same man-made poison, yet we never tested the shots long enough to reveal that. Now people are dying and suffering life-altering disease while we continue to inject the public with boosters containing the very substance that is causing these deaths and injuries. Today, I'm announcing in the first week of December, I will be conducting the third in my full-day reviews of COVID, to be called COVID in Trial. I promise to hound down those responsible...
Thank you, Senator Roberts. Do you wish to seek leave to continue your remarks?
Yes, I seek leave to continue my remarks.
Leave granted. Leave is granted. Senator Ayres.
Look, I have listened to these contributions from Senator Roberts and some of his colleagues. Mr Dutton's favoured candidate for the Senate, Senator Rennick, and others. And I've spoken about them at length before, and I don't intend to take much time. But that contribution, it is a titanic effort to fit every single barking mad conspiracy theory into one contribution, into one 15-minute slot of extremism and conspiracy theories. And the problem with extremism and conspiracy theories is that they do damage. They are deliberately calculated to do damage. They are propagated by people. Oh, here we go.
So I'm required to put the question unless any senator wishes to be in continuance. Point of order. Oh, sorry. Doing a great job today.
Senator Ayres is impugning motive and maligning.
I have been listening. I think the remarks are general in nature and haven't been directed towards you, Senator Roberts, but I will continue to listen.
Really trying to hurt people.
To the extent that you made that remark, Senator Ayres, are you willing to withdraw?
Of course, I'm always happy to withdraw.
Did you wish to? Were you finished, or did you wish to continue?
I have a few more minutes. The people who propagate those conspiracy theories are either unwitting dupes who are silly enough to believe that kind of material that you find in the sort of swamp of the dark recesses of the internet, or they are deliberately seeking to do social harm. And I don't know which category Senator Roberts falls into, but he falls into one of them, because there is no alternative there. Misinformation...
Senator Ayres,
Yep, of course.
I do think that crossed a line. I think you now are impugning Senator Roberts, so I'm going to ask you to withdraw that.
I'll withdraw that too, although I have to say I'll withdraw unreservedly, but it is open to me to canvass what are the various reasons that this kind of damaging misinformation and disinformation is being propagated. It has a serious effect. And we see that where there is extremism, there is a reason why the ASIO Director General highlights the role of extremist misinformation and disinformation in terms of its corrosive effect, because it does lead to some of the acts of violent extremism here and overseas are motivated by the same vile conspiracy theories that we've just heard and are supported by some of these characters here. The problem really for the Liberal National Party on this is how much they continue to tolerate it. It's all the pats on the back for all the extremists. It's always, yeah, don't worry, that's just Senator Roberts. You know, he's just, he and his sort of Cooker associates, that's just them. Don't worry about it. But every time they do that, they support extremism.
Senator Roberts.
Order. Senator Ayres again maligning. I'm not associated with Cookers.
Senator, Senator, please restrain yourself from.
I am doing my best. I am doing my best. Because what is being propagated is so damaging to Australia, to our democratic institutions, to the health of our public debate, to public health itself, and it is exactly the kind of conspiracy theory ideology that is used to promote violence, threats online, the kind of swamp online that these theories come from is exactly the swamp that these kind of characters play in. And it should not be tolerated by a party that says that it hopes to form government one day. Should not be tolerated, but it is. It is tolerated. It is encouraged. It is acquiesced to. It is becoming a stronger and stronger strain of thinking amongst some of these characters in the Liberal National Party, and that some of whom are on their own what appears to be path to radicalisation. So I just think it's got to be called out every single time it happens, and I will continue to call out because it's bad for Australia, damaging to our democracy, and is beneath contempt in my view.
Senator, are you planning to speak on this particular one? No, I have to do something procedurally before. And are you seeking to speak on this? I'm intending to put the question, if another member wishes to speak on it, and or seek to continue their remarks. Right, I'm putting the question. Those for the question say aye, against, no. The ayes have it. Senator.
Thank you, Deputy President. I move to take note of the report from the Parliamentary Joint Committee on Human Rights Inquiry into Compulsory Income Management. This report must spell the end of compulsory income management. For years, advocates, participants, academics and the Greens have fought for the abolition of compulsory income management. Evidence before this committee showed the dramatically different rate of exemptions granted for compulsory income management, with First Nations people much less likely to apply for an exemption and significantly less likely to get an exemption. This report, one of many through the years, only confirms what the Greens and the community have been saying for years, that this system does nothing but reinforce a racist and oppressive program. The fundamental premise of this system is discriminatory. This scheme is only another way that the government systematically discriminates against and oppresses First Nations people. Evidence from this inquiry called the scheme, and I quote, a racist, paternalistic policy framework that only does damage to individuals and communities, especially to First Nations people, end quote. The system is built on the assumption that some communities cannot manage their finances and so they need to be limited by the government. This program has been a dud since its inception. Its stated purpose is preventing welfare payments from being spent on gambling, alcohol and drugs, but the data doesn't bear this out. 97% of recipients subject to this program had never gambled or gambled more than what they could afford to lose. 81% said they never drank or drank less frequently than more than once a week. In attempting to address a non-existent problem, this government went back on their promise and instead expanded a paternalistic system that makes managing finances more difficult and discriminatory for recipients. and they tell these recipients that they don't trust them. This report also highlighted the complete lack of positive impacts that these decisions have had. Instead, successive governments have crafted a system that places additional burdens and pressures on women and children fleeing domestic violence. It makes it harder to put money aside to escape abuse, and survivors have expressed difficulty in buying bus fares, school lunches and second-hand clothes. Compulsory income management also limits recipients' ability to purchase cheaper second-hand goods, including things like textbooks for study. Evidence from the report showed, and I quote, "Subjecting an individual to mandatory income management and restricting how they may spend a portion of their social security payment engages and limits the rights to social security, to privacy, to equality and non-discrimination, and it may limit other human rights, including the right to an adequate standard of living and the rights of a child." End quote. In many submissions to the committee, recipients described extra fees and added difficulty to pay rent and bills on time as a direct result of the smart card system. One respondent noted that compulsory income management felt similar to the financial control and abuse that they suffered in a former domestic violence relationship. This report is long overdue, and the complete abolition of compulsory income management is even more overdue. Labor must not continue to kick this can down the road. It is a matter of urgency that compulsory income management be abolished. It's a matter of urgency because just in the past few days we've seen the incoming Northern Territory leader commit the NT government to shift parents of kids who are missing school to income management. All of this is against the background when you have the most underfunded schools in the country in the NT. And instead of coming at this from a place of care and support and empathy, we've got a new Territory Minister now jumping up and down asking the federal government to keep expanding income management. It is critical that this government take advantage of progressive support in the Senate to abolish compulsory income management for good. Otherwise, we risk the very real possibility of a more amenable government coming into power and expanding income management even more. I urge the Labor government to act now and to act on the promises that they made in opposition. And I seek leave to continue my remarks.
Thank you. We've completed committee reports and government responses. Are there any ministerial statements? Minister.
Thank you, Deputy President. I table documents relating to orders for the production of documents concerning tax assessments for not-for-profit entities and fire ant eradication and helicopter flight permits. Thanks.
Senator Cadell.
Documents seek leave to continue your remarks.
Senator Cadell, it's all those documents? Okay, is leave granted? Leave is granted. Senator Roberts.
I wish to take note of the government's response to the fire ant request.
That's already been done by Senator Cadell, and he sought leave to continue his remarks, so it will remain active in the list. The President has received a letter requesting changes in the membership of a committee. Minister.
I seek leave to move a motion to vary the membership of a committee.
Is leave granted? Leave is granted. Minister.
I move that Senator Mackenzie replace Senator Reynolds on the Rural and Regional Affairs and Transport References Committee for the committee's inquiry into Commonwealth, Olympic and Paralympic Games preparedness, and Senator Reynolds be appointed as a participating member.
Put the question. Those to the question say aye. Against no. The ayes have it. Honourable Senators, the President has received messages from the House of Representatives informing the Senate that the House has agreed to amendments made by the Senate to the following bills: Net Zero Economy Authority Bill 2024, Treasury Laws Amendment Financial Market Infrastructure and Other Measures Bill 2024. Honourable Senators, the President has received a message from Her Excellency, the Governor-General, notifying assent to 5 laws, details of which will be incorporated in Hansard. Clerk.
Business of the Senate notices of motion number 2, standing in the name of Senator Rennick, relating to a reference to the Legal and Constitutional Affairs References Committee regarding a Federation Convention.
Senator Rennick.
Thank you, Mr Deputy President. I'm pleased to move this motion today. As I said in my maiden speech, of all the issues faced by Australia, few are more damaging to our country than the fiscal imbalance and ambiguous responsibilities between state and federal governments. You've really got to ask why Australia, a country of 25 million people, has 9 growing health bureaucracies while maternity wards are being closed in my home state of Queensland. Our constitution was designed to hold government to account by the people, yet 120 years of compromise has rendered it ineffective. It's time for what was then COAG, now National Cabinet, to hold a Federation Convention to clearly define and separate these responsibilities, with proposed changes to be put to the people. The blame game needs to end, and Australians deserve much greater accountability. Now, I said that back in September 2019 when the bushfires were ripping through the east coast of Australia. I well remember many people that came to my maiden speech had to take various diversions to avoid the bushfires, and we saw in the bushfires the blame game in full throttle, with the federal government being blamed for not doing enough, despite the fact that state governments are responsible for dealing with fires and emergency management. We've seen the COVID disaster, whereby there was constant bickering between the state and federal government over who was responsible for what. And of course, just a couple of weeks ago, we've had the situation up in Gladstone, whereby we had another tragic accident on the Bruce Highway. And of course, the usual blame game goes on. And I know my good friend, member for Wide Bay, Lou O'Brien, had many conflicts, fights and arguments with the Queensland Transport Minister, Mark Bailey, over getting funding to duplicate the highway north of Gympie. And I know my good mate Lou is very, very passionate about improving road transport. But the point is that we can't deliver essential services in this country while we continue to bicker between state and federal governments. We can't generate productivity in this country when we have unnecessary rules and regulations that companies have to jump through in order to get anything built. And we've seen that just recently with the dismissal of the proposed gold mine in Orange, whereby Regis Resources had spent hundreds of millions of dollars in getting regulations and approvals from the New South Wales government, only to then come to the federal government and then have the project kiboshed. Now, the federal government isn't the government that's going to lose the royalties from that mine. It isn't the government that's going to lose the payroll tax from that mine. So yet again, it's very easy for the federal government to kibosh the mine on environmental or heritage concerns, but they're not the ones who lose the revenue. And yet again, as I often talk about capitalism, capitalist is someone who actually risks their own capital, not someone else. We've got this agency theory going on in our federation, whereby different levels of government can stick the boot into another level of government and not reap the consequences. But this issue is much, much more systemic. If we take health, for example, and I quoted this particular example in my maiden speech, maternity wards, we've had over 30 maternity wards closed in my home state of Queensland in the last 30 years, not so many recently, but between 1990 and 2005, a number of them shut down. And that's despite we've got these growing health bureaucracies and new departments, new CDC or whatever, and lots of bureaucrats in the back end coming up with more rules and regulations, but we can't deliver essential services. Now, with health, for example, the state government really only manages public hospitals. The federal government is responsible for funding private hospitals, it's responsible for Medicare, it's responsible for the PBS scheme, it's responsible for approving drugs through the TGA and other health issues as well. So wouldn't it make much more sense, for example, to move health to the federal government and then in exchange for that, move education back to the state government? Now, you know, one of the things, and I often hear the other side chamber talk about this, is that the funding for education, you know, it's very difficult to get, you know, we've got another situation here whereby we have private schools funded by the federal government and we have public schools funded by the state government. And then we have this bickering over, you know, how much funding private schools get, how much funding public schools get. It's very hard to get a comparison between the schools as to know who knows what they get. We have this bizarre situation where universities are owned by state governments but are funded by the federal government. So why not just have this, and what I'm proposing here is a federation. I originally wanted a constitutional convention, but I think that was a mistake. I think it should be a federation convention because some of these roles and responsibilities of state and federal government don't actually need to change the constitution. They can be a simple agreement through section 109 where they go, okay, you take responsibility for this and we'll take responsibility for that. And in doing so, you can actually eliminate bureaucracies and get them out of the road. And you'll save money when you eliminate these bureaucracies, because what we've seen in the last 40 years is increasing number of bureaucrats. And if you look at the figures in the health sector, for example, the ratio of bureaucrats to frontline services is increasing. And one of the proposals that I've just suggested then, the reason why I'd like education to go back to the states is that I believe education is competitive and it would be good to have competition between the states. On the other hand, health is a very inelastic, at least basic health, emergency services and things like that is very inelastic. And it's a term, and that matters because we often talk about competition in this chamber, at least this side of the chamber, and there's this view that greater competition leads to better outcomes. It doesn't always. Competition can be constructive and it can be destructive. And it's very important that our role in government is to make sure that we have competitive competition that is constructive. Now, to understand that, you need to also understand elasticity. When it comes to health, there is very little elasticity with basic health services. If I'm bitten by a big black snake out in a paddock somewhere, I'm not going to pick up the phone and ring around the country looking for the cheapest hospital to go to. I'm going to go to the cheapest hospital. So we need to be able to deliver reliable health services across the country, regardless of where you live. And that is very, very important. And that is the role of the government. It is the role of the government to provide a safety net. But we're not really providing a safety net for the people out there beyond the Beltway, beyond the bubble here in Canberra. What we're really giving them is a set of rules and regulations. So that's one example that we need to look at. Then we've got the whole energy debacle where we have, you know, our energy sector is controlled by AEMO, which is effectively, and I'll stand to be corrected on the numbers here, but I think it's 40% owned by the states and 30% owned by the private sector and another 30% owned by the federal government. So this is another classic example of when everyone's in charge, no one is in charge. And our energy sector, of course, has become a complete mismatch of sort of a cross Frankenstein of sort of some public assets left in Queensland with our coal-powered fire stations. We've privatised baseload assets in other states. We've then got the conga line of rent-seeking parasites in the renewable sector who's constantly milking the federal government for subsidies to keep their head above water. You know, state governments are throwing subsidies at both renewable sector and the baseload sector now because they've run down the baseload sector so much that they've had to now go around and prop that up rather than just have a simple model whereby one level of government is responsible for the provision of energy. Now, I would tend to go back to having the states run energy. It's not in Section 51. There's no head of power, I'm led to believe, under Section 51 that says energy should be the responsibility of the federal government. Having said that, I will give credit to Ben Chiefley here when he used Section 51(6) of the Constitution to get the Snowy Hydro project built, because he had to bring New South Wales and Victoria together. And at first, I'm led to believe they complained, but when they realised the federal government was going to pay for it all, they let it go through. And that's another example of whereby if we let this energy sector run down, we may actually have to end up using 51(6) because if the energy grid collapses. But yet again, my experience in life has been you've got to have clear lines of accountability. And when you've got three players in this, the triangular system, state government, federal government and the private market, it ain't working. It ain't working. Then on top of that, we've got the water sector. Now, nothing grinds my gears more than what happened as a result of the Tasmanian Dams decision in 1983. Now, regardless of what your view on the environment is, the fact is Bob Hawke used Section 5129, the foreign treaties powers, to override the powers of the state government. Now, I'm pretty sure when our founding fathers set up the Constitution and said that the federal government was responsible for foreign powers, it wasn't so that they could then go and sign treaties whereby you've got UNESCO or whatever stopping the state government from building dams, much needed dams. And might I add, a good way of actually providing renewable energy is hydropower, and we don't do enough of that in this country. And it's no surprise that since that decision that there's been very few dams built in Australia, and I'll back dams any day over desalination plants for two reasons. A, you can get the sort of renewable power I do support, which is hydropower, number one, and you will get irrigation as well. And in this country, we need water security desperately because we do have a hot and dry climate, and we can't sustain a rising population unless we learn to control our water. And that's been, the whole basis of civilisation was founded around the fact in the Middle East and those places in the Indus Valley. It's no coincidence that civilisation was built around the river systems of the Indus Valley, Mesopotamia with the great Tigris and Euphrates rivers, and of course the Nile and the Yellow River and the Yangtze River, because these places were used as irrigation. People were able to, the communities at the time were able to secure their food supply, and as a result of that, you went from hunting, gathering to actually farming, and then people could go from farming into the cities where they could go and specialise further into trades. And if Australia wants to continue to grow and prosper, we desperately need irrigation in this country. Which actually brings me to one of the things that I spoke about in this motion, is actually looking at a way which we can fund infrastructure in this country, because all state governments don't have the privilege, what is known as exorbitant privilege. They don't have their own currency. That is the domain of the federal government. But we should draw some inspiration from Lachlan Macquarie, who did understand the art of exorbitant privilege and the right of any country to control its own currency. And that is actually one of the key responsibilities of any country, to control its currency. And we need to look at having an infrastructure bank to help the state governments, fund the state governments to build infrastructure. Because at the moment, state governments, if they want to build a dam for $1 billion, they have to go and borrow that $1 billion, generally from offshore, and then the first $1 billion they make in wealth from that dam, they have to repay offshore. And really all they're doing is when they're borrowing money from offshore, the biggest market in the world is the Eurobond market, which is all the Treasury US dollar bills that get traded around the world outside the US. That money just came from the US printing press. And it's ridiculous that we pay another country to use their printing press and when we should be doing it ourselves in a constructive manner by issuing infrastructure bonds. And this is one of the biggest mistakes that people in the Western world make, and we were taught this through university, is the art of exorbitant privilege is to be able to tap the nation's untapped wealth. What we have in this country, we've got 7 million square kilometres, we have this thing called untapped wealth. Every time it rains, that is free wealth falling out of the sky. Every time the sun shines on the soil and we have plants growing, that is free, recurring wealth every time. We need to secure that untapped wealth against the title that our forefathers fought for and built over the years, because that is the definition of a sovereign country. It is title over your untapped wealth. And that is the true art of exorbitant privilege, is to secure that untapped wealth for our children by issuing infrastructure bonds against the 7 sovereign assets. Many of these are built by state governments. They need a funding facility so that they can capture the wealth and not the foreign banks. So we need to have, in summary, we need a Federation Convention to look at reducing the bureaucracy, reducing costs to the taxpayer, streamlining regulation so that we can increase productivity, and finding a way to help fund state governments and federal governments build the infrastructure that delivers recurring revenue to pay for the recurring costs of our schools and hospitals on a sustainable manner so that our children and all Australians can have a better, prosperous future.
Senator Brockman.
Thank you, Mr Deputy President. Well, I too rise to speak on this motion. I thank Senator Rennick for putting it forward. There's, I think one thing you know about Queenslanders and West Australians in this place is we tend to be the committed federalists in the building. West Australians were strong federalists at a time when we probably needed a bit of financial assistance from the Commonwealth Government, and remain committed federalists at a time when we are certainly net givers to the federal economic situation, whether that's through the GST or whether it's through the extraordinary tax revenue and royalty revenue that flows from our great mining industry. But the issue Senator Rennick highlights here is one that we should never take for granted, and that is the health of our democracy, the health of our structures and systems, the health of our federation. Because I think many of us who have been in and around politics for a number of decades know that these discussions about waste and duplication and inefficiency, the lack of clarity between the roles and responsibilities of the Commonwealth Government and the states, the blurring of the lines, the tendency for Commonwealth to creep into areas that were, quite frankly, quite clearly not part of its purview when the Constitution was drafted. And there has been a slow drift. There has been occasional huge lurches in that process through High Court decisions or through, as Senator Rennick outlined, the handing over of particular powers to the Commonwealth governments by agreement from the states. But that doesn't mean that this is a set and forget federation. We cannot think that the discussions that were held over 120 years ago now should be the final word as to the health of our federation and the structures of our federation. I think Senator Rennick highlighting the possibility, I mean, this, when it's all said and done, is a referral to the Legal and Constitutional Affairs References Committee for an inquiry. And I think that is what this chamber has a responsibility to do. We've seen a tendency in this place in recent times, particularly in the last year, for the Labor, particularly in combination with the Greens, to block what I see as quite legitimate and uncontroversial inquiries, such as the inquiries of the transmission lines through particularly agricultural property that are going to be a significant part of the proposed future rollout that the Labor and the Greens are championing of renewable energy. That was quite a reasonable inquiry put forward by Senator Cadell, who's in the chamber at the moment, and Senator Colbeck, put forward a number of times. How many times did we get up to, Senator Cadell? 10? 9? 9 times that inquiry was put to this chamber, and 9 times Labor and the Greens and the crossbench combined to block what was a perfectly reasonable inquiry. And so I see here from Senator Rennick a perfectly reasonable thing to inquire into, consideration as to whether a Federation Convention should be considered, to look at some of the issues that have been identified over many decades as being at least a question mark over the efficiency and strength of our federation. And one of these issues has just been laid absolutely bare in the last few weeks, which is the overlap of federal-state jurisdictions on mining approvals and the lack of clarity that provides to the industry. When you've got Regis, a listed Australian company, one of the largest Australian gold miners, who spends $193 million and 7 years going through all the state approval processes and through all the federal approval processes, only to have the decision, an arbitrary decision from a minister, overrule the project at the 11th hour, shows that these systems are not at all as efficient, clear, transparent, reasonable as they should be. I mean, the fact that companies have to go through those dual processes that we know, if anyone in this room who talks regularly to major project proponents knows that the approval time for projects has blown out from 2 to 5 years to 7 to 12 years, and sometimes even beyond that for much more significant projects. And this is the fault of systemic problems that see state approval processes intersect with federal approval processes, the delays and confusion that results from those approval processes, overlaid then with another layer of arbitrary decision-making that we've seen from this government in particular in recent days. So I think Senator Rennick's motion clearly raises issues which are of concern, they are of interest. We saw the very long, protracted debate over GST sharing arrangements, where my home state of Western Australia was on track to receive cents in the dollar of GST revenue raised in WA, cents in the dollar. And it took a coalition government to fix that issue in the face of Labor state and Labor parliamentarians in this place saying it couldn't be fixed, couldn't be done, absolutely impossible. Of course, the Liberal government did fix it, championed by particularly the Liberal members of Parliament in this place, to put in place a 75-cent floor in the GST sharing arrangements. But should that be the last word? I mean, from my point of view, that should be the lowest we possibly see in terms of that 75% floor. But what Senator Rennick here is proposing is an examination of other funding streams to the states and the way in which the Commonwealth Government interacts with the states on that basis. So I think the motion is one that deserves our support. It's a perfectly legitimate motion, and we should allow the Senate Legal and Constitutional Affairs References Committee to look into this matter. Thank you.
Senator Roberts.
Thank you, Mr Deputy President. Through you, I thank Senator Rennick for his motion. I compliment his intellect and understanding, his technical and financial and historic and understanding of history. I'm going to read the motion because I think it's fitting. This is a very significant motion that I will be supporting. The motion reads, to move that the following matter be referred to the Legal and Constitutional Affairs References Committee for inquiry and report by 10th of December 2024. The benefits of conducting a federal convention to examine the ambiguous roles between the state, territory and federal governments, considering but not limited to the following issues. I'll go through those issues and respond to each in turn. So I will deal with the terms of reference. I want to point out something that Senator Brockman just pointed out and add to it. Systems drive behaviour, and behaviour shapes attitudes. The combination of behaviour and attitudes plus values, plus symbols, plus leadership shape culture. But systems are enormously powerful driver of culture. And culture, as we all know and increasingly understand through business and other organisations, is fundamental to productivity, fundamental to safety, fundamental to quality, fundamental to security. Culture is crucial. Think about, as I go through these terms of reference and make some points, think about, please, the systems and the behaviours that are driving, and the culture, because our culture is falling to bits in this country. And think about productivity, which is the key to wealth creation. I'm going to read some figures here from the Australian it's from a paper entitled The Australian Precedents for a Hamiltonian Credit System. Page 15, a paper presented to Cabinet calculated the value difference, the value added, in exporting aluminium ore, bauxite, versus processed aluminium in 1970 dollars. I'll convert to 2022 dollars. Exporting 1 million tonnes of bauxite, the raw material, earned $65 million. Processed one step into alumina, earned $355 million, 5.5 times as much for Australians. Processed again into aluminium, earned $1.6 billion, 25 times the cost of the price of the ore, the value of the ore. Processed finally into aluminium products, it earned $7.8 billion. That's 120 times. You can see that the wealth has been created. Instead of just mining red dirt on Weipa, on Western Australia and other places in the country, and shipping it overseas, if we process it here, we can generate enormous wealth, almost $8 billion worth of wealth instead of 65 million. Terms of reference, number A, the need to streamline the duplication of bureaucracies to save billions of dollars in bureaucratic waste and reduce unnecessary regulations. Look at the Health Department and the Education Department, duplicated at state and federal level. Complete waste of money. Worse than that, destroys accountability. Because when there's a problem with education, the federal point to the states. When there's a problem with education, the states point to the federal, and nothing happens. There's a culture of blame created. Think about the behaviours and the culture developed under this kind of system. We need to get rid of that, streamline the bureaucracies, end the duplication to improve productivity. And government productivity in the government sector is abysmal in this country. We're shutting down the private sector, which has got high productivity and generating enormous wealth, and crippling it with transferring it to low productivity. I read the second term of reference, B. The lack of accountability and transparency between the state, territory and federal governments. And this goes to the heart of the problem. I listened to a mayor, a wonderful mayor dedicated to his town. He pointed out to me, the federal government has the money. The states have the power through regulations and legislation because the Constitution has handed them the power for most of the services provided by government. So I'll say that again. The federal has the money, the states have the power, and the local councils have the problems. Now, councils have got accounting system problems in terms of inadequate, the council systems, accounting systems drive inadequate behaviours. But the councils depend upon grants, which can only be sometimes 3 years in advance, 5 years in advance, which means that councils, local councils, do very little in the way of long-term planning. They can't. But the federal government, our fathers of the Constitution, our country's forefathers, pinched an idea from America, competitive federalism, which basically means sovereign independent states are competing with each other to provide the best services or the most efficient services. And the same thing has happened here, and that drives accountability, because if a state does poorly in something, people leave the state and go to somewhere else. If a state does well in something, people come to that state. As Joe Bjelke-Petersen, Premier of Queensland, when he abolished death duties, we saw people around Australia flock to the Gold Coast because when they died, they could leave their money to their children. And what happened? With that improvement, other states did the same because they lost people if they didn't. So a market of competitive federalism is a marketplace in governance, and that's what we need, because at the moment we have a central domination of our system, just like America has sadly evolved into, a central government domination, there's no marketplace in governance. There's very little accountability. The states blame the federals and the federal blame the states. So we need a marketplace in governance to be restored. Australia, 120 years ago, was the world's wealthiest country in terms of per capita income. We need to get back to that. We have the resources. We have the best resources in the world. We have great people. The education system sucks, but we can get back to a proper education system. We need to restore accountability. We need to bring back competitive federalism. And these terms of reference so far are on the right track. Terms of reference C, the need for state and territory government to raise their own revenue to reduce their reliance on federal government funding. Completely agree. We used to have the right of states to raise income tax. That was taken as a war measure in 1942 or 43 by the federal government and hasn't come back. I would suggest that we need to seriously look at making sure, as the terms of reference says, that we strip the federal government of income tax powers and give it back to the states. Let the states be accountable for what they raise and for their interest rates. At least have the debate. When the state raises money, it's accountable for its spending. If it needs to go to its taxpayers for more, then let the taxpayers make up their mind, the voters. This would bring real accountability and significant productivity improvement. Significant productivity improvement. Terms of reference D, the need for federal grants and goods and services tax allocations to state and territory governments to be much more transparent, efficient and effective. Wholeheartedly agree. We need comprehensive tax reform to make the GST transparent. Why not just have comprehensive tax reform to see whether the GST can't be abolished and replaced with a far more productive system? Because under the GST, states like Western Australia generate the majority of the revenue, and states like South Australia and Tasmania are on the tit for money. They don't have to produce. They don't have to be productive. They don't have to develop their resources. They don't have to take accountability. And Queensland, I'm sad to say, at least a couple of years ago, one of the wealthiest states in the world, was a net recipient of GST. That's an absolute disgrace. And that's because of the Beattie, Bligh, Palaszczuk, Miles governments that have destroyed budgets, destroyed the economy in Queensland and exacerbated the revenue and created so much waste. So why not have the states raising the tax? At least have a discussion. It's not the states raising the tax in addition to the federal, it's instead of the federal government raising income tax. And then actually have the state governments determine how much they will share with the federal government. Accountability and productivity again. Then we go to terms of reference E, the need for the implementation of coordinated infrastructure funding facility to provide capital for sovereign infrastructure. Long-term plan, wouldn't that be wonderful? Councils, state governments, federal governments, long-term plans. Streamlining approval processes. And what about the project that I've introduced into the Senate? It wasn't my idea. It was Lang Hancock's and maybe even someone before him in Western Australia. But Project Iron Boomerang. Restore Australia to be a significant player of high quality, high value added steel and one of the biggest producers of steel in this world. And we've already got, according to the proponents of the project, significant interest from Japan, Korea, Taiwan, Communist China and Indonesia and potentially India, Saudi Arabia in that project. Because instead of sending ships loaded with our dirt from Western Australia and our coal from iron ore dirt from Western Australia and our coal from our east coast in central Queensland, we would send coal to the west coast and make steel out of there, mixing it with the iron ore, and send iron ore to the east coast and make steel there at Abbott Point. So we would have up to 10 steel mills at each end, which would make us a significant producer of steel, which would add productivity to us, add value to us, add security to us, add accountability and wealth generation, enormous wealth generation. So as Senator Rennick said, we can convert nature's blessings into products and services that are meeting people, that will meet people's needs. Why ship our raw materials overseas so someone else can make the value added? We need to do that here in this country. And connecting the West Coast with the East Coast and having steel mills at both ends with a railway line would make it very productive and open up the whole of Central Australia, the whole of North Queensland, the whole of Northern Western Australia, and give the communities in those remote areas access to water from a pipeline, access to communications, access to a railway line, eventually bringing tourists and investors from around the world and exporting products to the rest of the world. Looking at terms of reference F, the need for the Corps of Royal Australian Engineers to take responsibility for building and maintaining all national land transport road networks. I'm not so sure about this because it doesn't comply with the true federal system. States need to retain responsibility and accountability. But we need the debate. We need to start that debate, and that's what I compliment Senator Rennick for on raising this. We need to also consider the use of data in our federal government. Data is ignored, contradicted, twisted, misrepresented in this country, and this federal government in particular, federal parliament in particular. We need to get back to governance, good governance through the use of data for making decisions. And I just take this opportunity, I've mentioned it to one or two senators in the place here. Why don't senators sit in state groups? Because this is not only the House of Review, it is the state's house. It's to protect the states. So for those reasons, and above all, to start the debate on how we can improve our country and restore our country to be productive so that all Australians can be wealthy. I commend Senator Rennick for moving this motion, and I will be supporting it.
Are there any other contributions to this debate? Minister.
Thank you, Deputy President. I thought I might present an alternative perspective on the world for the people of Queensland and from the people of Queensland, and an alternative perspective from the Labor Party. The government will be opposing this motion, although I congratulate Senator Rennick on introducing his first motion as a newly independent senator. I am looking forward to some of the freestyle policy that we're going to get from Senator Rennick. It'll certainly liven things up around here. But I regret to say that we will be opposing this motion. The Albanese government is committed to working cooperatively with states and territories, which is why we've already managed to deliver significant reforms in the national interest. Just last week, National Cabinet agreed to a landmark $4.7 billion package to end violence against women in a generation and strengthen legal services. This will deliver much-needed support for frontline specialists, better identify and respond to high-risk perpetrators, and address the role that systems and harmful industries play in exacerbating violence. This is the biggest investment by any federal government in legal services in our nation's history. Last year, National Cabinet announced a $3 billion new homes bonus to incentivise states to build homes faster and secured a better deal for renters. This sets our ambitious goal to build 1.2 million homes and develops a nationally consistent renters policy, including phasing in minimum rental standards. This year, $1 billion was paid to states and territories to build the roads, sewers, energy, water and community infrastructure that we need for new homes and for additional social housing supply. In health, National Cabinet agreed to a further $1.2 billion package of strengthening Medicare measures to take pressure off our hospitals. This will grow and support our health workforce while reducing unnecessary presentations to emergency departments. We also boosted funding to Medicare urgent care clinics, and last week we opened our 75th clinic. Last week, the Commonwealth reached a historic bilateral agreement with the Cook Government in Western Australia to fully and fairly fund Western Australia's public schools. This will ensure all WA schools are funded to 100% of the schooling resource standard by 2026, and this follows similar agreements reached with the Northern Territory Government. Following the tragic event at Weambilla in Queensland, National Cabinet reached landmark agreement to implement a national firearms registry. This will allow police to know where firearms are, who owns them, and what other risks to the community and police may exist. This is the most significant improvement in Australia's firearms management systems in almost 30 years and was the result of good cooperation between the Commonwealth, states and territories. And this initiative is led by the Attorney-General's Department and the Australian Criminal Intelligence Commission, working alongside state and territory governments. Our governments, federal, state and territory, will continue this good work, and therefore we will be opposing this motion.
I intend to put the question. I put the question. Those for the question say aye. Against no. I think the noes have it. You wish division required? A division is required after 6:30, so it will be deferred until tomorrow. Clerk.
Government Business Order of the Day number 1, Australian Human Rights Commission Amendment Cost Protection Bill 2023, resumption of second reading debate.
I believe, Minister, you're going to sum up the debate for us. Well, that was my understanding, but I might be wrong.
I was just going to clarify. I remember Senator McGrath spoke very briefly on this and said he was in continuation, but I presume he's not intending to continue. Okay. All right.
You had the call, Minister.
Thanks, Deputy President. This bill that has been debated today, and I think, in fact, the debate commenced yesterday, will implement the objectives of Recommendation 25 of the Respect at Work report by alleviating a significant barrier to justice for those pursuing federal unlawful discrimination proceedings. It will do so by inserting a modified equal access costs protection provision into the Australian Human Rights Commission Act. This reform would overcome the deterrent effect that an adverse cost order currently poses to applicants seeking to commence unlawful discrimination proceedings and provide certainty for all parties as to how costs could be awarded. This bill would address the power imbalances and resource disparities present in most unlawful discrimination proceedings. It would ensure that where an applicant is successful on one or more grounds, the respondent would pay the applicant's costs. However, if the court is satisfied that a successful applicant's unreasonable act or omission caused the applicant to incur costs, the court is not required to order the respondent to pay the costs incurred as a result of that act or omission. This bill would prevent a court from ordering an applicant to pay the respondent's costs, except in certain defined and limited circumstances. These exceptional circumstances include where the respondent has been successful in the proceedings and is not at a significant power or financial advantage over the applicant. These modifications to the equal access model ensure the bill strikes an appropriate balance between protecting applicants and helping to overcome the financial deterrent to them commencing proceedings and recognising where this would not be reasonable or fair. I thank the Senate Legal and Constitutional Affairs Committee for their considered inquiry and report on the bill. The government has implemented the Senate Committee's recommendation to provide further guidance on the term unreasonable act or omission through an addendum to the explanatory memorandum. This will provide further certainty for all parties involved in federal unlawful discrimination proceedings that a holistic approach must be taken when making such determinations. I also welcome the Senate Committee's recommendation that, subject to this change, the bill be passed. The government considers that the modified equal access cost protection provision in this bill reflects a considered and balanced approach which best achieves the policy objectives of Recommendation 25 of the Respect at Work report. And on that basis, I commend the bill to the chamber.
I intend to put the question. I put the question. The bill now be read a second time. Those for the question say aye. Against no. I think the ayes have it. Division required. A division is required, but we're after past 6:30, so it's deferred.
Sorry, Deputy President, it was remiss of me. I forgot to table the addendum to the explanatory memorandum relating to the Australian Human Rights Commission Amendment Cost Protection Bill 2023. The addendum responds to matters raised by the Legal and Constitutional Affairs Legislation Committee.
That can be tabled. So as we cannot go into the Committee of the Whole, as I understand there are amendments, we now come to the next bill, so I'll call the clerk.
Government Business Order of the Day number 2, Taxation Multinational Global and Domestic Minimum Tax Bill 2024 and 2 other bills. Second reading debate.
Senator Dunningham.
Deputy President, I rise to speak on the Taxation Multinational Global and Domestic Minimum Tax Bill 2024 and its 2 associated bills. The Coalition supports continuation of the OECD 2-pillar process on multinational tax avoidance, a process the former government initiated and is now being continued by the Labor government. Working with like-minded nations in international forums like the OECD is critical to ensuring that multinational corporations from all jurisdictions pay what is their fair share of tax and contribute to the countries in which they operate. The Coalition took extensive action over our 9 years in government to address multinational tax avoidance. As the host of the 2014 G20 summit, Australia played a leading role in the original OECD G20 Base Erosion and Profit Shifting, or BEPS project, which was initiated in 2013 and delivered in 2015. Under the Coalition's leadership, Australia adopted the OECD G20 BEPS recommendations, which established a multilateral approach to preventing tax avoidance and increasing tax transparency for tax administrators. At the time, the Coalition government implemented several key measures, including the introduction of the Diverted Profits Tax, the DPT, which limits the company's ability to shift profits outside of Australia. We also introduced the Multinational Tax Avoidance Law, the MAAL, ensuring that companies cannot avoid a taxable presence in Australia. We also strengthened the thin capitalisation rules, improved transfer pricing rules, doubled the penalties for tax avoidance and established the ATO, Tax Avoidance Task Force, in 2016. The ATO Task Force was designed to enforce existing laws and support new government measures aimed at preventing tax avoidance, and between 2016 and 2021, the ATO raised $24.2 billion in tax liabilities against large public groups, multinational corporations and privately owned wealthy groups. This effort generated collections of $17.3 billion. It's critical that we continue to pursue fair and consistent tax rules, not just within Australia, but also with like-minded nations around the world. This is exactly what we're doing through initiatives like the OECD 2-pillar solution in collaboration with our international peers. We commend the Labor Party for following our lead and continuing this important work. However, while we support these efforts, it's important to recognise that the current government has not fully delivered on its promises. At the last election, Labor made a clear commitment that its sole focus on taxation would be in addressing multinational tax avoidance. Yet, despite this promise, they've failed to follow through on even that basic commitment. Labor's handling of country-by-country reporting and changes to thin capitalisation has been nothing short of shambolic. This policy incompetence of the Assistant Treasurer has been so glaring that at least once he needed his senior minister, the Treasurer, to intervene and fix his harebrained schemes. Labor, led by the Prime Minister and the Treasurer, assured Australians that there would be no tax increases beyond working with other countries to make multinational tax regimes fairer. But as we've seen, this promise was not worth the paper it was written on. Labor's pledge to focus solely on multinational tax avoidance has well and truly been broken. Instead of keeping their word, Labor has raised taxes in several key areas that will have an impact on the lives of everyday Australians. Labor has increased taxes on superannuation, capturing 1 in 10 Australians over time. And according to Treasury modelling, young Australians earning average wages today will be subjected to this tax. This is also a new tax on unrealised capital gains, unprecedented in our tax system. This is an assault on family-owned businesses and self-managed super funds, undermining the financial security of hard-working Australians. In addition, Labor has targeted franking credits, banking $500 million in taxes from Australian companies, retirees, super funds and also charities. This is a direct attack on the financial well-being of those who've worked hard and planned for their future. Labor has also ended small business tax concessions, dramatically reducing the instant asset write-off that so many small businesses rely on to invest in their operations and to grow their operations, and failing to provide certainty due to their continued legislative mismanagement. Higher taxes will not help address the cost of living crisis that so many Australians are facing, and higher taxes will not solve the problem of anaemic economic growth. Higher taxes, of course, will not reverse the collapse in productivity that we're witnessing under this Labor government. Our economy is shuddering to a halt. Personal income taxes have risen by 20%, thanks to bracket creep. Prices are up by 10%, and for working households, prices have increased by over 18%. Real wages have collapsed by 9%, and living standards have fallen by 8%. Household savings have dropped by 10 percentage points also. Australia is now trailing behind our peer nations, and a family with a typical mortgage of $750,000 is approximately $35,000 worse off. This is in no way responsible economic management. Labor's higher spending, higher interest rates and higher taxes, coupled with the additional $315 billion of spending across 3 budgets, have left Australians far worse off. Their broken promises on taxes, including on superannuation, franking credits and small businesses, have only added to this immense pain. The changes to the multinational tax arrangements in this bill do not make up for Labor's attacks on aspirational Australians. These changes do not compensate for Labor's inaction on inflation. They don't address the impact of rising interest rates on Australian households, nor do they undo the harm caused by Labor's tax policies. Australians deserve a government that is focused on the challenges they face today. And while the Coalition will not oppose this legislation, we will not apologise for holding this government to account for their broken promises on tax, their failure to take meaningful action on productivity, and their lack of focus on fighting inflation. We need a government that prioritises the economic well-being of all Australians and takes real steps to address the cost of living crisis, improve productivity and, importantly, to restore confidence in our economy. In conclusion, while we support the continuation of efforts to tackle multinational tax avoidance, we can't ignore the broader economic challenges facing our nation. Labor's broken promises and misguided policies have left Australians worse off, and we must continue to hold them to account. Our focus must remain on creating a fair and prosperous Australia where everyone has the opportunity to succeed.
Senator McKim.
Well, thanks very much, Deputy President. I rise, obviously, to speak on the Multinational Global and Domestic Minimum Tax Bill 2024, and I can inform the chamber that the Greens will be supporting this legislation. And we'll be doing so for a range of reasons, but in the main because it aligns Australia with the 2-pillar solution, which has been agreed by the OECD and the G20. And that 2-pillar solution, of course, seeks to reform international taxation rules to improve the taxation of multinational corporate profits. But I do want to say that we think this bill should be going far, far further than what is proposed in this legislation, and also Labor should be doing much, much more to make big corporations pay their fair share of tax in this country so that we can invest in programs and supports for people like, for example, putting dental and mental health into Medicare. I'll have a bit more to say about the things that Labor could be doing to make big corporations pay their fair share of tax in Australia, but are not doing, of course, because they accept obscenely large political donations from those big corporations, including the big supermarket corporations, the big fossil fuel corporations, the big gaming corporations, and the list goes on. This bill implements internationally agreed rules to ensure that multinational corporations with an annual global revenue of 1.2 billion Australian dollars or greater are subject to a global minimum tax rate of 15%. Putting a floor on the global tax rate for large multinationals is a good thing, and that is one of the reasons the Greens will be supporting this bill. If a multinational entity has a parent or subsidiary company based in Australia but relies on an international tax haven to pay less than 15% at a group level of tax, Australia will be able to apply a top-up tax. Now, while this represents a small step forward in addressing the profit-shifting behaviour of big multinational corporations, it needs to go much further. In Australia, our corporate tax rate is 30%. Fixing a global minimum corporate tax rate of half of Australia's corporate tax rate is far too little. 15% is close to the soft rates charged by tax havens like Ireland, Switzerland and Singapore. It'll do little to end the damaging race to the bottom on corporate tax or to rein in the widespread use of tax havens. The bill is set to increase tax receipts by $370 million over the next 5 years. Now, that is a good thing, but let's be clear about this. When you take the massive multinational corporations that operate in Australia as a collective group, including things like big pharma companies, big tech companies, that represents a very small drop in the ocean of the profits that those companies extract from our country and from our people every year. So we urge Labor to use its position as a member of the G20 and the OECD to advocate for a global minimum corporate tax rate of 25%, which is far closer to Australia's corporate tax rate and is about the weighted average of OECD countries. Now, Labor's not going to do that, we know that, because they are a party beholden to the oligarchs and the big corporations, but that is what Labor should be doing. If we set the global minimum corporate tax rate at 25%, that would be a far more effective that would far more effectively reduce the incentive for corporations to artificially inflate the amount of deductible expenses in high tax jurisdictions. It's also the rate that organisations including Oxfam, the Tax Justice Network and the Centre for International Corporate Tax Accountability and Research have tirelessly advocated for, including in their submission to the inquiry on this legislation. And I want to thank those organisations for that tireless advocacy, for their important work at both a national and global level to reform our tax and financial systems, to address corporate greed, to make corporations pay a fairer amount of tax so we can put in place supports that would reduce economic inequality in Australia and would help people who are being crushed at the moment by a cost of living crisis. Now, another issue with the two-pillar solution is that, of course, it favours wealthy countries with far less benefits for countries in the global south. This is because the right to apply a top-up tax is given in priority to the home country or countries of residence of the multinational corporation by applying an income inclusion rule, while the host country's right to top-up tax on profits at source is only a fallback. As a result, the two-pillar solution benefits countries where multinational corporations already attribute high levels of profit under current rules, jurisdictions which act as investment hubs or conduits for profit shifting. Estimates show that most Global South countries will gain little or no additional tax revenue directly from the global minimum corporate tax, and since its rules are highly complex and highly complicated, joining the scheme would not be cost-effective for most of those countries. So again, the Greens are asking Labor to increase its efforts to assist democratic governments in the Global South to obtain their fair share of tax revenue from the profits of multinational corporations doing business in their countries. And notwithstanding those concerns that I've raised, we will absolutely be supporting this legislation. But the aim here from Labor and from Labor's global advocacy should be to prevent the continuation and exacerbation of the present unfair and ineffective approach and maintain the momentum towards a more comprehensive reform that delivers more equity and fairness than the reform that we are currently debating. A fair way to do this would be would be based on unitary taxation of multinational corporations with apportionment based on where the corporations are actually doing business and not on their artificial legal structures. That is a proposal that's been advanced by the Tax Justice Network, and I commend them for the work they've done to develop that proposal and for their advocacy of it. A proposal like that could benefit all countries and multinational corporations alike by establishing a simple, effective and fairer system for multinational corporate taxation. We want to see Labor go further. We want to see them go beyond the bare minimum and use their power on the international scene to advocate for strong international tax reform that would rein in the profit-shifting behaviours that we so often, far too often, see from multinational corporations and deliver benefits not only to Australia but countries in the global south who are going to disproportionately miss out on tax revenue from big multinational corporations that they are due under that they are due. Now, I also want to take this opportunity to talk about corporate tax in Australia and the things that Labor should be doing but isn't doing because of the institutionalised bribery of political donations. Labor needs to crack down on corporate profiteering and it needs to act to make corporate price gouging illegal. Now, the ABS, the Australian Bureau of Statistics, has collected data since 1960 on the share of the economy that goes to profits versus the share of the economy that goes to wages. And in the 64 years of collecting this data, corporate profits have never been higher as a share of the economy than they are today, and wages as a share of the economy have never been lower. Think about that for a minute, colleagues. It means the corporations are making off like bandits to an extent that they never have been before, since this data was collected well over half a century ago, and workers, people who go to work every day and earn a wage, they've never been receiving less share than they have since this data started being collected 64 long years ago. The corporations are doing very nicely in this country, thank you very much, and the workers are doing terribly. And it's because governments of both political stripe over the last 50 plus years have been far more interested in acting on behalf of corporations than they have on acting on behalf of wage earners and ordinary Australians. Corporate profits at record highs, money flowing to corporate profits has never been higher, and people are being crushed by inflation and the RBA's response, which has been to engage in a record series of interest rate rises. The lived experience of Australians who are currently struggling to make ends meet, currently struggling to put food on the table, currently struggling to afford to pay their power bills, currently struggling with rent increases and interest rate rises which are smashing mortgage holders, that is borne out in some of the data that we are seeing. The big banks are raking in billions of dollars in profit. They are rewarding their CEOs with multi-million dollar annual salary and bonus packages. Corporate profits as a share of the economy have never been higher. Wages share of the economy has never been lower. A third of the top 100 largest corporations in this country pay no tax at all. Corporations are price gouging Australians. Their profits are going through the roof and millions of Australians can't afford to put food on the table or pay their rents or keep up with their skyrocketing mortgage payments. Corporations are price gouging and it is ordinary people who are being smashed as a result. Now, what Labor should be doing is backing in the Greens on our big corporations tax package that we are taking to the next election as policy. Now, taken as a whole, the Greens corporate tax package will raise $514 billion over the next decade. It includes a big corporations tax that will impose a 40% additional tax on excessive profits that would raise $296 billion over the decade. It includes a revamped tax on offshore oil and gas to close the loopholes in the PRRT, which, as it currently stands, is one of the greatest tax rorts for big corporations in Australia's history, arguably the biggest tax rort that big corporations have ever enjoyed. The other significant component of our big corporations tax is a 40% tax imposed on the super profits of fossil fuel mining projects, with an exemption for new and vital sectors like lithium and nickel that are essential in terms of the renewable energy investment that we need to see in Australia. That tax will raise $107 billion and will ensure that everyone in Australia benefits from the resources that mining companies are extracting. And we could use that $514 billion, that over $500 billion over the next decade, that the Greens will raise from our big corporations tax package to actually help people who are getting smashed with the cost of living. We could afford to build public housing so everyone can have access to a secure and affordable home. We could put dental and mental health into Medicare. We could make university genuinely free, like most people in this chamber who've got a university degree got to enjoy free university when they were at university, whereas now Labor is allowing HECS fees to grow faster than a lot of people can actually afford to pay them off. It's well beyond time that Labor started backing in the interests of the Australian people over their corporate political donors. Well beyond time. It's time that corporations paid their fair share of tax so millions more Australians can lead a more dignified life. It is outrageous that about a third of the top 100 earning corporations pay no tax at all, less tax than a nurse or a carpenter or a teacher. It is an absolute, utter disgrace. Labor must do better.
Senator Walsh.
Thank you, Acting Deputy President. Well, we are a government that takes multinational tax reforms seriously, and we are getting on with practical reforms and practical progress. And indeed, it would be fair to say that there hasn't been a government in Australia that has done more to reform multinational tax than this one, led by Assistant Treasury Minister Andrew Leigh. Our reforms are about making sure that multinationals pay their fair share of tax in Australia and around the world. Our reforms are about shining a light on the tax affairs of some of our largest multinational companies, because we know that greater transparency brings greater corporate responsibility and greater compliance too. These are sensible reforms. They are about lifting standards to meet community expectations, and they do just that. Importantly, they are not being done in isolation. The rest of the world, off the back of the OECD's work, is getting on with the job of implementing these very same reforms too, making sure that in Australia, in developing nations and right across the world, companies benefiting from the economies that they are operating in are giving back to those economies and those societies too. These bills are just the next step in our government's agenda to deliver on our commitments. They legislate the powers necessary to allocate top-up taxes where companies have not paid at least a 15% rate of corporate tax. That can be in Australia or in another jurisdiction. In effect, this sets a global floor on corporate taxes, directly addressing the race to the bottom of corporate tax, ensuring that when companies may be doing the wrong thing, when they may be shifting profits to avoid paying their fair share of tax, that there is a multilateral approach to correcting that. The Senate Economics Committee held an inquiry into these bills, and the committee heard just how important it is for Australia to be one of the leading jurisdictions on these global reforms, and what it will mean for lifting the standards of corporate taxes and reporting right across the world. The Tax Justice Network Australia urged the committee to support the passage of the bills through Parliament, and the Corporate Tax Association noted the significant milestone these bills represent in delivering the OECD's multilateral changes to global tax laws. The Economics Committee agreed to recommend that these bills pass. And these bills complement a series of reforms that this place has already passed, delivering on the government's election commitments to reform multinational taxes and to ensure that multinationals are paying their fair share of tax. These reforms include important changes to how thin capitalisation rules factor in debt. They include new anti-avoidance rules to ensure that artificial debt isn't being created for the purposes of writing down tax liabilities. They include a requirement for publicly listed companies to include detail on their subsidiaries, including where in the world they are and how they operate. And also before the Parliament is country-by-country reporting, a really important tool to lift the transparency and reporting standards of these large companies. This will require large companies to report publicly where they are doing business, where they are making their money, and where they are paying, or indeed not paying, their share of taxes. So, in conclusion, taking this suite of bills together, these reforms are making really important changes to the amount of tax that multinational corporations are paying in Australia and right across the world. They are part of global reforms to boost the transparency and accountability of multinational tax affairs. And in Australia, our package of reforms will boost revenue by around $1 billion over the forward estimates. So these bills should be commended, and I welcome the Parliament's support for them. I welcome the support of the Greens and the Coalition, as we've heard this evening, and I thank everyone for the work that they have done in championing these reforms and helping to usher them through the Parliament.
Senator Polley.
Thank you very much. I rise tonight to make a contribution on the Tax Multinational Global and Domestic Minimum Tax Bill 2024. This is one part of a three-part package of bills which seeks to reform our taxation system, which, if passed, will apply to fiscal years on or after the 1st of January 2024. These bills enable a 15% global minimal tax and domestic minimum tax for multinational corporations operating here in Australia, with an average global revenue of 1.2 billion Australian dollars. The Albanese Labor government is deeply committed to ensuring that everyday Australians are taxed fairly. In the last month, we have provided and a little longer than that now, in fact, we've actually ensured that a really fair tax cut has gone to all Australian workers, every Australian taxpayer, ensuring that more of what they earn actually stay in their pockets. The Albanese Labor government is 100% dedicated to fairness and equality in every aspect that a federal government is involved in. That is why we also want to ensure that the big end of town, big business, multinational companies pay their fair share of tax. We luckily have a very robust corporate taxation system here in Australia, where multinational corporations must pay their fair share of tax. Since coming to office just 2 years ago, the Albanese Labor government has already delivered 4 significant and integral multinational tax reform measures. We have introduced a new disclosure law which requires listed and unlisted public companies to disclose information on the number of their subsidiaries in their country of tax residency. Really important. This creates more transparency in how companies are structuring their subsidiaries, and help prevent corruption and abuse of the legislation. The second fundamental reform the Albanese Labor government has made in the area of multinational taxation legislation is the implementation of a public register of beneficial ownership, which makes information more transparent relating to who specifically benefits from profits made by multinational corporations and who holds ownership. The third fundamental part of our multinational tax reform is strengthening the way our foreign investment system reduces the risk of multinational investors trying to dodge tax. We have delivered a stronger, more efficient, more productive and more streamlined approach to foreign investment. The Albanese government has delivered a funding boost for Australian Taxation Office Tax Avoidance Task Force in the October 2022-23 budget by around $200 million a year. Our government, our Labor government, has bolstered crackdowns on multinationals dodging tax or avoiding paying their fair share of tax in this country. Furthermore, our government has introduced 5 further reforms for our multinational tax reforms. They include beginning a country-by-country reporting structure that has already been introduced to Parliament, but once introduced will implement reporting structures from July this year. These measures are all really important to ensure that multinationals are paying their fair share of tax here in Australia. The register, which will be implemented, is part of the government's commitment to integrity. We promise this. We went to the last election committing to having more open and transparency, integrity in everything that we do, and this is another area that we have delivered in, because we will not waver from our commitment on those principles. So fundamentally, this bill is about the Albanese Labor government ensuring that our taxation system is fair, transparent and has integrity. The entire purpose of our taxation system is to ensure that our country's government services are provided fairly, equitably, and the objection of this bill to provide that is no exception. This bill has provided our election agenda. It's actually delivering with more objections in relation to strengthening the way our foreign investment system reduces the risk of multinational investors avoiding taxation. I'd also like to pay my gratitude and thanks to the Assistant Minister for Competition, Charities and Treasury, the Honourable Dr. Andrew Lee MP, for his contribution to this very important piece of legislation. Tonight I'd like to urge those sitting on the crossbench to support this crucial piece of legislation to ensure that multinational corporations, both globally and domestically, are taxed fairly, because every Australian taxpayer needs to be treated fairly and there needs to be equitable outcomes for the pay-as-you-go taxpayer, multinationals, because that's the principle of what Australians really stand for. If we don't ensure that multinationals and individuals pay their fair share of tax, then no government, whether it's a Labor government or whether it's those from the other side, will not be able to deliver these services that we need. And we know on this side of the chamber as a Labor government that in terms of affordable housing, providing incentives to get people back into the workforce. That is always going to come from this side of the chamber. If we want a government that is going to be strong in supporting people in the care economy, like in aged care and in early childhood education, then they know that they have to support a Labor government. And to be able to do all these things, we have to ensure that people pay their fair share of tax. So I'm proud of the Albanese Labor government and what we have been able to achieve in a very short period of time to turn around and start cleaning up the mess left by those who were in government for 10 years that didn't address these multinational issues, making sure there's fairness in our taxation system.
You will be in continuation. Senator Hughes. Sorry, I do propose that the Senator adjourn. Senator Hughes, you have the call.
Thank you, Mr Acting Deputy President. I'd like to draw attention to a discussion paper which has been supported by AstraZeneca, which shines a light on the incredibly challenging reality faced by the estimated 10,500 Australians who are living with metastatic breast cancer. While the survival rate for Australians living with metastatic breast cancer has improved over the past 5 years, there is still a long way to go. With metastatic breast cancer, there is no end date for treatment and care. Metastatic breast cancer is currently an incurable, invasive cancer that is spread from the breast to other parts of the body. It often comes with a never-ending treatment, poor survival rates, and a sense of invisibility. 5 years from diagnosis with metastatic breast cancer, only a third of patients are still alive. The psychological and financial pressures of living with an incurable cancer are significant and unrelenting, and it's clear that these patients need greater support to help them get through their disease. The report that examines their plight is entitled Out from the Shadows. It's so named because in compiling the report based on local and international evidence, the overarching theme was that metastatic breast cancer patients experience, and indeed feel, an acute sense of invisibility in the health system, as well as in society more broadly. This is a conversation that's happening among oncologists, breast care nurses, academia, patient advocacy groups, the Department of Health and state-based cancer councils, and of course, among the most important group of all, the metastatic breast cancer patients themselves. Representatives of all these groups form part of a webinar that was organised to launch the report, which is a fantastic outcome, already given it proves the clear appetite for constructive change in this space. The report identifies 3 key priorities: greater visibility in the healthcare system, the presence of a louder voice specific to their cancer type, and increased psychosocial support. The esteemed oncologist Professor Fran Boyle, who wrote the foreword to the report, said it is time now to make urgent changes, counting them in cancer registries so we see them, providing platforms so their challenging stories can be heard, building quality information to guide them, and creating support and care that meets their specific needs. She also went on to say that specific care and support tailored to the stage of their cancer and access to psychosocial services is also imperative to meet their evolving needs. It's time to accelerate the momentum we've seen over the past few months for metastatic breast cancer patients so that these patients and their families can come out of the shadows and for us all to see, hear and support. Better psychosocial support is absolutely paramount to this. Currently, Australians with metastatic breast cancer can access just 10 MBS-funded mental health sessions per year. This is clearly inadequate. This number needs to be urgently revisited to ensure Australians get the access they need for this important care. There is also insufficient resourcing in the mental health sector, and additional training is needed for mental health experts to support Australians with metastatic breast cancer. Cassie, a 36-year-old from Newcastle in New South Wales, has shared her experience stating, she says, "When I tell people about my diagnosis, I often struggle with their lack of understanding about the differences between early and metastatic breast cancer. Colleagues and friends often ask me when I'll be in remission or if the disease will stop. But remission is like a mythical unicorn in our world, and I'm constantly haunted by the thought of cancer. Recognising the unique challenges and experiences of people like me with metastatic breast cancer as a separate group could bring huge benefits. We're more than our diagnosis. Many of us to continue to work and contribute to society, despite the physical and emotional toll of our condition. It's about creating a more hopeful and informed future, not only for ourselves, but for generations to come. And I'd just like to close with a quote from Emma, a 36-year-old mother in Victoria. Emma says, "I'm hopeful for a future with better support and more help for those of us with metastatic breast cancer, a future where we're equipped with the right information to tackle each day as it comes, living our lives to the fullest."
Senator Hodgkins may.
Thank you, Acting Deputy President. Today marks 58 days of the refugee-led encampment outside of the Department of Home Affairs in Melbourne. And it marks more than 12 years of lives lived in limbo for thousands of people. Last Friday, I spoke at the refugee-led 24/7 encampment. I addressed the families and children who have braved freezing weather, who have braved neo-Nazis, and who have braved 12 years of uncertainty through no fault of their own. I shared in their grief about lives cut short and lives damaged. Right now, more than 8,500 people who came here for safety over a decade ago are being denied a clear pathway to permanence that they need to rebuild their lives. They live in fear of being taken from the towns and suburbs that they call home. These are people in our communities, people that our kids go to school with, people that we work with, people that we volunteer with. And one of those people is Abbas, who shared his harrowing story with me when he came to Canberra to speak to politicians on behalf of the thousands of people living in limbo. I want to share Abbas's story with you. We came by sea and didn't know if we would survive the journey, but took the chance to seek a safer life. For the first few years, we were moved through detention centres until we settled in Melbourne. It felt like we had finally found home. But in late 2018, everything changed. Our protection claims were rejected. Then in 2020, while we were waiting for our appeal, COVID hit and things got worse. We couldn't get Medicare. We couldn't get work or any government assistance, and we struggled to pay rent. My dad also got really sick. He was mentally struggling. Eventually, he made the decision to go back to Iran, and it wasn't an easy decision. My dad was taken into custody by Iranian authorities. They beat him and left him cut and bruised. He has now been missing for 1 year. I can only fear the worst for what has happened to my dad and know that if I am forced to go back to Iran, this will be my fate. I don't understand why the Australian government has punished my family in this way. All we wanted was to be safe, to be together and to rebuild our lives. That is why I'm joining others to peacefully protest. It is our hope that the Minister for Immigration will stand up for better treatment of refugees and people seeking asylum. I want to thank Abbas for his leadership and acknowledge the shameful experiences that he and thousands of other people are facing. They went through a visa process that the government abolished because they determined that it was unfair. But now Labor is saying that those people who had their claims refused have no serious way to challenge them, despite them determining that that system was flawed. Ministerial intervention is inefficient and often takes many, many years. And to date, only a small number of people have had success with ministerial intervention. What is needed is a credible pathway to permanent protection, and that is exactly what the Greens will continue to fight for. To the protesters camped outside in Melbourne, Sydney, Brisbane, Adelaide and Perth, we see you, we hear you, and we will not stop fighting until there is a pathway to permanency for you and your families. The majority of Australians want to see a ban on harmful and destructive gambling advertising that is plaguing televisions, which was confirmed in yet another poll today. instead of adopting the recommendations from its own inquiry led by Peter Murphy, which called for gambling ads to be banned across all media and at all times, Labor continues to delay a decision. In my neighbourhood of Macnamara, community members are telling me that they're sick of being bombarded by gambling ads. Whether at the footy oval on the weekend, whether at the skate rink, or whether in their own living rooms, they are sick of listening to their kids reeling off the betting odds instead of the footy scores. They're sick of the constant inducements normalising the insidious gambling industry. And they're terrified about their kids joining the growing statistic of problem gamblers in this country. Today, I call on the member for Macnamara, where I live, to listen to the needs of our community and to publicly call for a complete gambling ban ad ban right now. It's time.
Senator Tyrrell.
Thank you, Acting Deputy. You know, smoking is something I'm very familiar with. My dad was a smoker, my sister was a smoker, my uncle was a smoker, my partner was a smoker, and I was a smoker too. You could say smoking was a bit of a family habit. I gave up my addiction to smoking after having surgery, but others in my family have used vapes to manage their addictions or give up altogether. The Tasmanian government has introduced changes around vaping that means you can only access vapes if you're over 18 and have a prescription from a doctor. I don't know about you, but I'm not sure how many doctors are going to write a prescription for something they think is harmful, addiction or no addiction. And don't even get me started on how requiring adults to have a prescription to access vapes means they will clog up Tasmania's already overstretched doctor waiting lists. Or how when they can't get a doctor's appointment, people will turn to other means to access the vapes they need to manage their addiction. It will be harder to access vapes, which will make it harder for people trying to give up smoking. Not only is this ban the harshest in the country, but it's harmful and leaves those struggling with addiction with few options, one of those being the black market. This isn't just a broken promise. It's a public health disaster in the making. Vaping has been a lifeline for many smokers trying to quit. I've already told you about how I've watched family members successfully switch from smoking to vapes, and some of them have quit. But I've also spoken with other Tasmanians who have used vaping to quit smoking and have improved their health in the process. Even the federal government acknowledges that vaping can be an acceptable alternative to smoking tobacco. The Therapeutic Goods Authority, TGA, provides guidance to medical professionals looking to prescribe vapes to their patients. The TGA says therapeutic vapes may be a reasonable intervention if smokers have tried other quitting aids like patches, gum, lozenges, mouth spray or even inhalers. The Tasmanian government's approach is going to make things tougher for people to quit smoking, and it will negatively impact our already struggling health system. So why would the Tasmanian government make it harder for Tassies to access a harm reduction approach to give up smoking? Does the Tasmanian government want more people to smoke and less people vaping? That doesn't seem like harm reduction to me. Tasmania has already the highest rate of smoking in people aged over 14, a not-so-good statistic we share with the Northern Territory. If we know something will help smokers give up, why wouldn't we make it available to them? Vaping is one of multiple proven methods when it comes to quitting smoking. Look, I know smoking is bad. I know smoking damages people's health. But I also know my state government should not be telling adults what to do when it comes to managing their nicotine addictions. Restrictions like those the Tasmanian government has introduced guarantee the rise in a black market for vaping products. When a product is pushed underground, the rules that provide safety and quality are stripped away, and the products people buy might be even more dangerous than the cigarettes they are trying to give up. This approach puts Tasmanians at greater risk. The state government's stance is dangerous. If the Tasmanian government was truly concerned about people's health, the approach should be to manage and educate through effective regulation, not restrict and punish those who are trying to quit. To put it simply, this approach makes it so much harder for Tasmanians to access safer alternatives to cigarettes. We're all addicted to something. It might be alcohol, cigarettes or gambling, all of which have been the subject of debates in this place over the years. But what about other addictions that have been normalised? I can't function without coffee, and I like chocolate and KFC too. Do I know too much of these things aren't good for me? Yeah, but that doesn't stop me from having them. I'm an adult and I should be able to choose what I put into my body. If I decided to get healthier and stop eating chocolate or drinking coffee, I'd be applauded. Why is it different for those people who choose to use vaping to help them give up smoking? The Tassie government needs to support people who are trying to give up smoking by allowing them to access vapes without jumping through hoops. Banning vapes and pushing them into the black market is not a minor stumble off the curb. It's taken a big leap off the cliff altogether.
Senator Walsh.
Thank you, Acting Deputy President. Well, after 100 years of proudly generating energy for Victoria, Gippsland is looking ahead. The region is known for its energy legacy, and now locals are focused on securing a sustainable future for their communities and industries, which was really clear to see at this year's Gippsland New Energy Conference. For the third year running, the conference was packed with community groups, businesses, unions and locals, and among them was Dean, a Gippsland born and bred local currently working at the Yallourn Power Station. Yallourn is set to close in just a few years' time, and the community is getting ready for the next steps. With impacts of climate change looming, the urgency of the energy transformation is only becoming clearer and clearer. And in that transformation, Gippslanders want ownership of their future. And that future looks like a path in renewable energy. Gippsland is a region with agency, one that is deserving of respect that hasn't always been afforded. We saw this with Hazelwood Power Station, abruptly closed 7 years ago, with only 5 months' notice from its multinational owner. And this closure is a stark reminder of the need for a community-led approach. Now, Gippslanders are calling for the energy transition to be done in partnership with them, not to them. And the Albanese government recognises Gippsland's potential, awarding feasibility licences to 12 offshore wind projects, capable of matching Victoria's current energy output. These projects are set to transform Gippsland's energy landscape and create thousands of new jobs for locals just like Dean. Since the announcement, the community has not wasted a day in embracing the opportunity. Local businesses, unions, the community, traditional owners and groups like the Committee for Gippsland, the Gippsland Trades and Labour Council and the Gippsland Climate Change Network have united to chart a new energy future, culminating in the launch of the Gippsland Offshore Wind Alliance at this week's conference, designed to ensure support for this new industry is heard at all levels of government. And this year, the Minister for Climate Change and Energy, Chris Bowen, came to Gippsland to listen. Minister Bowen's address to the conference highlighted our government's commitment to this region and its energy transformation. At a community roundtable, the Minister heard the plan and goals for the region directly from Gippslanders invested in their own future. Demonstrating commitment to investing in the region, he announced the results of the capacity investment auction. And the Warreen battery in Gippsland was just one of the recipients. This 350 megawatt battery can power 400,000 homes for 4 hours and comes with a $500,000 community benefit fund to ensure Gippslanders will feel the benefits from this project. And locals like Dean are paying attention to announcements like this one. For Gippslanders, these developments are more than just policy changes or the next announcement. They are real investments in the region, a region that is worthy of a bright future, so that Dean and others like him can live and thrive in their hometowns, contributing to and benefiting from the region's renewable energy transition. Existing power stations are shaping their futures around renewables too. The next power station to close after Yallourn is slated to be Loy Yang A in 2035, owned by AGL. AGL is also one of the 12 proponents awarded an offshore wind licence with its Gippsland Skies venture. However, the recent identification of the Loy Yang A site as a potential nuclear location by the Coalition in June has been really troubling. Not only did AGL have no say in the announcement, but the community knew nothing either. And AGL CEO Damien Nix has been very clear. Nuclear is not part of their plans or their strategy. It is just not on the radar. And how can it be when you have no consultation, no listening and no plan. For Gippslanders, nuclear at best spells distraction, at worst dangerous delay. The abrupt introduction of nuclear energy without proper engagement undermines the years of work invested by locals and the energy sector. The hundreds of conversations held by locals in Gippsland last week and in the years before reinforced the critical need for partnerships and open dialogue. Regions relying on a path to energy transition deserve a real plan to get there. Gippsland should be in the driver's seat of this transition. Dean and other locals need these investments like those our government are doing for generations to come. It's time that Gippsland takes the wheel and drives their own new energy future.
Senator Antic.
How often do you hear a woke politician or media pundit using the words misinformation or disinformation? Usually refers to an issue which one of them disagrees with rather than actually being something which is untrue. We're told that misinformation lurks in the confines of the free speech digital world, ready to pounce on unsuspecting citizens. It can only be cured by fact checks and censorship. The strange thing is that from where I sit, the main purveyors of actual misinformation and disinformation aren't on Conservative podcasts or tweeting on X. They're experts freelancing around their fields of expertise. Now, these experts spend years mastering one niche topic and then mistakenly feel like this gives them the equal authority to freelance into other topics with opinions which coincidentally marry up with their political views. The media is awash with these experts, speaking out on matters that are often totally unrelated to their personal field of study, all the while using their academic titles of expert status as justification for presenting those opinions as facts. So if you want a way to push your climate agenda, find yourself a sympathetic marine biologist to give you a meteorological opinion. If you want to lock people in their homes, force them to inject themselves with a novel therapy, get yourself an epidemiologist to tell you what they think about infectious disease. These people are very capable of drawing false conclusions and very, very vulnerable to the natural human tendency of bias. Many experts claim impartiality but allow their work to be influenced by their political views or the priorities of those who fund their research. Many experts make research decisions based on concerns about their own social reputation or their desire to support the legacy of their own earlier work. And many experts freelance outside the scope of their expertise. Now that's proper misinformation. An unhealthy reliance on expert views is attractive to those who don't think the people can be trusted to make their own decisions. That's one reason why during COVID politicians allowed the best expert medical advice to set the rules by which we were allowed to live. Now we know that most of those views turned out to be genuine misinformation. I'm sorry to tell you, your masks didn't work and they still don't work today. In March of 2020, when governments in this country began rolling out COVID lockdowns, they did so at the behest of legal advice. That saw us locked down for weeks and months, subjected to ridiculous procedures and forced into treatments we didn't want, all in the name of science. Or was it politics? Having studied a particular topic in depth doesn't make someone infallible. Modelling software is not a crystal ball. Anytime you hear one of these people say, the science is settled, alarm bells should ring because the science is never, ever settled. That's what makes it science. The scientific methods demand that every question be open to investigation at any time. To trace the history of human knowledge, and scientific knowledge in particular, is to trace an endless process of orthodoxies being proven false and replaced. People dislike being spoken down to like this, but they dislike being lied to even more. The use of so-called expert evidence has become a powerful way for politics to dress up opinion as fact and to crush dissent. But not all of it is valid. So where's the real source of genuinely dangerous misinformation? Is it people grappling with ideas on a podcast and social media, or is it your socialist GP giving immunology advice to the entire country on national TV? I tell you what, I know which one I'm more concerned by.
Senator Askew.
Thank you. Since the Albanese Labor government came to power 2 years ago, it has mandated pay rises for the early childhood sector on 3 occasions. To date, it has been the families who have borne the brunt of these pay rises through increased daily fees for their children attending care.
The third mandated wage increase was announced on the 8th of August, just over a month into the new financial year, and has been tied to a promise that centres would not increase the daily fees by more than 4%. I'm not here to say early childhood educators don't deserve a pay rise. However, the first two of these three increases over the past 2 years has already added a significant burden to the household budgets of those who have children in early learning. Families have been struggling with the incremental increases in household essentials, with food, electricity, healthcare, insurances and petrol all increasing due to the action, or should I say inaction, of the government. And a large proportion of these families have been burdened with 12 interest rate rises and a sustained period of high inflation. ABS labour force data from August confirm wages for working householders are going backwards under Labor. Despite Labor's constant assurances that their fiscal measures are not inflationary, many hard-working families are finding it harder than ever to make ends meet. Those with children in long day care have seen their daily fees, before the childcare subsidy is applied, rise by about 17% in 2 years. And that's before this latest package is applied. And with the supposedly capped increase of 4%, which the government has apparently made a condition for workers to receive this latest pay rise, it will add another $6 per day. And while that might not sound like much, if you consider a child that is in long day care for 5 days per week, it will cost families $858 per week before the childcare subsidy is applied. And while each family's subsidy is different, the average family who receives, for example, a 77% subsidy is looking at an out-of-pocket cost of about $300 a week, which totals $15,600 a year. Remember when Prime Minister Anthony Albanese announced Labor's signature cheaper childcare reforms? When he boldly declared no family would be worse off under the changes to the childcare subsidy. Well, that's just another broken promise. The Albanese Labor government promised increasing the childcare subsidy would make things easier for families looking to re-enter the workforce and create a more affordable system for all Australians. These mandated wage rises might be a quick sugar hit for the workers in this industry and an election bid by the government for their vote, but they do nothing to address the inequities in the system faced by parents looking for reasonably priced childcare for their children. We have all heard the stories of mothers-to-be signing up their children to waiting lists at the daycares in their area before the child is even born, only to be unable to secure a place when they need it. This particularly applies in rural and regional areas where they are so often childcare deserts. Having a baby in Australia has become an incredibly expensive lifestyle choice. There are many couples who feel they can no longer afford to start or expand their family. With countless people struggling under the burden of Labor's homegrown inflation and the uncertainty over our future housing and energy markets, to name a few, it is no wonder more people are choosing to be childless by choice. Birth rates are dropping. Data from KPMG released in July this year describes Australia as experiencing a baby recession. Birth rates have dropped to their lowest level since 2006. While I will never advocate for the removal of a woman's right to choose if she wants to have a baby, it's equally important for us to recognise the critical importance of the next generation for this country. We all know that women having babies is good for the economy. It's good for productivity and it helps keep the economy ticking as generations enter and leave the workforce. To do that, we need a safe, affordable and accessible childcare system to give children a good foundation for future learning and to give their primary caregivers an opportunity to re-enter the workforce. But instead, this system has created a world where parents who may have received more subsidy have simply watched that subsidy increase and with it the daily fee increases, which puts them back at square one. What's more, many centres directly attribute the daily fee increases to the pay rises, effectively passing on the cost to parents. The reality facing hard-working Australian parents is very different to the story Labor is claiming. For the government to claim these reforms as genuine cost of living relief needs to be called out for what it is, a policy that has done nothing to create meaningful change for many. Australia's children deserve better, not a system propped up by band-aid solutions as proposed by Labor. Thank you.
Senator Henderson. Senator Henderson, you are seeking a 5-minute call?
Yes, I am.
Senator Polley, resume your seat. We're still on the 5-minute list. The agreed sequence is someone who's on the list who walks in late goes to the end of that list. Senator Henderson is now at the end of the 5-minute list. Senator Henderson, you have the call.
Thank you very much, Deputy President. Well, as each day passes, Labor's international student caps debacle keeps going from bad to worse to disastrous. After promising so much to the higher education sector, including the University Accord, the Albanese government's hapless Minister for Education, Mr Clare, has managed to plummet this sector into turmoil. It's not as if he wasn't doing enough damage. Record high student debt driven by Labor's homegrown inflation, shocking campus anti-Semitism that does not mean different things to different people, declining completion rates made worse by Labor's abolition of the 50% pass rule, the nonsensical start-up loan scheme where students are forced to pay full price for courses they could previously do for free. And then came Labor's immigration mess, with the Albanese government opening the floodgates to record levels of international students, which is fuelling the housing crisis and causing unprecedented chaos in the international education sector. I want to reiterate how serious this is. In inner-city Sydney, suburbs like Glebe, rentals have gone up 17% in 12 months. And let's not forget, at the University of Sydney, there are now more than 50% of students who are foreign students, more than 35,000, clocking over that 50% mark, and of course giving rise to serious concerns that universities like the University of Sydney have lost their social licence to bring foreign students to Australia, because the bottom line is, Acting Deputy President, the educational outcomes for all students matter, and that's why I've called for our public universities to go back to basics, including to focus on the educational outcomes for domestic students, which is their fundamental job. So the doubling of the number of foreign students studying in Australia went from 336,000 in March 22 to now more than 800,000, a mess of Labor's own making. Every country has a responsibility to manage its migration program in the national interest, but Labor has botched this fundamental obligation and Australians are paying the price. Then came Ministerial Direction 107, implemented by the former Minister for Home Affairs, who was so bad at her job that she was sacked by the Prime Minister. The decision was made to prioritise visa processing at our nation's most prestigious universities, the Group of 8, whilst smashing regional and smaller universities and private higher education providers. So Labor was looking after the big end of town while treating the regions and the private sector with contempt. This resulted this year in 83,000 student visas for the Group of 8 and just 8,900 visas for regional universities. Now Labor is covertly, behind closed doors, allocating individual student caps to higher education and vet providers using a flawed methodology which still looks after the prestigious universities while punishing many others. And we've heard in a number of Senate inquiry hearings great universities like Western Sydney, which play a vital role in educating foreign nurses who then go on to fill the gaps in the nursing workforce shortages. There are 10,000, there's a workforce shortage of nurses of 10,000 just in Western Sydney. They have been absolutely squeezed, as I say, while others haven't. And if you look across the sector, and we are really concerned about the numbers we are seeing, the university allocation has gone back by only 1%, while the allocation to private providers has gone back by 28%. And some private providers have been left with zero caps, like Nova Anglia, who is offering bachelor degrees in EV technology and has been left high and dry. So this is an absolute mess, and we are not satisfied with what we are hearing or seeing from this government. It is appalling the way the government is implementing these caps, and this minister should be ashamed of himself.
Senator Roberts.
I'm doing 10, Chair, so...
You were on the 5-minute list. You can go to the end.
No.
You're on our 5-minute list.
So is Karen, so go to Little first.
List, my whip forgot to put me in, and the Labor Party said just go to the bottom of the list, so that's what I've done. 10, but I'm doing it 10 minutes. I'm happy to go last.
Okay,
that's
Senator Little.
So, well, what a load of hypocrisy on show today from the Australian Greens and the Labor Party and some independents. A motion voted down today seeking to better understand native title outcomes and opportunities is a missed opportunity to improve the lives of Indigenous Australians. It is ridiculous and disingenuous to talk of self-determination and to have voted against this motion. Co-signed by cross-bench Senators Lambie and Thorpe and myself, this motion sought to start to tackle an issue for which there is much evidence and much urgency. Shadow Minister for Indigenous Australians, Senator Nampa Price, hosted native title holders from Central Australia who were in the chamber to watch in disgust, disappointment and disbelief that their concerns were ignored. This was an opportunity to let people speak. It wasn't about hearing from organisations, statutory authorities, but about letting native title holders tell us, in their view, in their words, what's going on from their perspective. Why has native title been in place for more than 30 years and people are land rich and dirt poor? Why have some land rights bodies had mining units for decades, yet never a new mine? Why have so many prescribed bodies corporates, the first point of contact for government and other parties wishing to undertake activities on native title land, entered administration? How many continue to see little financial return despite formal agreements with developments, resources and tourism operators and prosperity on their doorstep? They want to talk about this. They don't have what the Albanese government called consultation fatigue. Elders and the current CLC's current chairman travelled to Canberra, and they did so because of their resolve to see change. The Labor Party, the Australian Greens and those independents who voted against this motion simply found it expedient, convenient and plausible to say no. How could you when there is so much evidence that this is needed? What you lack is courage and a will to secure and support their will for change. Consider the admission from Labor just yesterday about Anandiliakwa Land Council's poor governance and the lack of commitment to improvement, something the Labor government knew about 18 months ago. How terrible is it that as custodians of the land on which we pay so much respect every single day, that you respond the way that you did? It was a simple motion which potentially had the ability to change lives, to give hope that someone was listening. It was to examine the role, governance and accountability of native title representative bodies and prescribed bodies corporates and the impact of the Native Title Act. It included concept of free, prior informed consent, consultation and negotiation, the integrity of the register of members, transparency and accountability in decision-making, the process for progressing and approving developments. It was not just about land councils, it was about native title, which includes the perspectives of the impact of native title and its act, and gave space for talk on PBCs, native title rep bodies and traditional owners. Did the Labor Party, the Australian Greens or independents who voted against it even read the motion? This was broader than the reviews that occur periodically by the ANAO because it gives voice to people, not those employed by a statutory authority of government, the land councils. Let's be honest with the Australian people, that's what the ANO looks at, just the land councils in the Northern Territory. This motion was about looking at so much more, giving so many more people the opportunity to speak up, to speak out and be heard. You know, ironically, the Greens and the Labor Party spent 2023 talking voice, so much about voice, yet today voted down providing Indigenous Australians an opportunity to speak. In objecting, the Labor Party said, First Nations community are already experiencing consultation fatigue. This wasteful duplication would be confusing and distressing for First Nations communities. Well, thanks for caring so much. You still said no. The Labor Party said, we don't need another standing committee with another review. The motion isn't about governance, it's about politics. Rubbish. Well, certainly the Australian Labor Party and the Australian Greens and those independents who voted against it made it about politics, when in fact this was about people and unrealised potential.
Senator Polly.
I rise to speak about a very emotional and important event which occurred last night in this building. My parliamentary colleague and co-convener of the Parliamentary Friends of Dementia, Nola Marina, and I hosted a very special gathering for an event in conjunction with the Childhood Dementia Initiative. We heard from families firsthand about their experiences with this insidious and devastating disease. Their courage and dignity speaking on the panel that we hosted yesterday was very powerful, was very raw, it was very personal, and it was a contribution to this discussion that I think those who were fortunate enough to witness it will remember for a very long time to come. Behind every statistic are real families with heartbreaking stories, fighting each day to give their children the best possible life in the very little time that they will have. The reality is childhood dementia causes a similar number of deaths in childhood as childhood cancers, yet receives only a fraction of the attention and funding. It is always very difficult to compare one disease with something that is just as equally devastating to the families and to the individual. But this disparity is not just unfair, it's devastating. Because over the last decade, we have seen an amazing turnaround with childhood cancers where we have 74% survival rate, which is fantastic, and I applaud that. I applaud the doctors, the medical fraternity, the researchers, it's fantastic. But if you have a child with childhood dementia, your loss is just as devastating, no matter whether it's childhood dementia or it's cancer. The loss to the family and our communities are all the same. But when you consider that you raise your children, you teach them to talk, you're excited when they learn to sit up, when they crawl, when they walk, when they are anticipating going to school for the very first time and kindy. And then you have to witness the rapid decline when they lose the ability to speak, they lose the ability to be able to eat. It is absolutely devastating. And so there is so much more for us to do, and that's why we held this function yesterday with Nola Marina and myself, so that we can raise the awareness. Because too many people that I talk to have no understanding, let alone knowledge, that there is such a thing as childhood dementia. We've raised dementia awareness in this parliament, I'm pleased to say, and I've played a very small part in that. And we know how debilitating that is. But when you see and you hear from parents, last night we had a panel and we had some very brave parents talking about their experiences. There was one mum who was married, her husband, they had the joy of having 3 children. It was their youngest child, 8-month-old, that was first diagnosed with childhood dementia at 8 months. Then the second, the middle child, and the eldest child. 3 children from that family. Where they were once a happy family of a mum and dad and 3 children, they now have a mum who is completely dedicated to giving those children the best possible care, but she's doing it alone. And can I just remind people that her grief and her struggles are no different than what their dad's was. But she's there, and to hear her talking about the challenges that she has and having very few options to turn to get support is absolutely heart-wrenching. So we need to do so much more. We need more money from governments for research. We need more researchers prepared to do the research into this particular disease. But can I just say, childhood dementia is quite unique. At the start last night, the families affected by this disease, they spoke to us about the roller coaster of emotions, the challenges and uncertainties that they experience. Their daily lives are consumed by relentless demands of caring for their children, trying to juggle some medical appointments, not really being able to navigate a very complex health system that doesn't really have the complete understanding that they should have of this incestuous disease. So they're trying to do that, and some of them are, if they're lucky, they have a partner, so they're still able to have a career. But it's a very exhausting process. And many are completely at loss, feel dazed, and sometimes feel that they aren't actually living themselves. But I wanted to thank Sydney, Felicity, Nicole, Peter, Renee and Sam for speaking with us last night. It takes a lot of strength, as I know everyone in this chamber would agree, to come from outside of this place, not being a politician, and talking about something that is so personal. To share your grief, because from the time of diagnosis, as we know with dementia generally, it's a grieving process for their family and their loved ones. But put yourself in the position where you have a 6-year-old that you have loved and cherished for 6 years, and even before that, in the anticipation of their birth as being the mother or the father. How that must feel. I can't even imagine what it would be like to lose a child. But for those who have one child, it's devastating. But if you're the parent of 2 children, and then 3, but what was really beautiful was that they were prepared to share their story and their experience to help others so that their child has not died and will be forgotten, and there won't be advancements made in this area. It was the Albanese government, through Health Minister Mark Butler, that actually funded in the last budget to enable the State of Childhood Dementia in Australia Report 2024 to be funded, which was fantastic. And I know that Minister Butler will be open, as he has, to meet with these parents and to hear their stories. But we need to do more. We need to make sure that these stories are not forgotten. But each one of those parents is looking forward to the opportunity of coming back to the Australian Parliament to tell their story again and again and again until more people understand there's more funding and more support. And I am so proud of them, and I thank them from my heart, because it means so much and it is so powerful. I can speak in this chamber, but it's not until you hear a parent talking about their anguish, their loss and their love that is so powerful. But there are In this country, there is unfortunately a child born with childhood dementia disorder in this country every 3 days. Every 3 days. And half of all children with dementia die before the age of 10, and 70% of them will die before they reach adulthood. And throughout their very short lives, Australians, as we know, going through this, they die slowly in an agonising death and unfortunately without the support that they need. We should never forget these children, and for the parents who told the story about their children, we should never forget Caleb, Dylan, Toby, Hudson, Austin and Holly. We heard you and we do remember you.
Your time has expired. Senator Scarr.
Thank you, Acting Deputy President. Well, good on you, Senator Polly. Good on you, Senator Polly, and also good on Nola Marino MP for taking the lead on this. I was not aware of the extent of that issue in terms of childhood dementia before the activities of this week. So congratulations and deep respect to you for that contribution, and also for the work which you are doing on a collegiate basis with Nola Marino MP. Thank you very much. Acting Deputy President, Springfield, where my office is located in South East Queensland, had its Business Oscars last Saturday night, and the event was convened by the Greater Springfield Chamber of Commerce, and it was its Marquee Business Awards. And I'd like to offer some congratulations. The winners first. The winner of the Lifestyle Award was Tash Marie Tours and Events. The winners of the Professional Services Award were P&L Accountants. The winners of the Best Customer Service Award were APAR Hair Studio. The Media and IT Award, Purple Bunny Marketing, congratulations. Education and Training Award, the Springfield Anglican College, which is an outstanding educational institution. The Financial Services Award, which I had the opportunity to actually present, had 3 wonderful entrants: Jet Team Finance, Zest Mortgage Solutions and PSK Private Wealth. The winner was, and there can only be one winner, Jet Team Finance. Congratulations to the Cafe Kalina at Springfield for the Hospitality Award. The Real Estate and Property Maintenance Award, First National Real Estate Springfield Outstanding Small Business Award, AquaShield Bathrooms. The Business of the Year Award and Members' Choice Award, Zest Mortgage Solutions. Business Person of the Year Award, congratulations to Rebecca Sanfuentes from McNamara Law, and the President's Award going to Helping Support Minds. I would like to give my deep congratulations and pay my deep respect to the President of the Chamber, Neil Coupland, whose real estate agency, First National Real Estate, actually won one of the awards, and one of the first times I've seen Neil being almost speechless. Also to Layla Stewart, the Executive Officer of the Springfield Chamber of Commerce. Neil describes Layla as their single superstar employee, and she certainly is. And there's something special that's been created by the Springfield Chamber of Commerce, and that's brought about by the executive, but also the wonderful businesses who are members of that chamber. So congratulations to everyone. It's absolutely, it was a great privilege to be in attendance on Saturday night, and everyone's a winner in the Greater Springfield Chamber of Commerce. I would like to speak about a remarkable cultural and spiritual event that I attended on Saturday, 31 August, at St Paul's School, Bald Hills in North Brisbane, organised by the BAPS Swami Narayan Hindu community, where we celebrated Janmashtami, marking the birth of Lord Krishna. The event was a vibrant celebration, rich in faith, culture and community spirit. The venue was beautifully decorated, and I just want to emphasise that, absolutely beautifully decorated, including with scenes from Lord Krishna's life, welcoming families, and there were so many families there who gathered to honour this sacred occasion. And what really stood out was the unity and inclusiveness that brought together people of all ages and backgrounds. It was open to the entire community, strengthening the bonds within our wonderful, diverse community. During the event, I had the privilege of receiving a Nadach Hardy, excuse my pronunciation, a sacred thread, which I'm actually wearing this evening and haven't taken off actually since the event, which further deepened my connection to the cultural significance of the day. And I'd like to pay my deep respects to the BAPS representatives, Pooja Ashpurash Daswami, Pooja Bhaktinidhi Swami, all the BAPS volunteers, the members and devotees, also to Utsav Sejpal, who coordinated my participation in the event. Congratulations to everyone. It was great to see the wonderful Councillor Sandy Landers there from Bracken Ridge, and also two wonderful LNP candidates for the forthcoming Queensland State election. The LNP candidate for Aspley, my good friend Ms Amanda Cooper, and also Mr Chris Mangan, who's the LNP candidate for Sandgate. He'll make an absolutely outstanding member for the seat of Sandgate, and all the other community leaders who were there. Congratulations. It was a great event, and congratulations to the BAPS community. I would like to pay my deep respects to Archerfield Club Rotary, of which I am an honorary member, for their very successful annual dinner and charity night at Gambaros. This is an absolute institution. They raise funds on the night for a wonderful charity called Interplast. And during my time as company secretary of a great Queensland company called Panos Limited, we work very closely with Interplast, who assists in terms of facial reconstructions, especially for children in need of those treatments in developing countries. We assisted that charity in Laos and also in PNG, so I'm very familiar with the work of Interplast. And there was a considerable amount of money raised, tens of thousands of dollars raised on Saturday night by Archerfield Rotary for the charity, and that will go to promoting treatment in the Asia-Pacific region, which is a wonderful, wonderful thing. Special thanks to Lester Drew and Ray Dean, both dear friends of mine, for their work in bringing the event together, and for all the attendees at the event. Thank you so much for your contribution to what was just a wonderful evening, and thank you to Archerfield Rotary and the broader Archerfield Rotary community for everything that you do for the community. I would like to congratulate a wonderful Queenslander, Ms Julie Peel, who was successful just this week in being awarded a teaching fellowship from the Schools Plus Teaching Awards. And Ms Julie Peel is principal of Milperra State High School in my home state of Queensland. And Milperra State High School is one of my favourite places in the whole of Queensland. This is a high school which provides specific educational services designed for refugees and the children of refugee families. And they have an outstanding record in terms of the wellbeing of students, the attendance rates of students, school completion rates, and it is an amazing environment. So Ms Julie Peel is the principal. She provides the leadership and is just outstanding in terms of everything that she does. But I know Julie would say, and I will say this, that this award, this fellowship, which is a great honour which she has received, I know that she would say she is receiving it on behalf of the Milperra State High School community, the whole community. And that's all the teachers, that's all the volunteers, that's all the students, the families of the students, for the very, very special environment which they've created at Milperra State High School, which from my perspective represents the very, very best of Australian values. And with that, I want to just give my heartfelt congratulations once again to Ms Julie Peel, 2024 winner of a teaching fellowship from the School Plus Awards from my home state of Queensland.
Thank you. Senator Rennick.
Thank you, Acting Madam Deputy President. And I rise tonight to speak about the key policies introduced by the People First Party, albeit one person, but I think it's very important to note that it is a party that actually has some key policies that seek to empower hard-working Australians, the individual and their families. Because if there's one thing I've noticed about politics in this country, is that we have a 3-year cycle of the Punch and Judy show in this chamber, whereby the major parties come in here and they criticise each other, and then they'll call an election, and then half of the election campaign spent being asked, when are you going to release your policies? And then finally, about 3 weeks out from the election, they'll start releasing policies, the election's held, and then they go back into another 3-year cycle of the Punch and Judy show. Well, let me tell you that under this party, it's going to be different. In the very first week I announced my departure from the LNP, I was happy to put out 5 key policies, and I'm happy to stand by them. I'm happy to debate them in this chamber or with any other politician on any other media outlet or with the media themselves. And I will note, and I'll quote Rob Stitch here from that great show, The Holloman. For some reason it's been forgotten about, it's been surpassed by the Utopia show, but I always thought Holloman was the better of the two shows. But I well remember the program where he was talking about policies and he came up with this idea that you've got to have a raft of policies. And in many ways, that's how you would describe the major parties' policies, is that they're a raft. They're basically drifting around on the ocean with a bamboo pole. There is no rudder or outboard motor powering the Australian people. And the Australian people are looking for leadership in politics. They are looking for politicians who have a vision and a way forward as to how their children and themselves are going to get the same opportunities that our forefathers gave to us, and how they're going to ensure that they have a prosperous and comfortable life. Because many, many Australians are concerned about the direction we are heading in. They are of the view that in the last 40 years we have seen governments sell all the infrastructure that they're responsible for, and they've privatised that infrastructure. They've walked away from providing essential services, and they've marched into the family home, the classroom, the bedroom, the corporate boardroom, the doctor's waiting room, telling people what to do in their personal lives. And we need to reverse that, because this process in the last 40 years is that we've effectively privatised people's or nationalised people's private assets and personal wealth, and then they've gone and then privatised the public assets via the infrastructure. So my 5 key policies that I want to actually promote over the next 8 to 10 months in this term are the following. And the first is that I want to lift the tax-free threshold to $40,000. That would give those people up to $40,000 a $3,500 tax cut. Because there's one thing that's always grinded my gears in this country, is the fact that low-income earners have to pay tax below the cost of living. These are the people that get out of bed every day and put their nose to the grindstone, when in many circumstances it would be easier to stay in bed or to maybe get welfare or give up, and they don't. And you know, this country was built by the battlers, and it's those people on the low incomes that we have to keep going, because in many cases, in all cases, these people are keeping the wheels of industry turning. You know, I started off on a low income myself. I jackarooed and I worked in pubs and bars and picked fruit and whatnot. And, you know, a lot of that work was often harder than some of the work I did later in my life when I was sitting in an office and pushing pen and shuffling paper. And I've never forgotten those people. And, you know, my first role after I graduated was in public practice, and I'd often do the tax returns for these people, and they really relied on getting a tax refund, because that was going to be the difference between them getting ahead or falling further behind. And we owe it to those people, and we need to call out the Treasury and the way they model the velocity of money, the way they model tax cuts, because they don't assume secondary impacts when
modelling tax cuts, and that discriminates against tax cuts to low-income earners. Because let me assure you, if you give a $1,000 tax cut to someone on $40,000, that money, most of that money, will end up in the Treasury coffers within 12 months, because those people will go out and actually spend that money straight away just to meet the cost of living. Now, I hear some of the people say, but won't that cause inflation? Well, no, it won't. Well, it'll cause very little inflation for these two reasons. A, elasticity of demand when you're living below the cost of living, okay, is very elastic. These people will go out and have to buy things, but what they'll do is they'll end up using the credit card to do it. So what they'll do is they'll use credit and get further into debt just to keep their head above water. And secondly, who is it that supplies the goods and services in this country? It is the people that get out of bed and put their nose to the grindstone, whether it's workers or small business, that actually deliver goods and services. So if you cut the tax on the delivery of goods and services, you will increase the supply of goods and services. So I don't want to hear any pushback, and if anyone wants to debate me on this, bring it on, that somehow giving a tax cut to working Australians is a bad thing, because it's not, and we can't afford not to do it. Now, the second policy that I want to push forward is the fact that we should be paying childcare directly to the parents. Okay, we have millions of shift workers out there. We have nurses, police who work late hours at shift work. I know my mum used to come home at 10 o'clock at night, go to bed. She'd get to bed by 10:30 and have to turn around and be up at 5:30 to get back to work at 6. Okay, they don't have time to necessarily pick their child up at 6 o'clock at night or drop them off in the morning on their way to work because the childcare centre isn't open. Okay, we have millions of part-time workers who pay, who might work 3 or 4 hours a day, but pay for 12 hours childcare. Why are we increasing demand on childcare places for booking this person out? So often you've got to book a childcare centre for a term or a year to get your child in childcare. You're paying for childcare often when you don't need it. We have fly-in, fly-out workers who might have a 10-day roster on and 5 days off. That's their weekend, and yet they will have to pay for childcare when they don't need it. We have other people who want to work from home and may only need a nanny for a few hours a day. Why do they actually have to take their child to the childcare centre and not let the nanny come to their place? That in itself is creating more stress and time pressures on people that have to meet deadlines. And then we have our farmers who have to drive in and out of work. So we need to provide greater flexibility in childcare. The third thing we need to do is give greater flexibility in terms of superannuation. Superannuation is not working. 50% of retirees in 1992 were on a full pension. Today, 50% of retirees are on a full pension. We have not shifted the dial on reducing the number of retirees on a pension at all, despite the fact that we give $50 billion in tax concessions to the mainly upper 25% of income earners, and the pension costs $54 billion for the bottom 50% on the full pension and the 21% of retirees on a part pension. It is unsustainable. We cannot afford to be paying $30 billion in fees to the white-collar workers in their ivory palaces to manage other people's money. I've spoken about superannuation many times, so I'll touch on that later. Now, the fourth thing, and the way I want to pay for these income tax cuts is there are a number of measures. Number one is to remove the duplication of the bureaucrats in the state and federal bureaucracy. Number two is I want a means-tested defined benefit scheme. We have over 40,000 retired public servants who get over $75,000 a year. That is estimated to cost by finance $137 billion. We have 30,000 retired public servants who get between $50,000 and $75,000 a year, that is going to cost the budget over the forward estimates, and when I say like over the life of the defined benefit scheme, $90 billion. Many of these people were on high salaries before they left work. They should have an assets and income test applied to them just like everyone in the private sector. It is ridiculous that multi-millionaires are getting gold-plated pensions from the taxpayer, many of whom are on low incomes paying tax above $18,200. And the last policy that I want to talk about is bringing back a public bank. We sold the Commonwealth Bank in 1992 for $8 billion. Today it makes $10 billion a year. We've got branches closing in the regions. We've got a decline in the level of service in those banks. We need to bring back a government insurance office. We've got businesses out there in Australia, we've got people out there in Australia that can't get basic insurance. And the last thing we need to do is reform our monetary policy in this country, and the best way to do that is by securing our infrastructure against the necessary need to expand the volume of credit as we have a rising population. And that's not my opinion, that was the opinion of the 1937 Banking Royal Commission. So I look forward to fighting for these policies over the next 8 to 10 months. Thank you.
Thank you. Senator Roberts.
Thank you. I note staff in libraries across Victoria have been given a new LGBTQIA+ instruction called the Rainbow Libraries Toolkit, which requires libraries to ask the gender pronouns of children as young as 5. The Allen Labor government launched the toolkit and advises library staff that adding books on gender diversity to their collections and promoting the drag queen story events to children will make them more LGBTIQA+ friendly. The toolkit advises library staff not to assume the gender pronouns of primary school-aged children. The explanation for this is, quote, "It is important to recognise that, especially for young people, gender identity and sexuality can shift or evolve over time. Children in particular may want to experiment with different gender expressions, and we can support them," end of quote. Library staff are told that even if they are familiar with a child who visits their library, they should, quote, "leave room for them to express a change in their identity, including by prompting them if they still go by the same pronouns. Checking in casually about their pronouns. Do you still prefer he, him pronouns? Do you still go by Sam? Or is there something else you'd like me to use?" End of quote. Now, what the hell is going on? When these books, written for children supposedly, are opened, it's easier to see they're actually instruction manuals for sex. Who puts gender propaganda into libraries for primary-aged children to access? Who runs drag queen shows for children? Who talks to children as young as 5 about their gender identity? Groomers do. The Australian Labor Party does. Who knew the P in ALP stood for perverts? The inevitable outcome of this childhood grooming will be an increase in gender dysphoria in children, leading to increased pharmaceutical interventions. Here is what we know about the drugs used in gender dysphoria, commonly called puberty blockers. According to the TGA product assessment for Leuprolin, the purpose of the approval is for the treatment of cancer. The drug reduces the production of hormones on which cancer feeds. Fair enough for adults. This reduction in hormones causes, quote, "atrophy of the reproductive organs." What are the side effects? Dane case 816594, 26th of July 2024, female aged 9 years. Side effects included pain and fat necrosis. Fat necrosis, according to the Cleveland Clinic in America, is the death of fat tissue in the breast or other organs. The damaged fat may be replaced with a cyst or scar tissue. Nice. Dane shows there have been 42 reports of adverse events to Leuprolin in children aged 10 or less. Less than half of the reports include age, so the real figure will be much higher. This drug costs taxpayers $271 for a low dose and $1,370 for a high dose prescription. At a time when taxpayers are struggling with the cost of living, why is the Albanese Labor government choosing to spend taxpayers' money on this? Why? The propaganda around this very expensive drug is that these changes are not permanent, and the transgender lobby repeat this as a mantra. It's a lie, a straight lie. The condition that is reversible is precocious puberty, where a child goes into puberty at a very young age. Puberty blockers do indeed prevent that child going into puberty until they are removed from the drug, usually around 11 years of age. The extension of that safety data to any child is the great lie of childhood transgender experimentation. There is no proof these drugs are safe on a child who has not suffering the raised hormone levels associated with precocious puberty. This is not my opinion. Britain's National Health Service has changed their guidance on children and puberty blockers, preventing their use for gender dysphoria on the basis that, quote, "little is known about the long-term side effects of hormone or puberty blockers in children with gender dysphoria. The effects of bone density in children whose central precocious puberty is arrested with puberty blockers are considered unknown, as they have not been studied," end of quote. Why the hell not? Why are these things handed out like confetti and like candy when we don't know their long-term health impacts? That is not responsible. It's criminal. It's inhuman. A groundbreaking documentary from the state-run television channel in Sweden has revealed a shocking case of bone damage on one child, Leo. He's one of 13 children treated at the Karolinska University Hospital who are known to have suffered catastrophic injuries from puberty blockers. Their ailments include liver damage, mental health problems, skeletal damage, and a failure to grow. From that investigation, quote, Leo is in pain most of the time. His back hurts badly when he stands up or walks. It is a hard life for a teenager, and he has no idea if the agony will ever go away. End of quote. Leo has spinal fractures, the quote continues. Leo has spinal fractures and a condition called osteopenia, which weakens the bones, making them more liable to break. It is a disease that you often see in people aged 60 or 70 and is almost impossible to reverse. End of quote. The overwhelming evidence is that this atrophy, this damage to the reproductive organs of children, is permanent. We are administering this to children under 10 and it's sterilising them. It's this evidence that's seen 25 American states ban the pharmaceutical mutilation of children. Likewise, the transgender lobby will tell you a cross-gender identifying child has a greater risk of suicide without puberty blockers. A comprehensive literature review published in the Journal of the Endocrine Society found that there was no statistical signal that suicides increased or decreased from pharmaceutical gender intervention. So before the Munchausen by proxy brigade and before the lining their pockets brigade come after me, I suggest you take a long, hard look at yourselves. In estimates I asked the TGA, Senate estimates hearings, I asked the TGA if they had conducted safety testing and approved these drugs for use in children, and I was advised they had. I have a motion in the list for tomorrow calling for the release of that data, which is not on the TGA website. In good conscience, One Nation cannot support the continued harming of our children for a condition that can be treated successfully with counselling and love. One Nation will continue to defend the family and our children from the perversions of the Labor Party and bizarrely from Victorian librarians. Tonight, I ask if this Senate can have confidence in the integrity and competency of investigations at the Australian Securities and Investments Commission, ASIC. It was only a few months ago that the Senate Economics References Committee handed down a scandalous inquiry report which documents how ASIC has comprehensively failed the Australian people. Now further information has come to light which shows ASIC has once again failed to protect everyday Australians. This failure is ASIC's criminal investigation into a precious metal dealership called ABC Bullion that occurred between July 2022 to August 2023. Over the course of 13 months, ASIC spent approximately $300,000 to investigate serious allegations regarding ABC Bullion's storage services, including whether the physical gold and silver bullion of Australian investors was missing. ASIC closed their investigation on 10th of August 2023, stating it would take no further action. This is a decision I disagree with on the basis of information I have at hand. And it's troubling that current Prime Minister Anthony Albanese took the unprecedented step of holding a national press conference with the directors of ABC Bullion and its parent company, Pallian Group, and provided them an explicit personal endorsement. This press conference occurred while the ASIC investigation into possible fraud was underway. Pallian is Australia's third largest private company, and I'm sure that carries weight with ASIC and the Office of the Prime Minister. And this endorsement was despite the Australian Taxation Office's highly publicised pursuit of Pallian over the past decade. This Tax Office investigation cost millions of dollars and covered alleged involvement in an elaborate GST fraud scheme and illegal phoenixing activities. This saw the Tax Office succeed in a legal bid to appoint liquidators to the Phoenix Pallian Group while continuing to pursue the current Pallian entity. The Prime Minister endorsed a company that was under two separate government investigations from ASIC and the ATO, both of which were known or should rightly have been known to the Office of the Prime Minister. Why? Why would the Prime Minister endorse a company under two government investigations? Recently, independent investigators have found more troubling information about the millions in bullion ABC are charging mum and dad investors to hold in their secure facility in Marrickville. Firstly, ASIC did not physically inspect any ABC Bullion or Pallian Group facility for 9.5 months, providing ample opportunity for the Prime Minister's mates to physically alter the evidence. Second, on 31st of July 2022, a mere 3.5 weeks after the ASIC investigators tipped off the ABC Bullion that it was under investigation, ABC Bullion moved an undisclosed quantity of physical bullion from a tiny room in the Sydney CBD to an industrial building located in Marrickville. This building did not then and does not now have a valid occupation certificate, meaning that ABC Bullion and its sister company, Pallion Equipment, has been illegally occupying the building under New South Wales law for more than 2 years. In the past month, the Inner West Council has officially declared this occupation to be, in their word, unlawful. Third, this unlawful occupation was never disclosed to ABC Bullion's insurers despite being required under law. Such non-disclosure provides the insurer with the legal right to void any insurance contract, thus exposing investors to significant risks without their knowledge. Thus, in summary, ASIC investigated the Prime Minister's mates and gave them a clean bill of health, even though easily identifiable illegal activity was occurring under their nose.
Senator Roberts. Senator Shoebridge.
Oh, thanks, Acting Deputy President. Tomorrow, the 11th of September, marks 51 years since the CIA-backed military coup in Chile. This violent coup deposed the democratically elected government of President Salvador Allende and paved the way for 17 years of dictatorship under General Augusto Pinochet. What followed was 17 years of enforced disappearances and human rights abuses that inspired military takeovers across Latin America and turned Chile into a laboratory of state violence and unrestricted capitalism. 17 years where social security was at the mercy of investment profitability, ecosystems were plundered for profit, communities went without water to feed deregulated agribusiness, and those who challenged this were met with the heavy hand of the state. History has shown that the ultra-right-wing experiment in Chile turned the country into one of the most unequal in the world, with its cruel legacy remaining a source of trauma and heartache for millions of Chileans, including many who live in my home state of New South Wales. Peter Kornblue, a senior analyst at the National Security Archive in Washington, warns us that contemporary denialism about the atrocities of the Pinochet regime only strengthens the rise of the far right, calling the regime a Rosetta Stone for the discussion of the threat of authoritarianism versus the sanctity of democracy. And this, Madam Deputy President, was a Rosetta Stone that the Australian government had a role in carving. 3 years ago, the US government declassified previously secret documents that showed how the Australian Secret Intelligence Service opened a base in Santiago in 1971 to assist the CIA's destabilisation of the Chilean government ahead of the coup. This work included handling CIA-recruited Chilean assets in Santiago and filing intelligence reports to CIA headquarters. More recently, the Albanese government has come under sustained criticism from the Australian-Chilean community for its failure to progress the extradition of Adriana Rivas. Ms Rivas is charged in Chile with kidnapping and torture offences against 7 political dissidents during the dictatorship. She's lived in Sydney for the past 4 decades and was first arrested at Chile's request in 2019. The High Court cleared the way for extradition to Chile in 2022, but for reasons known only to the Albanese government, Ms Rivas still remains in Australia. Surely, as part recompense for Australia's past disgraceful role, it should expedite this request. So I want to take this moment to not only recognise the tortured, the silenced, the disappeared and the dead, but also those in the Chilean community here who are yet to experience justice for themselves and their families, and to recognise that democracy is fragile and it must be protected, sometimes from the very countries we otherwise consider our friends. Madam Deputy President, Madam Acting Deputy President, I want to acknowledge just some of the 377 Greens council candidates who are running in some 61 council elections across New South Wales this coming weekend. The first I'd like to note is indeed Councillor Kim Chappell. I know Kim because I work with Kim, and I have the privilege of working with Kim, an extraordinarily talented councillor on Randwick Council in her first term. Just some of her local achievements as a South Maroubra Nippers parent, working at the PNC local public school, working as a Maroubra United soccer mum. She's also stood with the community against tree removal at Maroubra Reservoir, delivered finally a connecting path to South Maroubra Surf Life Saving Club. She's protected Broadmeadow Reserve from intensive parking proposal, prioritised accessibility in the Maroubra Junction Master Plan, has a plan to have wheelchair and pram access to Malabar Headland from South Maroubra, has been bringing forward the renewal of the Maroubra Beach Playground. She's ensured the new water heaters that will be for the Des Renford Aquatic Centre will be powered by renewable energy, fought to retain the planned Maroubra Road cycleway to deliver key connectivity, and improved access to the rifle range for dog walkers. All of that while being a mum of 2 small kids, having a very, very busy day job and always accessible to her local residents, an extraordinary achievement in her first term. I'd also like to acknowledge 2 councillors from my local council up for re-election, Councillors Grieve and Robertson and Wallara Council. And I know Councillor Grieve because I was elected with her first to Wallara Council. They've delivered extraordinary achievements, an urban forest strategy to deliver some 30% more canopy cover and $15 million investment in new street trees over the next 20 years. Canopy controls across the municipality. Introduce ward meetings to enhance transparency and better communications between councillors and residents.
Your time has expired, Senator Shoebridge. I was told I had 10 minutes. No, 5. The clock's been ticking down from 5 since you stood up. You were 5 minutes. You were on the 5-minute list. There is a protocol. Well, he did not debate it with us, did not inform anybody else, and the protocol is that if you are on the 5-minute list and you are not here, you go to the bottom of the list, even if it's after the 10-minute people, and you get 5 minutes. Well, that is a written down and agreed protocol. Thank you, Senator Shoebridge. The Senate now stands adjourned and will meet again tomorrow at 9 a.m.